All right, Sean, may we have the full screen with all parties? There we go. Good morning, all. I'm Dwight Keene. I'm chair of the Kansas Corporation Commission. I'm joined this morning by fellow commissioners Susan Duffy and Commissioner Andrew French. We are now on the record and video streaming. Accordingly, I am calling this evidentiary hearing to order. The dockets before us this morning are docket numbers 21-CONS-3193-CPEN, 21-CONS-3201-CPEN, docket number 22-CONS-3031-CPEN, docket number 22-CONS-3034-CPEN, and docket number 22-CONS-3099-CMSC. These dockets are captioned in the matter of resolving various regulatory violations associated with Haas Petroleum, LLC, and in the matter of the application of Haas Petroleum, LLC for an operator's license renewal. All right. We will begin this morning with the entries of appearance, and I will start with the commission staff.
Good morning, commissioners. Kelsey Marsh on behalf of commission staff and the public generally.
Thank you very much. And for the operator?
Yes, the operator, Haas Petroleum, appears through its attorney, Keith Brock of Ottawa, Kansas, and also by its president and CEO, Rhonda Epps.
Thank you very much. Good to see you all this morning. Does the staff have any recommendation regarding the notice of this hearing?
Yes, notice of this hearing was contained in the presiding officer's August 18th order, setting an evidentiary hearing in these consolidated dockets for Thursday, October 6, 2022 at 8:30 a.m. via the Zoom video conferencing platform. The presiding officer's order was properly served on the parties. Further, staff notes that operators, president, and CEO, and its counsel are in attendance today. Based on these facts, staff recommends the commission find notice is proper and that the commission has the jurisdiction to hear this matter at this place and time.
Are there any objections to notice?
No
Hearing no
objection.
objections. Pardon me, didn't mean to talk over you. Hearing no objections and based upon staff's recommendation, I find the notice is proper and that the commission has jurisdiction over this proceeding at this time and place. Let's now consider some preliminary matters and first discuss procedures during the hearing. First, of course, we are conducting this over Zoom, and sometimes things can go wrong. If any party encounters a technical issue, please just ask to go off the record so that we may resolve the technical issues off the record. Second, witnesses are asked to keep their microphones off or muted when they are not scheduled to speak. And if everyone would please mute their cell phones in their offices and other electronic devices, that would be very much appreciated. Third, so that the parties are aware, if the commission needs to consult among themselves, we will go off the record and the commission will enter into a Zoom breakout room to confer. Thereafter, we will return from the breakout room and go back on the record. Fourth, since we are doing this by Zoom, please be especially careful to identify exactly what you're referring to when discussing pre-filed testimony, exhibits, or other filings. We have copies of all of those on hand, and so we should be able to follow along if you will aid us in identifying for us the documents to which you are making reference. I would turn to the parties now and ask if you have any further matters that you would wish to take up at this time.
The operator has one preliminary matter, Mr. Chairman.
Please.
When we initially pre-filed testimony in December of 2021, the president and CEO of Haas Petroleum at that time was Mark Haas. And so we pre-filed testimony on behalf of Mr. Haas. Since that time, Mr. Haas is no longer with the company at all. And we would prefer that that testimony be given by its current president and CEO on behalf of that limited liability company, Ms. Rhonda Epps. And so we would like for her to be able to present his testimony. in the interest of time, I think that she can also testify to the matters contained in the pre-filed testimony of Julie Barber, filed on December 10th, 2021 as well. But that offer is only for efficiency purposes as it relates to Ms. Barber. She's still an employee and she's here today to testify. I'm only trying to be cognizant that the commission has a lot of witnesses today and that some of Mrs. Epps' testimony is duplicative with Mrs. Barber's testimony. So that one's only a time saving. But Mr. Haas is not affiliated with Haas Petroleum and he's not here today either.
Very well. Thank you, Mr. Brock. Is there objection?
There is. Staff would object to Ms. Epps being allowed to testify on behalf of Mr. Haas and Ms. Barber. As such would be impermissible, and doing so calls for hearsay. The answers provided by Mr. Haas and Ms. Barber are in their own words and from their own point of view. Additionally, many of the details discussed in their testimony occurred prior to Mrs. Epps' involvement with Haas Petroleum or were outside of her job responsibilities at the time that these violations and testimony occurred. Additionally, Mr. Hobbs did not attend the pre-hearing conference on Monday, and I don't think Haas should be given the benefit of allowing a person who had an unexcused absence have their testimony incorporated into the formal record, and that staff would object. So therefore, staff would object to Ms. Epps being allowed to incorporate the testimony of others into her own.
For point of clarification, Mr. Marsh, what about the suggestion that Mr. Brock had for purposes of efficiency to incorporate the testimony also of Ms. Barber?
In that regard, staff has prepared questions for Ms. Barber, and staff would like the opportunity to ask those questions and get her point of view and her answers to those questions.
All right, thank you. Mr. Brock, as I understand it, Ms. Barber is available. Is that correct?
I didn't hear your question quite. Did you say is or isn't? I'm sorry.
It is available.
Mrs. Barber is available, yes.
All right. Mr. Brock, any response that you would have to Mr. Marsh's objection?
Yes. So Mrs. Epps, we can lay the foundation for her qualifications to testify regarding the matters contained in Mark Haas's testimony, and that she is now the president and the CEO. She's reviewed the company records. She's spoken with company employees. She has access to all data and information related to the company, both presently and before she became president and CEO of the company. As it relates to hearsay statements, generally statements by parties are not hearsay. These are corporate representatives, not individual parties. And so, generally an organization can testify about what happened within an organization and what employees within that organization, knew as a whole. We would like Mrs. Epps' testimony to be on behalf of Haas Petroleum LLC, not on behalf of an individual person.
All right, thank you. Mr. Marsh?
Well, I guess, as far as it goes to Ms. Haas testifying on part of the company, I mean, these were still individuals with the company, and, there's no reason why Mr. Haas couldn't be here today that has been provided by the operator. So I don't think operators should be allowed to avoid cross-examination and questions from the commission for a witness due to their lack of attendance.
All right, thank you. I'm going to rule on the motion at this time. With respect to the applicability of incorporating by reference, in effect, Mr. Haas' testimony and allowing Ms. Epps to address those issues, I'm going to overrule the objection. The commission certainly notes the objection that you have made, Mr. Marsh, and we can take appropriate notice of how we assign weight to the testimony that has any relationship back to Mr. Haas in that respect. With regard to the incorporation by reference, basically, of Mrs. Barber's testimony, I'm going to sustain that part of the objection. I think, given the fact that staff indicates that it has prepared or propounded questions directly for her, that we will go ahead and have her testify on her own behalf. As I understand, she is present. Is that correct, Mr. Brock?
It is, Mr. Chairman.
Mr. Brock, let me proffer this suggestion to you and see if it meets with your approval. Given the ruling I've just made on Mr. Marsh's motion, especially as it bears on Mrs. Epps and Mrs. Barber, it strikes me that maybe in the interest of efficiency, it might be better if, in lieu of what was maybe originally planned as the order of presentation of witnesses, that we maybe switch those where we have Mrs. Epps go first, and that may very well answer the efficiency question that you're concerned about with respect to Mrs. Barber. Would that change in the approach to the examination of witnesses be acceptable to you?
I would really like for Mrs. Epps to testify last. I don't have very many questions for Miss Barber, and I feel like the testimony Miss Epps will give really leads into the closing argument that we have planned. So, I mean, if the commission would allow it, I would still like to have Miss Epps testify first, and then, or I'm sorry, I said that backwards. Miss Barber testify first, and then Miss Epps testify second.
Very well, I'll honor your request. I was thinking maybe the bulk of the questions come first, but in any event, I would defer to your preference, and that's exactly what we will do. We'll follow the order of witnesses as originally scheduled, and we'll have Mrs. Barber precede the testimony of Mrs. Epps. All right, let's turn to procedures during the hearing. The parties will make opening statements. After opening statements, we'll have the examination of witnesses. After direct examination of each witness, there's an opportunity for cross-examination, followed by questions from the commission and redirect. Beyond this, any further examination will be at the discretion of the commission. Following witness examination, the parties will make closing statements and arrange for the filing of post-hearing briefs if necessary. And after that, we will conclude the hearing. All right, very well. Let's now turn to opening statements. We will begin first with Kelsey Marsh on behalf of the KCC staff.
Thank you, Chair King. May it please the commission. We are before you today after nearly 2 years since it was discovered that Haas Petroleum was concealing environmental violations. Since that discovery, commission staff has documented a mountain of various non-compliance issues after conducting a thorough inspection of Haas's leases. While there is a mountain load of information to sort through in these dockets, there are really 2 issues that need to be determined. First, should the penalty orders in dockets 21-CONS-3193-CPEN, 21-CONS-3201-CPEN, 22-CONS-3031-CPEN, and 22-CONS-3034-CPEN be affirmed. And second, whether Haas should have the privilege to continue to be licensed as an operator in the state of Kansas. Staff's position is that the facts in each of the penalty orders issued by the commission support an order affirming the penalty assessed, and that the facts and documentation regarding Haas's operation as a whole support a denial and revocation of Haas's license. Beginning with the penalty dockets, to put it simply, there is one similar order of facts in each of the penalty dockets that cannot be ignored or disproven. Staff found and documented wells that were out of compliance with the commission's rules and regulations. Staff sent an NOV letter to Haas regarding these violations. Haas did not comply with the notice of violation letters by the deadline in those letters, and Haas received a penalty for their noncompliance. In fact, 78 of the 109 wells found to have violations in these penalty dockets remain out of compliance with the commission's rules and regulations. Additionally, dockets 21-CONS-3201-CPEN and 22-CONS-3031-CPEN assessed heightened penalties as an actual and substantial economic deterrent for the egregious actions conducted by Haas. The reason for those heightened penalties are based on Haas's actions and the blatant concealment of environmental violations at over 30 injection wells. This was done by Haas's modification of the equipment at the wellheads in order to falsely obtain a satisfactory mechanical integrity test. The egregiousness and magnitude of these violations cannot be overstated, especially when considering the fact that District 3 has approximately 10,000 UIC wells and 58,000 known wells, and only 9 field staff to monitor those wells. That causes staff to heavily rely on operators to be honest and have integrity when self-reporting critical witnessing activities, such as mechanical integrity tests. The lack of honesty and integrity shown by Haas Petroleum leading up to these dockets necessitates the heightened penalties assessed by the commission. Lastly, it is staff's position that the application for license renewal should be denied and that Haas's license be revoked pursuant to KAR 82-3-120 subsection G and subsection J. Additionally, under KSA 55-155 subsection 3 and subsection 4, an applicant must demonstrate to the commission's satisfaction that the applicant complies with all requirements of Chapter 55 of the Kansas statutes annotated and amendments thereto, all rules and regulations adopted thereunder, and all commission orders and enforcement agreements. Based upon commission staff's inspection and investigation of Haas's leases, staff was able to document a mountain of at least 910 violations in association with 824 wells. Therefore, the license application submitted by Haas statutorily cannot be granted based on Haas's noncompliance with Chapter 55 of the Kansas statutes annotated, noncompliance with the commission's rules and regulations, and noncompliance with the commission's orders in these consolidated dockets. Further, the sheer number and variance of the violations documented by staff display Haas Petroleum's blatant disregard and negligence in acting as a reasonably prudent operator should. Therefore, staff believes the mountain of documentation gathered over the past 2 years clearly shows that Haas does not deserve to be a licensed operator of the state of Kansas. Thank you.
All right, thank you, Mr. Marsh. Mr. Brock, please, your opening statement.
Thank you, Mr. Chairman, and good morning. In 1985, Mark Haas was issued a license to operate in the state of Kansas by this commission. He operated under that license for 20 years until 2005, when Haas Petroleum was formed and acquired its operator's license. During that 20-year period of time, he had not received a single penalty order. And from 2005 until the events of 2020, Haas Petroleum operated, receiving only 4 very small penalty orders, 3 of which were only $100 penalties. So in essence, we have a 30-year history of operating in the state of Kansas, a good track record. In November of 2020, the events giving rise to these UIC violations that are at issue in this docket occurred, and of course, everything changed. Haas has never denied that this happened. Haas has never denied the severity of what happened. The present management and leadership at Haas is a big believer in accountability, and they acknowledge that they need to be held accountable for what has happened. And since that's happened, they've been trying to do everything they can to earn the right to be redeemed, to earn a right to show themselves, to prove themselves that they moved beyond that event. We've laid out a lot of steps that have been taken by Haas since those events occurred. And those are not to make excuses or to minimize what happened, but we want you to see the lengths that Haas has gone to try to make sure that nothing like that can ever happen again. So as it relates to the penalty dockets, our request is simple: issue a penalty. Haas, the commission, everyone acknowledges that a penalty is warranted. We're not claiming that it isn't. So issue the penalty. But importantly, allow Haas the opportunity to prove itself. Allow it the opportunity to seek redemption through its operator's license renewal. So on those issues, there's not a dispute. But where there is a dispute is that after these UIC violations occurred, staff has alleged a large number of additional violations. You heard Mr. Marsh say 900 additional violations. And they've also taken other actions that were done because they decided that Haas's license should be taken. And so they have alleged these violations in order to ensure that that's what happens. And that's why we're here today. is to address those issues, because it doesn't matter how we feel about an operator. Every operator has to be treated the same. Every operator has to be given the same opportunities. And so when we were hired with this, we immediately reached out to staff, because you do have an incredible staff, and they're always so willing to work with everyone, so open to communication. But in this case, we reached out to start communications, and we were directly told, no, we don't want to meet with you, multiple times. We tried to open discussions regarding compliance agreements, regarding trying to resolve these other issues. And we were told, no, we don't want to discuss those. We always have understood that the commission would need to impose the penalties for the UIC dockets. And that was always acknowledged, that we weren't seeking to settle that. We wanted that to come before the commission. We recognized that would have to come before the commission. But the other issues, we should have been able to resolve, but we weren't even able to discuss those. And so that's why we're here today. That's what we're here to talk to you about. You heard me say that they're treated differently. You're going to receive evidence today that the commission staff has tried to impute responsibility for 1,064 wells that are not the legal responsibility of Haas Petroleum. You're also going to receive evidence today that the commission staff has sent notices telling Haas that they have to shut down 116 injection wells simply because they're located within a quarter mile of some abandoned well. You're going to receive testimony that for a period of 2 years, the commission staff has either rejected or ignored transfers of wells, and then recommended to the commission that they issue penalties against Haas that are no longer operated by Haas. You're going to hear evidence that Haas Petroleum has been denied access to COLAR to file their documents to stay into compliance. And then, as I alluded to before, you're going to hear evidence that not only was there not a settlement reached, but there was no discussions even allowed, no meeting even allowed. And so that's what I'm meaning when I say that they're treated differently. No other operator is receiving these demands. No other operator is receiving this. And as badly as we wanted to settle this, as badly as we knew we needed to get this resolved, no operator can accept responsibility for 1,000 additional wells. And no operator can allow its injection permits to be held hostage in order to get it to accept responsibility for abandoned wells that are not legally theirs. And so we couldn't overcome those issues. And so that's why we're here at the commission to discuss those things. And so Haas isn't asking for any special treatment. They're asking to be held accountable for what they've done, but they're asking to be treated the same as every other operator on all the other issues, and to be allowed the same opportunities as every other operator as it relates to the other issues. And so that's what we're here to talk about today. Thank you.
Thank you, Mr. Brock. Okay. That concludes the opening statements. We're now going to turn to the examination of witnesses. We're going to begin with the examination of the KCC staff witnesses. So, Mr. Marsh, I would turn to you and ask that you call your first witness.
Thank you, Chair King. Staff would call Troy Russell to the stand.
All right. Good morning, Mr. Russell.
Good morning, Chair.
If you would, please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Thank you. All right, very well. Mr. Russell, let's begin with, in fact, Mr. Marsh, will begin with you in your direct examination, please.
Thank you, Chair. Mr. Russell, please state your full name for the record.
Troy Russell,
By whom and in what capacity are you employed?
Kansas Corporation Commission, as the District 3 Supervisor out of Chinook, Kansas.
And what is your work address?
137 West 21st Street, Chinook, Kansas, 66720.
Are you the same Troy Russell who caused to be filed in these consolidated dockets? Testimony consisting of 8 pages on November 8th, 2021. Testimony consisting of 7 pages on December 20th, 2021. Testimony consisting of 13 pages on January 7th, 2022, and testimony consisting of 9 pages on September 16th, 2022.
Yes.
Was this testimony created by you or at your direction?
Yes.
Now that you are under oath, do you have any corrections to make to your testimony?
No.
Do you swear the answers contained in your pre-filed testimonies at the time they were filed are true to the best of your knowledge?
Yes.
At this time, staff moves for the admission of Mr. Troy Russell's pre-filed testimony into the formal record.
Objections?
No objection. Let me make sure that I'm absolutely clear about what we're admitting here. Mr. Marsh, as I understand it, the pre-filed testimony I find from Mr. Russell comes in 3 parts. One was pre-filed testimony dated November 8th, 2021. Second pre-filed testimony was dated December 20th, 2021. And a third pre-filed testimony was dated January 7th, 2022. Are you asking for the admission of all 3 of these pre-filed testimonies?
All 3 of those testimonies and the testimony that Mr. Russell filed on September 16th, 2022.
Yes. Okay. Very well. Without objection, they're admitted.
Thank you. At this time, staff tenders the witness for cross-examination.
All right. Mr. Brock, please.
Thank you. Good morning, Mr. Russell.
Good morning, Mr. Brock.
How are you doing this morning?
Oh, good.
Good. We'll just get right into it. I know we've got a lot of witnesses, so we'll try to save everyone some time and go right into it. The first thing I'd like to talk to you about is in 22 CONS 3034 CPEN. These are the penalty dockets relating to the 77 temporary abandonment violations. I would like to ask you, I'm going to try to shortcut this a little bit. I'm sorry, I'm looking off the screen. I'm pulling up something to share the screen, so I apologize if it looks like I'm doing something else. I'm not. Do I need to ask permission to share the screen, or I don't know how you normally would?
No, you go right ahead. If you have problems, Keith, in enabling that, our folks can help you with that. Michelle or Sean can help with that.
Okay.
If you want to go ahead and make an effort to do a screen share and it works, then we're there.
Okay, thank you.
From my end, it seems to have worked. I'm
Are you
looking
seeing
at.
the testimony? I have
No.
2 screens. I just want to make sure I shared the right one.
Okay, the way I'm looking at is the Zoom screen. It says
Okay,
Zoom.
Okay, let me do it. I apologize. I chose the wrong screen. How about that time? Is this right? Pre-filed testimony of Julie Barber.
That's what I'm seeing. Basically, the table of contents of her testimony. That's
Okay.
what I'm seeing.
Thank you. Sorry about that. I've done it before, but not often enough that I can do it without error. Mr. Russell, have you reviewed the pre-filed testimony that Julie Barber submitted on December the this date is it's December the 10th, 2021. Have you reviewed that?
Yes, sir.
Okay, so I'm going to go to page 9. And we'll start with so Mrs. Barber lays out basically the facts that were that she contends surrounded the issuance of these 77 TA violations. And if you'll see, I'm just going to try to summarize it for you, but she basically says that when these notice of violations were issued, she contacted her attorney, and her attorney sent a communication to the KCC asking about these penalties be held while the parties tried to reach some kind of an agreement. And you can see the language from these communications. Do you agree that that's what occurred?
The
Russell, did you-
conversation beginning on 180, line 184. Are you implying that that conversation was with me?
No, I'm just asking you if you agree with the facts that she's laying out that gave rise to these violations.
Mr. Russell, did you understand the question?
Yeah, I'm sorry. I'm trying to look through my rebuttal to see if I specifically addressed that. It's been some time since.
Sure, I appreciate it.
Oh, would you repeat the quick question one more time, Mr. Brock, and then I'll get you an answer right quick.
Absolutely. I apologize. So I'm just asking if you agree with Ms. Barber's summary of what occurred before these 77 temporary abandonment violations were or penalties were issued.
Okay. Yes, sir.
Thank you. And so after these communications occurred, and I won't pull up your testimony, but in your rebuttal, you indicated that you had told Julie Barber at some time after a July 27th, 2021 notice of violation was issued that staff would not be working with them to resolve these TA violations. Is that correct?
No, what Chuck was told was explained that they did not respond within that timeline. And then at that time, we had dockets pending that we would resolve before we would pursue these. Meaning that letters were sent as part of an abandoned well or an inactive well on active licenses. You know, they were sent to numerous operators. And that this was part of that, and it was not part of any other of the UIC stuff that we were discussing, and that they had not responded within the deadline frames of those letters. And so at that time, penalty recommendations were made And any agreements at that point then would become settlement agreements, not compliance agreements.
And just to clarify, that conversation occurred sometime after a July 27th, 2021 notice of violation was issued. Is that correct?
Do we have the exhibits with the email showing those communications?
Yeah, I'll scroll down to it. Which email are you wanting me to display? I can do it for you.
Was that?
I'm sorry, I moved it. This is not one that was shown before. But these emails aren't what I'm asking about. In your rebuttal testimony, you claim to have communications with Julie Barber at some point after July 27th, 2021 notice of violations were issued. And I'm just asking if that's still your.
Can you direct me to that in my testimony?
Absolutely.
Okay.
I'm going to stop the screen share while I find that. Is that okay?
I have a copy in front of me too, if you know the page and.
Would have. I apologize. I wrote down other references to your testimony, but I didn't get this one written down for some reason. Sorry, I think I may have printed two copies of the same testimony. Give me 1 second and I'll find it. I apologize for the delay. I should have had this. Like I say, I marked all the others and Okay, Mr. Russell, I really apologize for that delay. I should have had this before I asked you this question. So I have up on the screen, this is your pre-filed testimony filed November 8th of 2021, and we're on page 5 at line 19. And in here, you're talking about the first contact regarding these 77 TA violations being from Miss Barber on July 27th, 2021. Is that correct?
Yes, in reference to the 3 NOVs that were sent in May that were in association with inactive wells on active licenses in May.
And at that time, you told Miss Barber that there wouldn't be a compliance agreement and that they needed to comply with these NOVs. Is that correct?
At that time, Miss Barber told me that Mr. Brock, the counsel, had told them that they were going to be resolved in a compliance agreement. And I informed Miss Barber that I had not been made aware of a compliance agreement. And at this time, the agreement would be need to be made through KCC legal staff as the deadlines had passed.
And so that occurred on July 27, 2021, correct?
Or thereafter.
Or
It
thereafter.
was after that date.
Okay. And the penalties in this docket for these 77 temporary abandonment violations, that penalty order was issued on August 3rd, 2021, correct? 6 days later.
I do not know the exact date. I don't recollect the absolute date, but I'm sure you have it.
Okay, thank you. So let's move on a little bit. In your pre-filed rebuttal testimony filed on January 7, 2022, we're just going to talk a little bit generally before, so you don't actually have to get it in front of you yet, but we're going to talk generally about it. But in that testimony, you talk about compliance agreements and the purpose of them and what they're for. Can you just generally tell me what the purpose of a compliance agreement is, what they're typically used for, that sort of thing?
Yeah, a compliance agreement, as current commission order template, is an agreement initiated by the district with an operator when both parties have identified violations that can be resolved without incurring environmental impact or done in a timeline that will allow them to accomplish those. On those agreements in general, the wells are investigated. Some of the things that we don't consider is that a UIC well in failed status is not considered on a compliance agreement. We would go through all the operators' leases or well inventory with them to try to find out what all potential violations they may have that would maybe be possible for discussion to include in such an agreement. The timeframes then are developed as far as the length of time and the number of objectives to be completed each quarter, and the prioritization of those are identified. That would be a general overview.
And why does district staff enter into compliance agreements as opposed to just forcing the operator to comply with everything they're required to right at that moment?
If all the criteria have been met as far as environmental concern, then it is a position that is to utilize that operator's resources, our resources, and can bring those back into compliance in a short amount of time. And they have demonstrated the integrity to work and communicate with us closely, and that we have developed a time frame, though maybe longer than a regulatory one, it is still fairly short and not just perpetually extended.
And in your pre-filed testimony, you alluded to the fact that the compliance agreement allows the operator to maintain compliance on their other leases. Is that correct?
Yeah, it can be utilized. They can still put those resources and remain economically viable to maintain their operations and keep those into compliance.
And so another reason then, as you just said, is so that the operator can maintain viability, can actually perform its regulatory obligations. Is that what you're saying?
If the agreement has met all the other criteria as far as environmental concerns, and they've demonstrated the integrity to communicate openly with district and district staff about the potential violations that we need to resolve.
Okay. And just generally speaking, our compliance agreement a frequently used tool by district staff?
Yes.
And especially for TA violations, isn't it incredibly common that operators are allowed compliance agreements for TA violations?
When we talk to an operator about a compliance agreement for TA violations, they have responded and communicated to us within the deadlines given, not after. After, if we, like an inactive well on active licenses, we send that notice letter that, they need to resolve these within 30 days. If they reach out to us before that deadline and want to start discussions, then those discussions can begin, and we will not recommend penalties until those discussions have been held. If the deadline is passed, the penalty recommendations will be made, and then it kind of moves into then where they would, their options are to see if legal staff would support a settlement agreement.
And so are you saying you would agree that they're a common tool for TA violations?
Yes.
Okay. And I know earlier the timeline was a little bit mixed, but when we were referring to Mrs. Barber's testimony, you stated that you agreed that, with the facts that she recited, and essentially she recited that 2 days after the NOV was issued, we reached out to staff to try to resolve those issues. And it wasn't until July the 27th of 2021 that you spoke with Ms. Barber and told her that there would not be any agreement. And then penalties were issued on August the 3rd, 6 days later. Is that all?
The deadlines for those NOVs sent in May were 30 days. So in July, we're 60 days out. We had already waited an additional 60 days for response. So then the penalties were sent out, and that the NOV dated July 27th, if we can pull that up.
So on May 26, 2021 is the violation.
There were NOV letters sent on the 6th, the 11th, and the 26th.
And then we reached out on May the 28th, 2021.
To who?
To the individuals in these emails. I think we've covered that. I can move on. We don't have to rehash that. So let's talk about compliance agreements a little bit. I've just gone through some very recent commission actions to look at some of those. And so let's look this past Tuesday on October the 4th, 2022, the commission approved an amendment and modification to a compliance agreement for Running Fox's Petroleum. It's 21 CONS 3017. And so we'll just scroll down to this. In essence, these are TA violations. There were originally 27 wells. There had been wells added to it and extended. The requirements under that compliance agreement were for them to repair or obtain TA
Objection. Is there
status.
a question anytime soon, or
I'll ask him. What does this compliance agreement say?
objection outside the scope of Mr. Russell's testimony?
Chair Keen, you're on mute.
Oh, yeah.
My apologies. I'm going to overrule Mr. Marsh's objection. Mr. Brock, please restate your question.
Would you agree that this compliance agreement pertains to TA violations? When I say TA violations, I'm meaning temporary abandonment violations.
Yes,
And would you agree that under this agreement, that operator is required to return 3 wells every 3 months to service or obtain TA status?
or plug them.
Or plug them, but it's 3
Yes.
wells every 3 months, correct?
3 wells per quarter, per calendar quarter.
Okay. I have several of these, but I'm just going to ask you, I can pull them all up. But we also have, so there's 23 CONS 3006 CMSC Atlas Operating LLC. They recently had a compliance agreement for TA violations, 117 TA violations. Do you want me to pull that one up, or are you familiar with that one?
I'm not familiar. Is that in District 3?
Here, let me pull it up and we'll see. So this compliance agreement, would you agree that it's for TA violations as well?
Can you scroll down and see where, I'm not, what district this came out of?
I don't know where it shows me that for sure. You tell me when to stop. I'm sorry, I don't know
Towards the
where.
bottom. No, that's out of District 2. That'd be Jeff Clock.
Okay. Would you agree that this compliance agreement pertains to TA violations as well?
I've not read this one, and to me, it looks like the template, and that's about all I can say.
823111, is that the temporary abandonment?
It's a TA reg, yes, sir.
And this agreement says this operator basically has to return 6 wells to service or plug them or TA them within every 3 calendar months, correct?
Yes.
I'm going to try to shortcut this just because we have a lot of time. If there's objections, I can go back and pull them up, but we also have 23 CONS 3471 Techstar Inc. They had 93 TA violations, required to return 4 wells every 3 months. We also have 22 CONS 3478 CMSC American Star Energy Services. They also had TA violations, required to return 3 wells every 3 months. 23 CONS 3010 CMSC John Brickley DBA B8 Investments. They had TA violations, 2 wells every 3 months. And then 23 CONS 3011 CMSC Brickley Enterprises, they're required to return 3 wells every 3 months. I know that's a lot, and I'm just, do you have a reason to dispute all of that, any of that?
I would have a question. You know, the construction of those wells would be important, and the reason why the operator was seeking this agreement were the wells, you know, old style completions and likely to be environmental concern or not? Did we have records of the high fluid level? I mean, there's a lot of information per well that goes into that research and into the prioritization, and to look at that agreement, you would need to look at all that in a whole and in summary to discern the specifics of each agreement.
And isn't it true that staff was not even willing to meet with operator to determine whether their wells would qualify for one of these agreements with Haas Petroleum?
No. There were conversations that they would need to go ahead and file TAs. If those TAs were denied, and then within that denial timeframe, within the 30 days, then if an operator contacts us, then we would discuss a well going on the compliance agreement. You cannot put a well on the compliance agreement that is not already out of compliance.
Before I forget, I would ask that the commission take administrative notice of these documents that I referenced and the filings in them, since they're not actually presented as evidence here.
Is there objection?
No objection.
Without objection, they're admitted.
And so my point in all that is that you had said earlier that compliance agreements were incredibly common, correct?
I said that they were a common tool used in District 3. We do use them.
Okay. And based on all of these based on these dockets we just talked about, operators have been required to return between 2 and 6 wells into compliance every 3 months. Would you agree with that?
On those agreements we looked at,
Okay. And then would you also agree that Haas's request to meet in order to discuss such an agreement was just unilaterally denied?
no, I think at the point, if it was denied, was because they had already missed the deadlines contained in the original NOVs. Before we want to enter into discussions with an operator, if they've been sent an NOV, we want that discussions to begin prior to the deadline and the associated NOV.
Okay. And so Haas was required to return all 77 wells into compliance with the TA regulations within the original deadline of the NOV. Would you agree with that?
Are we talking about the 3 NOVs sent in May?
I'm talking about the NOVs related to these temporary abandonment regulations.
Right, they would have been given 30 days
Okay.
in those NOVs.
As opposed to between 2 and 6 wells per 3 calendar months, correct?
The objectives are based upon numbers, environmental concerns, and the sheer number of wells that we were talking about. And then the overall time frame of the agreement would not automatically been 2 to 6, depending until we know 77 wells would have been, a very short time frame to file those TAs.
And you had said earlier, one goal of the compliance agreement is to allow an operator to continue to remain viable. Remember that?
Yes, to give them an opportunity to remain viable.
So I guess the converse would probably be true, that if an operator isn't given a compliance agreement, it may be difficult for them to remain viable.
It would depend on how deep a hole they have dug.
Okay. Let's move on from that. I'm sorry to go through all of that stuff, but I think the rest of it will go much smoother. So let's talk about page 6, line 18 of your January 7th, 2022 testimony. And just
Which one was that again? I'm sorry.
It's page 8. Oh, I'm sorry. Are you asking which set of testimony or which page?
Yeah, what is it? Pre-file rebuttal?
Yeah, this is the rebuttal filed on January 7th, 2022.
Okay. Page,
Page 8, line 18.
okay, I'm with you.
And so in this line of questioning, you're responding to the three options that Haas had laid out as being possible penalty options for the commission to impose. And your first objection to these options are, I'm just going to read it for you. All three options ask for staff to negotiate in good faith with operator. I sincerely believe that there is no feasible settlement with this operator. Is that so that lays the groundwork. Now I'll ask my question. Isn't it true that you refused to meet with the operator, refused to meet with staff, I'm sorry, with Haas Petroleum to even discuss if there was a viable settlement?
I don't believe that we denied any request to hear or visit with them. And at this point, you say, yeah, in good faith with operator, those actions taken to falsify the equipment on those UIC wells, and then what appears to be false filing of U7s for satisfactory unwitnessed tests, just destroys all credibility.
And that kind of goes to the whole point of the line of questioning. The initial violations occurred, and then all of these other events were brought about by staff's actions in response to them. Would you agree with that?
No, can you rephrase, please?
Yeah, that was just a poor question. I'm just going to withdraw it. I apologize. I should know better than to go off script. I'll always mess it up. I do bad enough on my own script. So my question was just, you made this determination that there was no feasible settlement without even trying to discuss settlement options with them, correct?
And we're talking specifically about the 407 violations, correct?
No, I'm talking specifically about the TA violations and the other issues. It's always been acknowledged that the 407 violations required a penalty. The commission should issue a penalty for those. I'm only talking about the other violations.
The answer you're referring to in my rebuttal is in response to the question to the 407 penalties. As far as other on the 82-3-111, the initial 77, the reason we would take that position with any operator if they had not approached us or tried to do something within the timeline of that 30 days on the TA. They could file those TAs even if they were denied and then initiate discussions. They did not contact us. They did not file any TAs or did not file all of them.
If we move a little bit further down, your testimony says that their actions and responses only occur when we cite them for violations. They are not proactive, wish to be rewarded for doing what they should be doing. Isn't a compliance agreement by its nature a proactive approach?
Well, within that time frame, there was plenty of time to begin addressing these on their own, even if no agreement was in force or enacted or in discussion. There was nothing limiting them from trying to start resolving these many issues.
And you had said several times throughout your testimony that there was no animosity toward Haas Petroleum. Is that true?
Yes, sir, that's true. No animosity towards Haas as an operator.
And so the very next sentence says, there are many operators in District 3, and they all have encountered the same economic hardships associated with this industry, but few, if any, have failed as miserably as this operator in navigating them.
What page are you on?
It's page, it starts on page 8 and goes to page 9.
And your question is, if I made that statement, what's your question?
You don't feel that shows some animosity?
No, I was stunned that they would allow things to got to that point without reaching out sooner. Compliance agreements have been out for a while. We talk about it at the associations. The field staff talk to operators about it when, they see something, maybe things are going the wrong direction. So that failed miserably is because they never came to us before this to let it get to this extent.
And then after that, it says that you believe that a development of an agreement would be a long and contentious affair if it could be implemented, and you believe the commission would constantly be debating merits and never-ending extensions, et cetera. Just to clarify, you made that determination without ever meeting with Haas to discuss the possible terms of the compliance agreement, correct?
Can you repeat that question?
The two sentences on page 9, lines
3 and 4.
lines 2 through 7, I believe. There's two sentences here. Starts with additionally. I've highlighted them on my screen. I'm just wanting to clarify that those determinations contained in those sentences were made without ever having met with Haas Petroleum to discuss the possible terms of any settlement agreement, correct?
When you say met with Haas Petroleum, do you mean discussed with Mark or discussed with you or discussed with Rhonda or discussed with Julie, or what are we talking about?
I mean, I've requested.
I've never been contacted by Mark. Contacts from, Rhonda and Julie have basically been informational or help with forms or these things. At that time, the agreement, so as far as shutting down, I have not heard anything. I have not heard or was aware of anything viable at this point in time, which it would have been a settlement agreement. So,
okay. Let's move on from that, and I'd like to talk about your rebuttal testimony filed September of 2022. So on page 4, lines 1 through 4, it says district staff pride themselves in applying commission rules and regulations fairly. Basically, district staff has never blacklisted an operator. We not view operator as an enemy or an adversary. District staff pride themselves on applying commission rules and regulations fairly and consistently to every operator. Do you still believe that's true?
yes.
I have sent an email for a cross-examination exhibit. Whoops. It's not the right one. For a cross-examination exhibit that we'd like to use. I think that's how we decided to do that, but I just wanted to make sure. I'm displaying it here as well. Do I need to do something else by virtue of the Zoom?
I'm not sure what you're asking.
We had a pre-hearing conference about how to present cross-examination exhibits, and I think I was only required to email them to John and Kelsey, and I've done that, and I'm just wanting to make sure that I just want to make sure that's what I'm required to do, and I don't need to send them somewhere else or do something else with this exhibit besides display it.
As I understand what you're saying, I think that's correct. You can proffer certain exhibits that you wish to have considered, and then we can determine whether or not the staff has objection.
Okay, thank you. I just was wanting to make sure I navigated Zoom appropriately with this. Mr. Russell, can you identify what this letter is?
Can you scroll down and see who sent it?
Yeah. It's sent by Todd Bryant, and you are CC'd on the letter.
Okay. And your question to me is
Can
what?
can you identify what that letter is?
It appears to be notification to the operator that there are inactive abandoned wells with an area of reviews of several of their existing injection or saltwater disposal wells.
So this is sent September 28th of 2022, correct?
That's the date.
And you've seen this letter and you're familiar with it?
I've seen it, yes.
I would move for the admission of cross-examination. I've labeled it TR cross 1.
Is there objection?
No objection.
Without objection, it's admitted.
And so let's look through this letter. You had said that it basically is the directions are shut in and cease injection operations at each injection well on the attached list within 30 days of the letter. And you said that was because these injection wells are located within a quarter of a mile of an abandoned well. Is that correct?
That's what the letter says. The letter was generated from the UIC department in Wichita, not from district.
Okay. Let's just look at this letter real quick. So if we scroll down, looking at these wells that Haas Petroleum is supposed to shut down, we go through all of these. Would you agree that there are 116 injection wells that they're being told they have to shut down?
I did not count them. Did they give a total in the letter?
There's not a total. I counted them.
You count? Okay.
Do you have a
Looks
reason
like-
to dispute it? I won't make you go through and count them all.
No, there are a large number of wells on that list.
And you had said you didn't send this letter, but I'm going to flip back to your pre-filed testimony filed September 16th of 2022, page 5, lines 23. Are you at the right place, Mr.
Yes, sir.
Russell?
Yes, sir.
Okay, so we're going to start with the sentence that says, here, the discovery and existence of abandoned wells within a quarter of a mile area of review would result in operator not being granted a permit and/or the permitted wells within the AOR being shut in until the abandoned wells were addressed. In order for operator to continue using its injection wells, these wells will need to be plugged, or operator will have to add them to its well inventory. Would you agree that this letter that we've labeled as TR Cross 1 is essentially carrying out what you've written in your pre-filed testimony on page 5, line 23 through page 6, line 3?
No, what the letter may have been after that, but that is just the common practice and understanding with UIC is that when we have an inactive well within an AOR, that well will need to be addressed before a new permit can be issued or before they can continue use of wells within that once it has been discovered.
And so the sole basis for telling Haas to shut in these 116 wells is because those wells are located within a quarter of a mile of an abandoned well. Is that correct?
And they pose an environmental threat.
Did you do any investigation to determine whether they pose an environmental threat?
I believe the reg just says if they have potential, and an unplugged well with unknown casing integrity is assumed to be an environmental threat until we know otherwise.
So you're saying you didn't do any investigation to determine if it was actually an environmental threat?
No, we cannot say that it is not an environmental threat.
Would you agree that the state of Kansas right now has approximately 5,500 abandoned wells? Do you agree with that?
Approximately, yes.
Have you sent letters similar to TR Cross number 1 to all other operators who have injection wells within a quarter mile of any of these 5,500 abandoned wells?
You would have to ask the UIC department that. I do not send those letters. They do not come out of District 3.
Have you been CC'd on any of them like you were on this one?
I think the ones that I've been CC'd on were more to do with, we have had letters to that effect on some. Predominantly is in the investigation of new permits.
But as it relates to existing injection wells that are already permitted, Haas is the only one who has received the letter like this, correct?
I don't believe that's true at all. I believe there are other letters that are notifications that probably have been made. A lot of times when staff finds something like that, if field staff finds it, they will bring it up to the operator and it'll get addressed before it ever gets anywhere near this point.
But you haven't sent letters like this to all other operators who have wells close to these 5,000 abandoned wells, correct?
I have never sent a letter like this that was not generated from District 3.
Okay. But you are attempting to impose this requirement on Haas Petroleum, correct?
When you say, am I personally, or is the commission?
That's a poor, I should have specified. You're exactly right. So commission staff is trying to impose this requirement on Haas Petroleum, correct?
And can you repeat what the requirement is you're saying? Are you saying what's in the letter or?
Correct. What's in the letter? To shut down all injection wells located within a specified distance from an abandoned well.
Until the inactive wells are addressed? Right, the abandoned well, that.
Or according to your testimony, until the abandoned wells added to their well inventory, correct?
On my testimony is not referring directly to that letter. That is saying that that is one option. If these abandoned wells, which, you know, there have been no penalty recommendations made, you know, at that point in the investigation, we were just asked to characterize. But if we had a well that we thought they were, we would talk with them. If we thought we had indications that would tie that well back to them, it should be on their inventory, such as taking the well on a lease assignment previously or something of that nature. Then one way they can get that done is if they put that well on their inventory, if they TA it, if it's TAable and gets an acceptable TA, that would resolve the issue with the AOR. So that's just telling them one of the ways that they could address it.
So let's talk about this general investigation, the broad investigation that the district staff conducted on all of Haas Petroleum's leases now. So if we go to just as a broad sense in the pre-filed testimony, would you agree that Haas is claiming that it is legally responsible for 1,168 wells, and the commission staff's investigation covered 2,232 wells?
The numbers I have in my pre-file are a little different. I mean, we have 1,482 that we got from Kohler that is from their well inventory. The 2,000 plus records you're associated with them on RBDMS, it needs to be pointed out that includes plugged and abandoned, expired intents, or what they claimed were expired intents that later were verified to be wells. So there would be a higher number on that than what would be on the certified well inventory.
Okay. And I guess the big picture I'm trying to point out is that there is a difference between the number of wells that Haas Petroleum claims and the number of wells that district staff is claiming, correct?
Yes.
Okay. And would you agree that that difference is 1,064 wells?
Again, I mean, you said 1,064. It's a large number of wells.
Okay, that's good enough for these purposes. I don't want to make you search for it. So let's talk about the wells that that district staff is including in its investigation and coming up with these 2,232 wells. So we talk about the first category, and we've already touched on it a little bit. But would you concede that in this investigation, staff included all abandoned wells located within a quarter mile of any of Haas Petroleum's injection wells?
Staff's investigation was limited to the physical boundaries of Haas's leases.
So you're saying that district staff did not include wells located within a quarter mile area of review of Haas's injection wells?
Yes, they would have if they were within the physical boundaries of what staff understood those physical leases to be, or if they were just readily apparent, you know, that you seen them. But we pulled the wells off the operator's well inventory and went to those leases. And we were limiting our investigation to those leases.
I'll ask that question of another witness then. Would you agree then, page 6, lines 7 through 10 of that same testimony filed September 2022, throughout the course of their investigation, staff documented all wells that fell within the lease boundaries. Do you agree that, and I think you just said it, that staff included all wells located within the lease boundaries of Haas Petroleum's leases? Is that correct?
That they could find. Like I said, we took those wells on license, try to find them, and then any other wells within those boundaries were documented if we discovered them.
And would you agree that under the amended statute, KSA 55-179, it specifically says an operator is not responsible for wells simply because they're located within their lease boundaries?
You're asking me, would you repeat that again? I'm sorry.
You're aware that KSA 55-179 was amended in July of 2021 by virtue of the efforts of the commission, correct?
I would assume so.
And are you aware that that statute has a provision that expressly indicates that an operator is not legally responsible for wells simply because they're located within the operator's lease boundaries?
Objection calls for a legal conclusion.
Overruled. Witness may answer.
And Mr. Brock, I'm sorry, would you please repeat the question?
I will, and I'll help this out a little bit more. I'll just read the language to you. KSA 55.
Can they pull that up? Can they pull that up with all the subsections and not just a single subsection?
You want me to? I didn't.
Oh, that's all right. Go ahead. Read it. That's fine.
Excuse me, gentlemen. John, is that possible to do?
Pardon me, what are you seeking to?
I think the question is, can you bring up for a screen share KSA 55-179?
You give me about 2 minutes, I could get it.
Yeah, I can do it as well. Hold on. Okay, I found it. My delay was the places I typically look. I know the statute's been changed and it hasn't been changed on those locations, but hold on, I have it. I'll share it momentarily here. Okay, that should do it. And if you want me to scroll it, Keith or whoever, just let me know.
No, I think they wanted to scroll it down. I'm not trying to become a part of the evidence here. I think they want you to scroll down to where the exceptions are.
Yeah,
I think that's what Mr. Russell was asking about.
it's B3.
Okay, it looks like I have 179B pulled up right here.
And Keith, again, you're specific to which section?
B3, specifically the second sentence, it says accepting an assignment of a lease, obtaining a new lease, or signing any other document between private parties shall not in and of itself create responsibility for a well located on the land covered thereby.
Is that, I mean, do we disregard B1? I mean, when we look at these regs and ask them, we consult legal staff. They give us the direction, tell us the parameters of which direction to go when we come up with one of these instances. So, if there was no communication or possible communication with injection or disposal, I mean, and no other criteria involved, then I'm guessing that's why that's in there in B3, but that has not been determined at this time.
But your investigation included all wells located within lease boundaries, correct?
That was our intent and our effort.
Okay. Even if they weren't on Haas Petroleum's well inventory, correct?
Right. Correct.
I'd like to share my screen again to go back to the testimony if we could. So the next sentence says that staff included wells that were not, I'm sorry, I didn't cite to where it is. It is page 6.
I'm with you.
Lines 10 through 11 of the pre-filed testimony filed on September 16th of 2022. So it also says that staff included wells that were not on operator's license, but were located within lease boundaries or associated with previous companies in which Mark Haas was the primary principal. So would you agree that staff also included wells that were operated by other legal entities in its investigation?
Right. We would have included all inactive wells we found. And when we say listed under Haas, generally what we do is we list that under what they call a working operator, which means we don't have definitive answer at this time in our investigation who the PRP will be.
I don't know what a PRP is. I'm sorry.
Responsible party.
Okay. Apologize. And then let's scroll down to page 7 of the same testimony, lines 4 through 13. This is basically talking about a large number of wells that Haas Petroleum had transferred to other licensed operators and submitted T1s for them. At lines 12 through 13 of your testimony, you say staff is waiting to process the T1s until the commission rules on the compliance issues in these dockets. So would you agree that staff hasn't approved any T1s submitted by Haas Petroleum since these events began?
There were a few initially that I believe were processed. T1s are processed by legal staff in Wichita. Early on, I believe there were some, but the recent ones that have not been.
Would you agree that that amounts to several hundred wells?
Yes.
And so were those wells then included within your investigation too? I shouldn't say your, I apologize. I got too relaxed within staff's investigation as well.
Well, speaking in general, a large number would have been included because the investigations were done on some of these prior to a T1 being transferred or being filed. So yes,
So yes, it did include wells that had been transferred to other operators too, as well.
it would be more accurate to say that, well, the transfers were filed after the investigation or after field staff's initial field inspections on a large number of those.
So moving away from the numbers, I guess we've talked initially that there is a discrepancy between the number of wells that Haas Petroleum claims and the number of wells that district staff claims. And then we've gone through 4 categories of wells that district staff claims that Haas Petroleum does not. Those are wells located within a quarter mile of an injection well, abandoned wells. Those are abandoned wells located on Haas's lease boundaries. Those are wells associated with other legal entities that Mark Haas is affiliated with. And then those are wells that have been transferred to other licensed operators. Would you agree that those 4 categories of wells were included by staff, but not by Haas Petroleum and their well counts?
Again, I understand the first part of those, but would you please repeat the part pertaining to transfers?
Yeah, let's talk a little bit about the transfers. So on the T1s, isn't it true that when an operator transfers a well, the new operator cannot pull any permits, even to plug a well, until the KCC approves that transfer? The COLAR system won't allow them.
I believe that is true.
Okay. And isn't it also true that that they can't pull permits to work over a well, to change construction of well, or otherwise bring the well into compliance if that requires a permit, until staff approves the T1?
That's true, but generally we do not transfer wells that are not in compliance prior
so
to transfer.
And isn't it also true that operators cannot even file normal reoccurring mechanical integrity tests for wells that they have assumed until staff approves their T1 transfers?
I believe that is true.
Okay. Isn't it also true that as a general rule, operators are reluctant to begin doing work on wells and investing money into them until the KCC has approved this T1 transfer?
I have seen instances of that both ways.
So would you agree that in this case, by not approving these T1 transfers, it effectively prevented the new operators from plugging wells and otherwise bringing them into compliance with KCC regulations?
Yes,
Would you also agree that by not approving these T1 transfers, it prevented new operators from conducting regular routine mechanical integrity tests on all wells that were transferred to them?
can you repeat that?
Would you also agree that in this case, by not approving the T1 transfers, it prevented all new operators that Haas Petroleum had assigned wells to from even being able to conduct routine mechanical integrity tests on the wells that were transferred?
I would see where I don't think a new operator would want to do that.
You don't think they would want to conduct their regular MIT tests?
No, not until the transfer is through. So I guess is yes to your answer.
Okay. So would you agree that at this point in time, there is more regulatory violations remaining than there otherwise would have been if staff had approved the T1 transfers and allowed new operators to plug wells, repair wells, conduct mechanical integrity tests on wells, and otherwise bring them into compliance with the KCC regulations?
No, we're assuming, one, that the new operators would have addressed these issues and that they were aware of, how serious or what repairs, plugins, or issues would have taken, prior to. So there's a lot of variables in that. I don't think that's as cut and dry.
But you'd agree that over that 2-year period of time where transfers were not approved, the new operators were not allowed the opportunity to do those things to bring wells into compliance with KCC regulations, correct?
I am aware of instances where things were done because we were told they were operating under Haas's license.
The question is that you would agree that the new operators who wanted to pull permits to plug wells, to rework wells, conduct mechanical integrity tests under their license were not allowed the opportunity to do that during this 2-year process where transfers were not approved.
Correct. Yes.
Thank you very much. You've been really patient with me, and you've been very forthright and honest. I really appreciate it. I don't have any more cross-examination questions for you. Thank you, Mr. Russell.
Thank you.
Thank you, Mr. Brock. Before our next step would be to have commissioner questions. Before we do that, we've been going now for, by my reckoning, about an hour and a half. Let's take a 5-minute break. So we'll stand in recess for 5 minutes. The time I have is 10:06. Let's resume again at 10:15. We're off the record until 10:15.
Parties, John Myers here. Please keep in mind that we are still live streaming, so keep yourself on mute and don't show anything on the screen that you're inclined to show, not to show.
Thank you, John. John, could we go back to full screen now?
I believe so, yes. And there you have it.
All right, very well. It's now 10:15. We will go back on the record and resume the examination of Troy Russell. Mr. Russell, I would remind you that you remain under oath. We'll turn next to commissioner questions, and I'll turn first to Commissioner Duffy.
Thank you, Chair King. Good morning, Troy. How are you?
Good morning, Commissioner Duffy. I'm okay.
Great. I have a number of questions, but I also need a couple of explanations. Okay, first of all, can you tell me approximately how much does it cost to perform an MIT?
There are a lot of variables depending on whether we're talking about a packer and tubing, which most of these would be related in this case. You know, the last numbers I heard, service companies, you know, it may be approaching the $500 mark, depending on, you know, how much work would be involved in prepping that well. I mean,
Okay, but approximately $500. And there's a requirement every 5 years that the operator perform an MIT and report findings to the commission, or else it is witnessed if there is staff available. Is that correct?
yeah, the cycle is 5-year max. If special circumstances arise, we can request a yearly or whatever interval we feel appropriate based on our concerns.
Does that happen very often?
Mainly when we shorten those, it's due to they've done some type of repair work or repairing that we want to just check it a little more periodically to make sure that repair is maintained.
Okay. If you could please, the falsification of the MIT, could you better explain how much time that would take, one, and two, does it involve welding the plate onto that nipple? I mean, is it done out in the field? Is it done back in a shop and then brought in? I'm having a little bit of trouble understanding how that is done.
Well, I have never made one, but I would assume they were made in a shop because they are welded. Plate inside that nipple, which is the short length of pipe, would, you know, could probably be done in the field, but it would probably be easier to complete in a shop, and it would require some skill.
Okay, so this isn't something you just pulled out of your pocket and inserted there on site.
No, it's a concerted effort to fabricate and then to install and then to go through the charade of even putting fluid within that connection to make it appear, you know, that the well casing was full of fluid as required before the testing.
Okay, how many of these did your staff find in their investigation?
We can confirm 6 that staff was able to determine that that fabricated equipment or there were multiple ones were used.
Okay, so once they put it on and they did the quote test, then would they take it off and use that on the next well?
They could. I think they had multiple pieces of fabricated equipment that they left on the well because initially staff was told that they didn't have the tools to remove it.
Okay, you just said that it required somebody with some skill to manufacture this. So who manufactured these? Who fabricated them? What service company was this?
I do not know who fabricated them.
We never found out.
No. I believe it was probably Dwayne Sims may be able to further elaborate on that. I would assume they were fabricated by Haas. I would be,
Would that have been Mr. Haas himself in the shop putting that together?
I do not think so. I don't know. I do not know.
Would it have been just one person or multiple people?
They could have been fabricated with just the knowledge of one individual, but you know, I don't know what, you know, how much traffic they have in and out of their shop, but I would think that it would not have been a big secret within the company that this was being done.
Okay, so when Mr. Sims did the inspection, was there a member of the Haas operating team or the service company with him?
Yeah, they met with Randy Bishop and it was Rodney Breeze that initially,
Oh, Rodney Breeze, I'm sorry. Yeah, okay.
yes.
So how often do you find these fabricated pieces of equipment designed to create or fabricate an MIT, a successful MIT?
Not very often, very rarely.
So you've had a long career with the KCC, more than 20 times, less than 5 during your tenure there in District 3?
My personal knowledge, I know of two other instances. And to put things in context, it you know, it may have been a more difficult thing to capture. You know, it's probably pretty easy. I mean, we have a large percentage of MITs that are unwitnessed.
What percentage are witness versus not witness, where you rely on the operator and the integrity of the operator to report accurate MIT testing?
The mandate is that we have to comply with EPA 25% witnessing. We're running 50-60%, and that has continues to improve. It's a tough number to maintain with the sheer volume of tests done in District 3, but also the technology that we have now to track things has allowed us, you know, we've made a lot of changes in our program, you know, that were either directly a result of this or accelerated by this, where now we have the capability to determine easily, you know, was this well witnessed on its last test? If not, you know, we're going to exercise our option a little more to say that we have to have somebody present and agree upon the time of the test, so that, you know, we don't have back-to-back cycles of unwitnessed tests, at least try to avoid those.
Were you, when you received the news from your field staff about this indiscretion, were you surprised?
Yes.
So after the initial fabrications were found, then you went back to a group of MITs that were performed the year before, correct?
Yes, ma'am.
And a significant number, is that correct? A significant number failed?
I believe it was 30 out of 32 or something like that. It was shocking. I expected a few, not that many.
So were those all witnessed MITs, or were they MITs that were unwitnessed, performed at the integrity of the operator?
We had some, both some that were recently done and even some of those that had been witnessed. We had staff witness them that was not, fairly new, inexperienced. That, hey, we did some MITs not long ago, brought their concerns to Dwayne, we need to go recheck those. Then when we got back to ones in the previous year, we went through basically all tubing and packer tests. And once we seen the failure rate of the ones we asked for, we just continued back through that 5-year cycle of all tubing and packer tests by this company. We requested new tests.
Okay. Okay, Chair Keen, I believe those are all my questions at this time. Thank you, Troy. I appreciate your responses.
Thank you, Commissioner Duffy. Commissioner French.
I have just a couple questions for Troy. Good morning, Troy.
Good morning.
My questions relate to this issue of the T1s and the transfers and whether staffs process them. And I'll frankly admit, I think that's a legal issue, probably can be addressed in briefing. So if you don't feel like you're the best person to address it, it's okay.
I'm probably not the best, but I will do my best.
And I do know this bit has been addressed in some briefing by the parties, and I expect it will continue to be. But I guess I want your perspective, at least to your knowledge. So my understanding of this is under the regulation, if there is a transfer of a lease or a well, then there's got to be the T1 form has to be filed. It's sort of a notice filing to us, but then we do have an internal way that we process it, and that can change and then that's what triggers the change in the well inventory. Is that correct?
Yes.
Okay. I guess, the question I have is there any process that you're aware of other than just the operator's own due diligence? Is there a process by which the new operator gets notice if there's a violation or remediation that needs to be done on a well before it's transferred to them? Is there anything out there that gives them notice? Is it simply the selling operator's legal duty to provide notice? I mean, any context you could give me would be helpful.
No formal that I'm aware of at this point. It is not unusual for the purchasing operator to contact the district to see, what they're looking at, what's coming due, especially that's not due yet, but maybe coming due soon.
Okay.
But that's that. Generally speaking, field staff kind of gets wind of when these things are going to be buying and sold, and there's a lot of off-record communication to try to get everybody on the same page. But I'm not aware of a formal. I mean, the request that we sometimes get is if there is financial assurance tied in with the operator who is selling the lease, then we may get a request to make sure, that we have compliance before the wells are transferred.
Do we have a policy, or is there a practice if a well is not in compliance on somebody's inventory and they transfer it? Is there any mechanism for that operator that had the violation and caused remediation to have to occur at that well, or some other compliance to need to occur? Do they remain liable to have to do anything, or do we have a policy on, once they transfer it, their hands are clean? What's been the staff position on that?
That's one of the ones that are above my head. I think generally they remain in the chain of potential responsible parties, but that would go before the commissioners and would decide what degree or how much, or, you know,
Yeah.
what percentage you would be held responsible.
I'm just trying to cut through and figure out, on this specific issue, you know, what's the reason for not processing? I guess, I mean, is it staff's position that there's a public policy reason to sort of hold your process in abeyance while there's a known outstanding public or compliance issue and potential environmental issue, just to ensure that nothing falls through the cracks in that transfer process, and that a known violation or an entity that has a known violation sort of remains on the hook until we resolve the compliance issue? Is that the staff position?
We would prefer that the operator, if you know, it was caught, that they resolve the compliance issue before that well changes hands. You know, from my perspective, it's just that is more easily accomplished than going through the arguments. You know, we've transferred this. Hey, we didn't know this. We don't have the resources to take care of that. We didn't know it was going to be that extensive of a, to resolve.
Mm-hmm. So, and this probably is a legal question, so I don't know that I should even ask it, but it's not even a matter of, I mean, from a property law standpoint, it sounds like the wells have changed hands. It's just a matter of us processing it and changing the inventory in our database, which may have some effect on our regulations, right?
I believe so.
I think that's all I have as far as clarification. Your testimony was all very clear, Troy, and I appreciate all your answers and the clarifications you've given in response to other questions today. So that was really the extent of the questions I had. So I appreciate it. That's everything.
Thank you, sir.
Thank you, Commissioner French. Well, good morning again,
Morning.
Troy. I do have a few questions for you. Without putting too fine a point on it, let me ask you to answer this. In overseeing the regulation of the Kansas oil and gas industry, to what extent do you, as regulators, rely on the voluntary compliance by operators of KCC regulations?
Extensively. There are numerous what we consider witnessed activities, you know, that are submitted to us that we did not have the resources to witness. Whether that be plugins.
Really kind of, I need to speak over you. Please continue.
No, go ahead. I'm
Okay. Pardon me. I thought you'd finished. So there is sort of an informal compact, is there not, with between operators and the commission, given the reliance the commission does place upon operators for compliance and the extent to which the level of detail about the various matters that are subject are regulated. The sheer number of that requires that sort of relationship, does it not?
Yes, we have extensive communications with industry. For instance, in the UIC, we may not witness, but we communicate to every operator about upcoming tests that are due and whatnot. You know, whether we are able to get there to witness those, but we're in communications with them about, you know, how to perform this test, when to do this test, when they're due, you know, multiple facets of communication.
All right, thank you. In order for me to ask the next question, John Myers, if you'd be kind enough, if you could go to the pre-filed testimony of Mark Haas, in particular, page 20, and screen
Yes.
share that.
One moment, yes.
Yes, very good. Thank you, John. Troy, can you see this?
Yes, sir.
John, you could go back to the other. Yeah, that's good. I think that's fine. That's if we need to scan in there's more closely, we can do so. Here's my question for you, Troy. In terms of potential approaches to resolving the violations that are under review here in these consolidated dockets, I'd appreciate your giving me, and I know you've addressed this within the context certainly of your pre-filed testimony, but I prefer that we kind of update that to current here and have you address it at this point. What is your view of these three options for resolution? Do you believe that any of them have a practical promise?
I do not.
And why is that?
No, I hear a lot about changes within the company. The contacts we are having in the field are all the same contacts. The resources that would require to put to it that, I would like to have seen, addressed the UIC issues that are still at large. It's going into 2 years. I've not done that. I would have thought that would have been a priority for the environmental part of things. I think that, there would be issues with what those objectives would be and how they would be prioritized. And then it requires a tremendous amount of resources to confirm status of objectives that are claimed to have been complete or not. And that there would be detail in there that probably, would create further discussion and debate, and that it would go on for a lengthy period of time.
All right, thank you. John, if I could have you turn to a different document here. If we could go to Mrs. Epps' pre-filed testimony of July 29th, 2022. In particular, pages 20 and 21.
Yes, one moment. Chair Keen, I believe this is what you're looking for.
Hasn't come up yet, John.
Oh, we have an issue then because it's showing me I'm sharing my screen. Give me just a moment.
Yeah. I'll tell you when it comes. It's I'm not sure Sean has access to the document to be able to aid you any.
Okay, do you see anything at the moment?
It says you're starting to screen share, but we see nothing. Black screen.
I see it, John.
Yeah, I see the pre-filed testimony of Rhonda Epps.
Okay, so it seems as if we've got some people being able to see it, but Chair Keen, you cannot see it.
Okay.
I see it.
Troy, can you see it?
Yes, and I have a hard copy in front of me.
Okay. Well, let's do this. I'm going to worry less about screen sharing now. This is F's testimony, and this is from July 29, 2022, page 20, beginning on lines 15 of 20, carrying on over to through line 7 on page 21. I believe what she does here, in response to the question about what Haas Petroleum is asking from the commission, I can see it. It's on my screen now. Thank you. And you've captured the whole thing. Thank you, John. If you take a look at this for a moment, just read through that, if you would, that answer to that question.
Okay,
Okay. As I see this response, I see basically three components of this response. One has to do with the suggestion that Haas be held accountable for the events of November 20th. That's alluded to certainly on line 16 on page 20. A second part of it begins on line 21, where Haas is requesting that their application for renewal of the license be granted on a probationary basis. And then it continues on over on page 22 with a bit more detail on that. And then the third aspect of this, what I kind of refer to as sort of a summary of outcomes that the operator is suggesting, is it's asking that the commission staff basically communicate to the commission, rather communicate to the staff to negotiate or deal with the operator in resolving certain issues here. Without being repetitive of your answers to the prior question that I asked you, I would appreciate your take on the approach that the operator is suggesting in this instance.
well, okay. I guess, in my position, all I can look at is the actions they have taken, those separate, they want to separate those that led up to this. And then during the time frame that this has, it has been before we arrived here today, the last 2-year period. I have not seen, in my estimation, the efforts to resolve these, they want to wait. I think when we delay, and as long as we can delay, I think it's probably beneficial for them as far as, kicking these things down the road until, they can, try to address them. Right now, there is a degree of difficulty in obtaining the service companies that would be required to accomplish these tasks. The focus on other, potential violation. I don't want to say minor violations, instead of addressing the most environmentally threatening ones first, I think would be an issue, because in any kind of, at this point, it would be a settlement agreement. We would want to address and prioritize those that pose the greater risk first, and that it would need to be done in a very short amount of time. I'm not familiar with any compliance agreement or settlement agreement that included a UIC well in failed status. I do not believe there is animosity between staff. I've talked to staff and we've directed them to, be as helpful as possible in technical questions or requests for information. We've shared GPS map information, well location information about wells that we have found in historical documents. What I do notice is that when those answers don't quite fit what they want to hear or expect to hear, that they're the ones that kind of get a little animosity. And that, you know, if you know, whichever way the decision goes, staff will work diligently to you know, to make the decision come to fruit. But I think that these things would be addressed far quickly. You know, I think industry as a whole is our best hope to resolving these issues in a quick and timely manner.
All right, thank you. Thank you, Troy. I was looking for a holistic answer, and that's what you provided. I appreciate your answer. John, you may remove the screen share now. Thank you very much. A couple more questions from me, Troy. I don't think it's necessary that we bring it up, but there is within as an exhibit to Mrs. Epps' testimony, again, the testimony pre-filed of July 29th, 2022. There is contained as an exhibit to that testimony a spreadsheet that is a spreadsheet of the alleged violations here that the operator has provided. And I guess my question to you is, which of the staff witnesses would I best address my questions to about the staff's perspective of this on this form, on this exhibit?
Ryan Dooling.
Okay.
I believe, you know, I think some of it is covered, you know, some of these numbers as far as what remains to be in compliance, issues that the operator have resolved that were not part of these combined dockets. We kind of break that out, and there's some information on that in my rebuttal from September of this year.
Okay. All right. My last question, which may be a series of sub questions here. I don't mean for it to be any longer than it need be, but to me, I think one of the most vexing and complex issues out of several complex issues that are presented by this case or this consolidated docket is a determination of the well count that should properly be attributed to the operator. This determination, I think, is certainly complicated by the transfers of some wells and well responsibility to other operators, and by whether some TA wells should properly be attributed to this operator, including based upon some reliance upon an interpretation or application of the most recent version of KSA 55-179. That's kind of a long prelude to my question, Troy, to be honest with you. But I guess what I'm asking is, in your opinion, currently, in the staff's opinion, what is the operator's total well count? Producers, injectors, and TAs. Do you have that handy? Or if you don't, who should I ask?
No, I mean, you know, we did not assign wells to Haas from our investigation. I mean, what we utilized was what we call the working operator, unless there was some extenuating circumstance. I mean, we found wells that they were producing that were not on their license. We found, you know, about a dozen unauthorized injection wells that were in use actively. I think there was one or two injection wells that they were actively in service using that were not on their license. So even if we resolved some of the additional wells that we can, you know, it's roughly, you know, depending on whether you count the wells that are included on transfers, you know, we're probably looking, you know, even if half of those were removed, you would be looking at a number around 1,800 to 2,000. a lot of the wells in the area of review, we're not looking at, we're looking more towards the 407 regs as far as area of review. Not, you know, they do not necessarily have to accept those wells. We're looking that those issues be resolved by whichever party we could find. And if we went into deeper, generally when we would initiate an inspection like this, those wells would generate NOVs, which open up the lines of communication so that we could try to resolve if there were other potential responsible parties that may be involved, or if the wells were simply abandoned and or Haases. Those were the two options. But, you know, basically we're wanting those addressed to satisfy AOR concerns and with injection. So, you know, some of those may be resolved, but I'm guessing, you know, you would probably be looking, you know, 1,800, and that's just a guess, right? Commissioner Keen.
Okay. Well, I appreciate your answer. Thank you for it was a difficult question and perhaps difficult answers. I'll ask the same thing of Mrs. Epps as well. That does conclude all of my questions at this time. I'll turn back to Mr. Marsh. Any redirect?
Could I ask one more question?
Absolutely, Commissioner Duffy, please.
Thank you, Chair Keen. Your questions prompted one of mine that I had missed. As I look at Ms. Epps' testimony of 7/29/22, she discusses on page 2, line 5, thus none of the senior leadership employed by Haas Petroleum at the time the events of November 2020 transpired are employed by the company any longer. So it's my understanding that Mr. Haas left. Who else left that you're aware of?
I'm not aware of, you know, any makeup. Like I said, our familiarity is with, you know, their field staff and who our field staff talks to. And then Mrs. Epps and Mrs. Barber, you know, have remained ones that we had contact with prior to. I've never been contacted by Mr. Haas. He's never reached out to me.
So would you believe that at the time, Ms. Barber, or excuse me, Ms. Epps was Director of Operations? Is that a senior leadership position to be Director of Operations? And I believe at the same time, Ms. Barber was a compliance officer for all of Haas's wells. In your opinion, as the district manager, are those senior leadership positions within a company that has multiple leases?
Yeah, I mean, I would see a company of that size that would want a compliance officer or operations, director of operations. You know, you would want people that were knowledgeable of the operations, knowledgeable of the regulations in which we operate on, you know, and have those good communications with the KCC. You know,
Are you aware of these two individuals actually going out to the field at any time and meeting with your staff prior to the events of November?
no,
So do you think, as being a compliance operator or director of operations, that they would have field savvy, and I put that in air quotes, about what is going on out in the field in terms of meeting the requirements, the regulation, the statutes of the state of Kansas?
yes, ma'am. I've had staff, you know, communicating with either of those two individuals or other field representatives within Haas, and the nature of the questions and the debate on the deal, you know, it shows that there is not a good knowledge of what they have on their leases what wells are in production, what wells aren't, where these wells are at, records of, completions and things like that, that we get requested that they want us to provide this information, and we share it if we have it. If we found it in some kind of historical documentation or whatever, we're happy to provide that. And we've provided extensive GPS maps where we try to match up these well locations that had never been GPS before surveyed, so that we are on the same page, at least when we're talking about a well and or a well location. But these are things that I think a prudent operator would have done, and I think there may be some requirements for that on the well inventory certification.
So isn't that why they hired Mr. Griffin, a licensed geologist in Kansas and Missouri, to gather and relay information from the field about their holdings that perhaps they didn't know what they had and felt? And again, this is after the November incident. But if these two individuals I discussed were not in the field, then you're relying on the service company to provide that information to you? Is that part of their responsibility?
My recollection and what I recall is why Mr. Griffin's services was that predominantly he was going to help them identify and ascertain, the wells that needed to have TAs filed and to do, those things you talked with. I do not believe I've ever been contacted by Mr. Griffith. It may be something that I know Taylor Herman with our staff, the district geologist, has had some interaction with him, I believe, on I want to say Miami or Franklin County, that maybe it would be useful to talk to him, question him about some of those interactions. But based on the limited conversation I heard, it did not appear that Mr. Griffith had actually been to the field either. So I don't know, who's collecting field data and how it's compiled and how that information is utilized.
Okay, thank you. And thank you, Chair Keen, for allowing me to ask another question. I appreciate it.
Absolutely. Thank you, Commissioner Tuffy. Redirect, Mr. Marsh.
Yes, thank you, Chair King. Troy, so one of the things that Mr. Brock talked about during his cross-examination was different compliance agreements that the commission has entered into. Have those other operators, to your knowledge, displayed the level of concealing environmental violations that Haas has?
No.
And I know that Mr. Brock also went into, talking about things such as good faith. I mean, do you believe that the actions demonstrated by Haas up to this point demonstrate good faith?
No.
I know another thing that he talked about were wells that have been transferred, and T1 wells. Are many of the wells that are part of that transfer out of, or are those wells that were Haas has filed T1s for out of compliance before the T1 form was filed?
Yes, the majority of the wells that are being transferred, a large number would have been out of compliance prior to the transfer being filed.
And another thing I'd like to point out, I'll share my screen if I can. Mr. Brock, let's go with this. Can you see my shared screen?
Yes.
Okay, so this is an email exchange between Mr. Brock and I. I believe it's attached as exhibit JB1 to Ms. Barber's testimony. Now on the subject line, it says regarding 21 CONS 168 CPEN. Is that a docket that is subject to these consolidated dockets, or a docket that is part of these consolidated dockets?
Not to my knowledge.
Do you know what docket that would be in reference to, or what operator would be subject to that docket?
I do not off the top of my head.
Okay, can you see this docket page for 21 CONS 3168? Under the description, it says penalty order for DB Energy LLC. Did I read that correctly?
Yes,
I would ask the commission take administrative notice that the docket 21 3168 does not regard Haas Petroleum and is part of the attached exhibit to Julie Barber's testimony.
Is there objection?
I don't have objection to taking administrative notice of what that docket entails.
All right. Accordingly, we will take administrative notice.
Okay. Troy, I know one thing you mentioned was that there was fluid in the elbows attached to these injection wells. Was that fluid placed there by Haas intentionally?
yeah, I believe so. It was to give the appearance. Generally, when you do a tubing and packer well, the annulus is filled with a non-corrosive fluid, and that is generally the method in which, you know, sometimes they have to add some fluid to it to get it to surface, get it to the top, and that's how the fluid is introduced into the casing.
So do you think that speaks towards the lengths that Haas went to cover up these environmental violations?
It demonstrates knowledge of what they would need to do to try and pull this off.
Do you know how many, so going to the penalty docket specifically, how many wells in these penalty dockets are still out of compliance?
I'm gonna get to my. I believe there are still. I believe it's 18 UIC wells and 61 of the TA violations.
Now, are you familiar with, so the UIC violations are for being in non-compliance with 82.3.407, correct?
Yes,
And the temporary abandonment regulations are for non-compliance with Kansas KCC regulation 82-3-111.
yes.
To your knowledge, do either of those regulations allow a well to be transferred as a way to bring it into compliance with that regulation?
No,
Lastly, I know Keith talks about KSA 55-179. Do you think these wells are more of a issue of 55-179 or more of an issue of the permitting factors under KAR 82.3.403? And I'm speaking specifically about the abandoned wells that were found within a quarter mile of operator or Haas's injection wells.
the wells investigated that were associated with area reviews, we were working under 403.
And does subsection A5 of 82.3.403 include abandoned wells within that subsection?
I don't think you have that pulled up.
Can you see me? Oh, I have the wrong screen pulled up.
I'm looking at 82.3.11.
Okay, let me get the right screen pulled up. I'm sorry about that. My numbers got switched around on me.
I'm not.
There we
in
go.
the team.
Can you see 82.3.403 now, which is permitting factors?
Yes, sir.
Okay, so to restate my question, under A2-3-403 subsection A5, does that include abandoned wells?
Yes.
Okay, thank you. No further questions.
All right, thank you. Recross, Mr. Brock, please.
Yes, I have just a few questions. I'm going to start my screen share. Can you see these emails, Mr. Russell?
Yes, sir.
They're
From you to Keith or to Kelsey? Yes.
correct. And it has this 21 CONS 168. Mr. Marsh displayed a different docket for a different operator associated with that number. Is that right?
Yes.
So if we scroll down to this, we're talking about injection wells canceling their authority, injection wells shut in. We list 4 wells right here. Are you aware of these 4 wells that are included in this docket, in these dockets? Riser B, Bob Edwards, Burke, and Harder number 3.
Yes.
And then we scroll up, it's the same email communication, we have a response. To answer your first question, I believe that Haas can fill out. We're talking about Haas specifically, correct?
I see it says Haas.
Okay. Could we put that, Kelsey, would you be able to share that 823403 that you had up a little bit ago for me? I apologize. I
Sure.
don't have.
Oh, you're good. Did I share the wrong screen?
Thank you very much.
Oh,
It just
sorry.
went away
I
on
didn't know if I
mine.
had the right screen or not, so make sure I get the right one. Can you see it?
I can. Thank you very much. I appreciate that. So, Mr. Russell, you're contending that as it relates to these injection wells within a quarter of a mile, that this regulation is the authority for basically including those within the district staff's inspection. Is that right?
Are we talking about on DB Energies or are we talking about Haas?
We're talking about Haas. Thank you for the clarification. I have to be careful with my numbers.
And
So-
I'm sorry, would you please, I'm get in here tight where I can read and listen here good. You'd repeat that question.
So this subsection A says permitting factors. When a permit authorizing injection is issued, the following shall be considered by the Conservation Division. Do these dockets involve an application for injection authority?
No,
And do you see anything in here that talks about well responsibility for existing abandoned wells and existing injection wells?
no,
And this is probably more of a legal question, but you would agree that KSA 55179 is a legislative statute addressing abandoned wells. Would you agree with that?
yes, but I would defer to legal staff's opinion, or if we had questions, I would confer with them.
Okay.
Yes.
And you would agree that this is an administrative regulation addressing factors to be considered when a new injection permit is issued. Do you agree with that?
I'm not familiar with the terminology when you call it administrative.
Oh, okay, that's fair. I just have one other question, and we may have to ask Ms. Epps to clarify, but I just want to see if it would change your position. So earlier you had talked about the remedies that she requested, essentially that Haas Petroleum be held accountable for the UIC violations, and that they be allowed an operator's license renewal, and then third, that they be that they be allowed to work cooperatively with commission staff to address other issues. When you answered the question, you referenced a UIC well being included in a compliance agreement. It's my understanding from this that Haas is not asking for these UIC wells to be included in a compliance agreement. They're only talking about these additional violations, primarily the TA violations, these other violations that the district staff discovered during its generic or broad investigation. if she clarifies that that is what she's meaning, would that change your opinion as to this? If they're asking they be penalized for the UIC violations, and that if they're asking that they be required to immediately bring those into compliance. I suppose the only caveat being wells that are transferred to someone else. But if she makes that clarification and I'm correct about her intention, does that change your position as it relates to her proposal?
And you're referencing compliance agreement. No, I mean,
Yeah, it was Miss Epps' testimony on pages 20 and 21. She had basically laid out, I'm referring to the line of questioning that Chairman Keene asked you about the three elements. And I'm just asking, when you answered the question, I understood your answer to mean that you thought Haas Petroleum was asking that its UIC wells be placed on this compliance agreement. I'm saying I'm just asking if Miss Epps confirms that that's not what she's requesting, that she's only talking about the compliance agreement as it relates to these other violations that the staff is alleging through its general investigation. Does that change your perspective on these three options?
not at this point in time.
Okay. I don't have any other questions. I appreciate your time very much.
All right, thank you. Thank you very much, Keith. Mr. Russell, I believe this concludes your examination this morning. We very much appreciate your appearing before the commission, and you may step down and you are virtually dismissed.
Thank you.
Mr. Marsh, if you would, please call your next witness.
Okay, staff's going to call Dwayne Sims. Let me go and grab him real quick. John, if we can change Troy's name to Dwayne Sims, I'd appreciate it.
Will do.
Morning, Dwayne.
Morning, Mr. Keene.
If you would, please raise your right hand. You swear or affirm that the testimony that you will provide today will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury.
I do.
Thank you. All right, very well. Let's begin. Mr. Marsh, if you would, direct examination.
Thank you, Chair. Can you please state your full name for the record?
Dwayne Sims.
By whom and in what capacity are you employed?
I'm employed by the Conservation Division of the Chinook, Kansas Corporation Commission. I am the District 3 UIC Program Manager.
And what is your work address?
It is 137 East 21st Street, Chinook, Kansas, 66720.
Are you the same Dwayne Sims who caused to be filed in these consolidated dockets testimony consisting of 13 pages and one exhibit on November 8th?
I am.
Was this testimony created by you or at your direction?
Yes, it was.
Now that you're under oath, do you have any corrections to make to your testimony?
No.
Do you swear the answers contained in your pre-filed testimony at the time it was filed are true to the best of your knowledge?
Yes.
At this time, staff moves for the admission of Mr. Dwayne Sims' pre-filed testimony and attached exhibit into the formal record.
Is there any objection?
No objections.
Without objection, it's admitted.
Thank you. At this time, staff tenders a witness for cross-examination.
We have
All
no
right, thank you very much.
cross-examination for this.
Miss-
I'm sorry, I got some feedback. Was I
All
talking
right.
over someone?
No, I got the essence that you have no cross.
Okay, yes,
Of this
yes.
All right, very well. Let's turn to commissioner questions. I'll turn first to Commissioner Duffy.
Thank you. Let me look here just a moment. Yes, if you would, Mr. Sims, I'm on page 7 of your testimony. It's line 14. It reads, on Monday, November 9th, 2020, I contacted operator's employee, Mr. Randy Bishop, about these wells. At that time, he informed me that he removed the equipment from the wells over the weekend. He also confirmed that each well had plates welded in the nipples. Further, he stated he had disposed of the equipment. I documented this conversation in the memorandum attached to my testimony. So I guess why would he dispose of the equipment? I mean, were you surprised? Is that?
I was very surprised that he disposed of the equipment on the 3 wells that we had checked the Friday before. I did obtain the equipment from the 2 wells that we had caught him on Friday before. And at his permission, I mean, I did not take them. I asked him if I could have them. He allowed me to take them. I don't know if he just done it just because they were embarrassed, or if they didn't want me to see them, or didn't want us to have that evidence, or I don't know why they disposed of them.
Well, I'm referencing your phone conversation, what you cited, the memorandum, and you state, when I asked him what he meant by that, he stated he had cut the equipment up into small pieces and disposed of them into the Verdigris River.
Yes, that is what he told me. He also told me I would have to go swimming if I wanted them.
Did he seem surprised that when you contacted him about this matter?
No.
Or how did he become aware of the matter itself?
Well, on November 6th, which was the Friday before November 9th, is when I went with, when I got a call from Rodney Breeze, said he thought we had a situation up there on the Wallace lease, number 8 and number 14. And when I got there, Randy Bishop was there, and the wells had the plates welded in them. They had already removed them, which he did not want to remove them at first. He said he didn't have a big enough pipe wrench to take them out. So I told Rodney I would head up there and assist him in that situation. Well, when I got there, they had found a big enough pipe wrench in the back of Randy's pickup to take them out. And they were laying there. One of them was still full of fluid because they put a plug in it. And I could clearly see that the plugs were in the nipples on the two fabricated equipment from the Wallace wells. His opinion that day was very, he didn't talk much. He sat in the truck. I had to engage conversation with him. He did not want to discuss the situation with me. I asked him on several occasions that day who fabricated the equipment and who put it in the well. He told me he would not know how they got there and who did it. And that was kind of how that went.
Did he believe that somebody had outside the company or the operator had nefariously done this, sabotaged their equipment? Did he offer that explanation at all?
That was never mentioned.
Okay. Thank you, Dwayne. I appreciate your responses. Thank you, Chair King.
Commissioner French.
I have no questions for Mr. Sims. Thank you.
Okay. Good morning again, Dwayne. I do have a couple of questions for you. John, if you could aid me just a bit here. I'm looking at Dwayne's pre-filed testimony of November 8th, 21. In particular, I want to look at pages 3 through 5. If you could bring up 3 and then go to 4 and then to 5. Go to 3 first. Yeah.
Okay, I
let's go
believe
back.
this is page 3.
That's 4, actually. Yeah, that's fine, right there.
My apologies. Here's page 3.
Yes. Dwayne, can you see that on your screen?
Yes, sir.
Okay. I'm looking at the question that begins on line 20, which is asking you to provide an overview of some of the operator violations here. Yeah, now scanning down, go ahead, John, and bring up page 4 now. Yes, with respect to docket ending in 3193 CPIN, we have 4 wells there. Then going on down on that page to docket ending in 3201 CPIN. And then go ahead, bring up the next page, please. Thank you, John. And then over on page 5, we have, again, with docket ending 3031 CPIN, a number of wells right there. Here's my question for you. This pre-filed testimony is now approximately 11 months old. In these 3 tables here, basically, to me, you set out for each of these dockets, the MIT status of several UIC wells as of the time of your testimony. If you know the answer to this, I would appreciate it. As of today's date, do you know whether there are any more of the wells that are shown here that are compliant, that were not compliant in November of 21?
Yes, there are more wells that they have brought into compliance since November of 2021.
Do you know how many of what we see here are out of compliance? I'm not trying to ask. Go ahead. I'm sorry.
There are still 17 wells on this list that are out of compliance.
Okay. Are they spread across all 3 dockets, or just 1 or 2 of the dockets? Do you know?
The first docket is complete. They've all been brought into compliance. The second one and third one still have wells out of compliance on it.
And a grand total of those out of compliance again is how many? 17?
17.
All right. Okay, thank you for that. The only other question I had for you, and I'm telling you, I'm almost reluctant to ask it because I think it may be manifestly unfair. So with that statement being made, because I think it may call for a legal conclusion, and I'm not trying to do that. I'm not trying to be tricky. I mean, in your role as the UIC overseer within District 3, you're dealing with our regs and our statutes day in and day out. It's part of what you do. So I guess my question would be this, to the extent you know, and if you don't know, please don't hesitate to say that you know. In performing all these various field investigations that occurred that pertain to the UIC wells of Haas, do you know if the field staff, are they aware of, and did they try to apply the various provisions and determine the applicability of KSA 55-179? And I'll even make the question more difficult. As I think was brought out through the testimony, and I doubt you even heard it, but the testimony that we previously had from Mr. Russell there is evidently a potential interplay, or I'd say even a potential conflict between KSA 55-179 and KAR 82-31403, which has to do with the application for injection permits and the requirement that the operator deal with abandoned wells within a quarter-mile radius of the proposed well. That is a really long question, but I guess let me take that in two parts here. And again, if you think it's something you would rather defer to legal counsel for, I'm going to tell you, you should say that. And I'm not trying to lead you there. I'm just trying not to be unfair to you in asking the question. In performing these field inspections on the UIC wells, is the field staff pretty cognizant of the provisions of KSA 55-179? Having to do with temporary abandonment and that sort of thing.
Temporary abandonment, or who's responsible parties?
Both.
So
responsible party primarily, pardon me.
I was gonna say, I thought 179 was responsible parties.
Yeah.
I would really rather not answer that question because that brings a lot of legal. I mean, I have not specifically talked with field staff about 179. So.
Okay. All right. Well, that's my question. I'm not going to the second part of it. The first part would lead to the second part. So those are all of my questions. Thank you for indulging me on that, by the way. That was not intended as a cheap shot. I think I appreciate your reluctance to answer. I understand that. I think it is a legal question. That concludes my questions. Mr. Marsh, redirect.
I don't believe so.
I'll give you a chance for recross if you wish, Mr. Brock.
I don't have any questions, Mr. Commissioner.
All right, very well. Well, Mr. Sims, that concludes your testimony. We appreciate your appearance before the commission this morning, and you were excused and you may virtually stand down.
Thank you, guys.
Thank you. Mr. Marsh, if you would, please call your next witness.
Thank you, Chair. Staff would call witness Rodney Breeze to the stand. John, if you could update Dwayne's name, I would appreciate it. Thank you.
When you're there, Rodney, please turn on the video. Very good. Morning, Rodney.
Good morning.
If you would, please raise your right hand. You swear or affirm that the testimony you're about to give this morning will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Very well. All right, we'll turn to you, Mr. Marsh, for direct examination.
Thank you, Chair. Can you please state your full name for the record?
Rodney Breeze.
Mr. Breeze, why, whom, and in what capacity are you employed?
I'm employed by the Kansas Corporation Commission, Conservation Division, in District Number 3 out of Chanute.
And what is your work address?
It is 137 East 21st Street, Chanute, Kansas, 66720.
Are you the same Rodney Breeze who caused to be filed in these consolidated dockets? Testimony consisting of 5 pages on November 8th, 2021, and testimony consisting of 15 pages and 3 exhibits on December 20th, 2021.
Yes, I am.
Was this testimony created by you or at your direction?
Yes, it was.
Now that you are under oath, do you have any corrections to make to your testimony?
I do.
What are those corrections?
The corrections on there are on the exhibits. under Exhibit RB-1. Page 43. The additional information I have wrote in there, it says shut in with a swedge and valve. And it's actually should be, the well shows 5.5 casing with 2.5 tubing, rods, and a pump jack with no head, which would disable the unit from operation.
Do you have any other, is that the only change to your testimony?
I have a few more, yes.
Okay. What's the next change?
Page 47, under the additional information, it shows as well number 26. It should state well number 27. On page 48, under the additional information, it also shows well number 26. That should state well number 28. And then page 76, it does not list a well number in the additional information. It should state well number 11.
And the correct well numbers were listed in the subject of those pictures, correct?
Correct.
Okay.
Then I have Exhibit RB2. I have some also.
Where's the first change on Exhibit RB2?
Page 37. On that one, I have the wrong, incorrect lease name and well number in the additional description. It should say Burke A7.
Does the lease name need to be changed as well, or is it still in the Berry lease?
It is on the Burke. The lease
Okay.
name is incorrect. Then page 86, the first sentence of the findings, the lease name should say Griblin.
And this is under findings?
It's actually a field report, not a picture. It should be,
Right, but under the findings of the field report?
yes, I'm sorry, yes, I misunderstood. Then page 128, have the incorrect well number in the subject. Should be stated W1. Then page 192. I have the wrong well number listed in the additional findings. It should be number 14. That is all of my corrections.
Do you swear that the answers contained in your pre-filed testimonies, along with the corrections that we just went through, are true to the best of your knowledge?
Yes.
At this time, staff moves for the admission of Mr. Rodney Breeze's pre-filed testimony with the aforementioned corrections and attached exhibits into the formal record.
No objections.
So let me be clear here, Mr. Marsh. We have more than one set of pre-filed testimonies for Mr. Breeze. Which of these are you referring to?
So I'll be referring to admitting the 5 pages of testimony that were filed on November 8th, 2021, and then the testimony consisting of 15 pages and 3 exhibits that was filed on December 20th, 2021.
Very good. I understand there's no objection, Mr. Brown. Is that correct? Without objection, they're admitted.
Thank you. At this time, staff tenders the witness for cross-examination.
All right, very well. Mr. Brown, all
We have no cross-examination.
right. Let's turn to commissioner questions, see if we have any of those. I'll turn first to Commissioner Duffy.
Thank you, Chair. Keen. Good morning, Rodney.
Good morning.
My understanding is you were hired at the commission in March of 2020. Is that correct?
That is correct.
But as I read your, as I read on page 2 of your pre-filed testimony dated December 20th, it appears that you've had a variety of duties in the oil field as a roustabout. You drilled and completed wells, plugged oil and failed injection wells, mechanical integrity, well preparation and testing, well maintenance, line repair, general operational duties. And then in March of 2020, you began your work at the KCC. Is that correct?
That is correct, yes.
So it appears that you've had extensive experience in the oil field.
Yes.
So when you began your mechanical integrity testing of the well on November 6th, the Wallace number 8, when, can you kind of go through that for me? Why you were suspicious of what you were seeing, and further, did you know what you found when you found what you did?
Okay, to go through it first, when we arrived at the location of the wells, everything was already set up. We had went to the Wallace 14 first, which was a 4.5 casing well, 4.5 inch casing well with 2 and 7 or 2 inch tubing on a packer. We came up to the location of the well, and the contractor proceeded to connect his connections or his hose to the well that already had the nipple, the valve, another nipple, and a 90 full of fluid. And he connected his gauge to it and pressured the well up. And typically on a well that's tubing packer, it does take I shouldn't say a certain amount of air, but per given the depth, it would take more air for the deeper the well. So the shallower the well, the less air. This well, I don't know exact depth of this well, but the amount of air that it took to obtain the 300 pounds was very minimal compared to other tests. I also noticed during the test that the wellhead has a plate on top that would mechanically seal the casing to the tubing to prevent any fluids or air escaping. That would have 2 bolts on either side of the plate to ensure this seal. Those bolts, if they're tight, they would seal the casing. If they're loose or gone, there would be no seal. This wellhead did not have any bolts at all, which gave me an indication that there was something going on. When we completed our time, we bled the well off, bled off the pressure, and it was a very, very small amount of air that came out. We then proceeded to the Wallace number 8, which I believe was a 3-inch casing with 1-inch tubing. And it just had a nipple and a 90. It did not have 2 nipples and a ball valve from the wellhead to pressure the well up. This one also took very minimal amount of air to pressure up. And we completed the time frame on this one, bled it off. It also had a very minimal amount of air released. And at that time, I asked Mr. Bishop if he would be able to remove the nipple from the wellhead so that I could verify the fluid on the backside or in the casing, between the tubing and casing. He had a wrench and he went over and attempted to remove the nipple, and it was unsuccessful in stating that, you know, he thought that they had been in there a very long time and that he probably wouldn't be able to get them out. And I trying to think of other ways to verify. I found a piece of wire that I had on the ground or in a pickup, I'm not sure which. Try to thread it in the nipple to reach the inside of the casing, which I tried multiple times and it kept going just to the end of the nipple, would not enter the wellhead from, you know, holding it outside, and it was the exact length of the nipple. So we then told him we needed to look at the Wallace 14 that we'd previously done, and he tried to take that one out as well and was unsuccessful. So I again used wire, and that one would only go, like I said, it had from the wellhead, it had a nipple, a ball valve, and then another nipple with the 90, and it would only go to the threads of the ball valve. It would go no further. At that time, we went, took a break for some lunch, and that was when I contacted Mr. Sims to let him know of the situation that I thought I had uncovered. And after lunch, we came back and we were waiting on Mr. Sims to arrive. And I happened to ask Randy or Mr. Bishop if he had another wrench or if he needed to get one to be able to remove the nipples from the wellhead. And he proceeded to get one out of the toolbox of his truck and went over and removed them. And he had put the plug back in the 90 so the fluids didn't escape when he was unscrewing it. After we got it out, the inside of the nipple was dry on the end that was connected to the wellhead, and the fluid still remained in the other end. I'm not sure how long it was before, well, I guess next we went to the Wallace number 8, removed it, and it didn't have a valve, so you could see the plug that was welded in right in the end of the nipple. It still had fluid in it as well. And then a little while later, Mr. Sims arrived and confirmed, you know, that there was no fluid on the backside of the case, or on the backside of the tubing inside the casing, and that, you know, obviously they had manipulated equipment to falsify the tests. Whenever we released the pressure, or I had an idea when we pressured the wells up that there was a possibility, and was seeing the condition of the wells. When we released the pressure, it was very evident that there was something not right. And then, of course, when we removed, and we could physically see the evidence. But
So while you had not been a KCC employee very long, you had worked in the oil field since about 2005 upon graduating from high school. So have you ever seen anything like this before? Did you know what you were looking at?
I had not seen anything like this before. I didn't know exactly what we would find when we removed them. You know, there are other ways to, I would say, achieve a false test. but would require more work. It'd be harder to get them to that point to pass. But personal knowledge, I didn't have any as far as what exactly we would find. If that answers your question.
Okay, thank you very much, Rodney. I appreciate your responses. Thank you, Chair King.
Commissioner French.
I have no questions for Mr. Breeze. Thank you, though.
All right. Mr. Breeze, a couple of questions for me. First of all, if I'm incorrect here, you correct me, please. But as I understand it, your area of responsibility in eastern Kansas encompasses Coffee, Greenwood, Lyon, Osage, and Wabunsee counties. Is that correct?
Correct. And also other places as needed.
Well, I'm going to credit you with knowing a lot of geography. That's a lot of territory. And I appreciate the fact that it's not necessarily confined to that either. As I look through your testimony, and I'm just summarizing it here succinctly for the record, in the investigations that you conducted, police inspections you conducted, in Coffee County, by my count, that encompass, these are Haas leases, 19 leases. In Greenwood, it encompassed 16 leases, and in Wabunsee, 3 leases. That again strikes me as a lot of geography. With that in mind, here's my question to you, and I want to kind of lean, as I think Commissioner Duffy was as well, on your experience. You have some certainly real world experience before you came with the commission. So my question is this: based upon your personal inspection of these Haas leases, what was the most common violation?
I would say the most common would have been wells listed as producing that were actually inactive.
Okay, and in those instances, how did you determine that they were inactive? Were they absent any surface equipment or tubing, or how did you determine that?
There was a variety of things that determined. Some of them were, like you said, absence of any equipment. They were just an open hole in the ground with no swedge or valve or anything. Some of them were would have tubing and rods, but pump jack would not be connected to the well, and some of them would be complete with pump jack and maybe wouldn't have electrical supply connected to the well.
Okay. How common, going back to that one category of wells that I just identified, how common in the instance of the T8 wells was the absence of any surface control equipment?
It was very common, I'd say. I can't put a number on it by any means, but I would say close to half.
Oh, okay. Now I'm telling you, I'm going to tell you what I mean by that for clarity on the record. What I mean by that would be an instance where you would have a casing at the surface that had no control valves, swedges or nipples on it. It was just open to the atmosphere. And so are those the kinds of wells that you're referring to as well?
Correct.
Okay. All right. And my other question is this. Again, based upon your personal inspection of these Haas leases that you inspected, What was, in your opinion, the most serious violation?
I would say the most serious would be probably the the injection wells that were being used that were not authorized and that hadn't been tested in a very long time.
Were these all tubing and packer completions, basically 4.5 by 2 inch of some sort?
The ones I came across, yes,
Oh, you didn't see any slim holes?
not very common in my area. No.
Okay, thank you. That concludes all of my questions.
Chair Key,
Yes,
if I
yes,
could,
please. Yes, please.
I'm sorry, but you keep, your questions are so good, it makes me have a question. Why would somebody list their well, an operator list their well as producing when it's clearly inactive because it doesn't have the motor or the electricity or whatever? Why would an operator list it as producing?
I would say it's personal opinion, but I would say it's maybe to avoid paperwork and having to start the TA process. Like I say, usually those are only allowed to be shut in for 10 years. So that kind of puts a clock on the operator for a timeline of having to do something with the well.
Okay. So isn't there a production report that's also available that lists the production from each well over a period of time?
Are you referring to like KGS?
Yes.
Production records? I believe those show production records for the lease.
For the lease.
They may list the number of wells that the operator, I believe, reports as active, or it wouldn't report inactive wells, but the number of active wells contributing to the production.
Okay. On these wells that appeared or were not in service, that were not producing, did it appear that they had just stopped producing lately, like within the last couple of months, or did a majority of them appear to be out of producing service for a long period of time? Can you even comment on that? Maybe you can.
I would say there would be some that may have stopped producing within the last few months or so at the time of the inspections, but majority of them had been, it was evident that it had been quite some time since they were producing.
So if it had been lately, they would have had to remove some of that equipment and perhaps installed it somewhere else, but there would have had to be an activity. You just didn't turn it off. Did you remove something typically from the well?
A lot of the wells did have stuff removed from, like, say, the tubing and rods is required to produce the well of those type. And there was several that didn't have the equipment there, whether it be a pump jack or tubing and rods or whatever. That's not an easy thing to just remove. And sometimes the equipment was, the tubing and rods would be laying beside the well and it was covered in dirt and grass, and it was evident it had been there for quite some time.
Okay, thank you. And again, thank you, Chair King.
Very well, thank you. Mr. Marsh, redirect.
No redirect.
Mr. Brock, any cross?
No, Mr. Chairman.
All right, thank you. Mr. Mr. Breeze, thank you very much for your appearance here this morning. This concludes your testimony. You may now stand down virtually and have a good day.
All right. Thank you, sir.
Thank you. Let me give you some idea of what I'm thinking about here in terms of our progress and our timeline. My plan is now about 5 till 12. What I'm thinking is that we try to do one more witness. After that, take a half-hour lunch break and then resume. If that's everybody's amenable to that approach, that's what we will do. I don't see anybody give me a big thumbs down, so that's what we will do. Mr. Marsh, if you would, please call your next witness.
Thank you, Chair. Staff would call witness Taylor Herman to the stand.
When you're there, Taylor, please turn on your video. Good morning, Taylor.
Good morning.
It still is morning, barely.
Yes.
If you would, please raise your right hand. You solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God, or under penalty of perjury.
I do.
Thank you. Mr. Marsh, direct exam.
Thank you, Chair. Can you please state your full name for the record?
Taylor Herman,
Mr. Herman, by whom and in what capacity are you employed?
the Conservation Division of the Kansas Corporation Commission in the District 3 office as a district geologist.
And what is your work address?
137 East 21st Street, Chinook, Kansas, 66720.
Are you the same Taylor Herman who caused to be filed in these consolidated dockets, testimony consisting of 14 pages and 3 exhibits on December 20th, 2021?
Yes.
Was this testimony created by you or at your direction?
Yes.
Now that you're under oath, do you have any corrections to make to your testimony?
I have one correction on exhibit TH-2, page 16. In the additional information underneath the picture, it should read inactive oil well, not completed alternate 2. Well has high fluid level and is within quarter-mile AOR of 2 authorized injection wells.
Do you have any other changes?
No, that is all.
Okay, thank you. Do you swear that the answers contained in your pre-filed testimony at the time it was filed, along with the corrections that we just went over, are true to the best of your knowledge?
Yes.
At this time, staff moves for the admission of Mr. Taylor Herman's pre-filed testimony, 14 pages and 3 exhibits given on December 20th, 2021 into the formal record.
No objections.
Is there any objection? Without objection, it's admitted.
Thank you. At this time, staff tenders the witness for cross-examination.
Mr. Brock?
Have no cross-examination for this witness.
Very well. Let's see if we have commissioner questions. Commissioner Duffy?
I have no questions. Thank you.
Commissioner French?
No questions. Thank you.
All right, very well. Well, Taylor, you're not going to get off quite so easily with me, although I think I don't think you have too much problem with questions I'm going to ask. And certainly in terms, you are the district geologist, so that means that you're the state geologist for all the territory encompassed within the eastern reaches in District 3, correct?
Correct.
So that is a heck of a lot of geography. We're going to give you probably the max out on geography here in terms of the witnesses. From reviewing your testimony, it appears to me that you have inspected operator leases in Franklin in Miami County. And by my count, you inspected 1 lease in Franklin and 15 leases in Miami. So my question to you is this, very similar to the question I asked of Mr. Breeze. Based upon your personal inspection of these Haas leases in these 2 counties, in your opinion, what was the most common violation?
I would say it's similar to what Rodney said, where it was wells listed as producing, but were inactive.
Okay. And what, in your opinion, was the most serious violation?
The unauthorized injection wells or disposal well.
Okay. Very well. That concludes my questions. Mr. Marsh, any redirect? I mean, yes, any redirect, please.
Thank you, Chair. I guess one question, Taylor, do you know off the top of your head how many unauthorized injection wells you found through your lease inspections?
I believe it was about 6, 5 to 6, I believe.
Thank you. No further questions.
Thank you. Any cross?
No, Mr. Chairman.
All right, thank you very much. Well, Mr. Herman, I believe this concludes your testimony. We appreciate very much your appearance before the commission this morning. You may virtually stand down.
Thank you.
Thank you. With the indulgence of all parties here, I mean, that took 5 minutes. I'm going to press on just a little bit further and would ask you, Mr. Marsh, if you would please call your next witness.
Thank you, Chair Keen. Staff would call witness Dallas Logan to the stand.
When you're there, Dallas, please turn on the video. Good morning. Good afternoon, Dallas.
Good afternoon.
Would you please raise your right hand? You solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Thank you. We'll turn to you, Mr. Marsh, direct examination.
Thank you, Chair Keen. Can you please state your full name for the record?
Dallas Logan.
By whom and in what capacity are you employed?
I'm employed by the Kansas Corporation Commission as an environmental and compliance regulatory specialist at the District 3 office in Chanute.
And what is your work address?
137 East 21st Street, Chanute, Kansas 66720.
Are you the same Dallas Logan who caused to be filed in these consolidated dockets testimony consisting of 32 pages and 4 exhibits on December 20th, 2021?
Yes.
Was this testimony created by you or at your direction?
Yes.
Now that you're under oath, do you have any corrections to make to your testimony?
No.
Do you swear the answers contained in your pre-filed testimony at the time it was filed are true to the best of your knowledge?
Yes.
At this time, staff moves for the admission of Mr. Dallas Logan's pre-filed testimony given on December 20th, consisting of 32 pages and 4 exhibits into the formal record.
No objections.
Without objection, it's admitted.
Thank you. At this time, staff tenders the witness for cross-examination.
Mr. Brock, any cross?
I have no cross. Thank you.
All right, thank you. Let's see if we have commissioner questions. I'll turn first to Commissioner Duffy.
Thank you. Yes, just a couple. Good afternoon, Dallas.
Good afternoon.
I see by your educational background and work experience, you've
Quick.
you have spent some time in the industry before you came to the KCC in 2018. And you state that I also conducted mechanical integrity tests on disposal wells for initial disposal permits and 5-year tests. So my question to you, as I read through your testimony, you go lease by lease and talk about your findings, but specifically, you're familiar with MITs. And in that regard, in your work experience, either in the industry or at the KCC, have you ever seen evidence of fabrication of equipment to manipulate an MIT?
I had not.
Would you know it if you saw it?
Yes, I think that there would be reason to question, as Rodney stated in his testimony, that when you're on location, there'd be things you'd notice to question the integrity of the test.
So while you had a lot of responsibility in reviewing the Haas leases, you also have responsibility reviewing other leases and doing the work out in the field, correct?
Correct.
And during that time, you've never seen or never witnessed an MIT where you suspected there to be some fabrication of equipment to disguise the testing.
Correct.
Thank you. That's all I have, Chair Keen.
Thank you. Commissioner French.
No questions. Thank you.
All right, thank you. Dallas, just a few from me. First of all, I just can't help but note, I'm looking on page 2 of your pre-filed testimony. Your biographical information reflects, as I think Commissioner Duffy indicated, a dearth of practical experience in the oil patch. Primarily Eastern Kansas too, is it not?
Yes, all in eastern Kansas.
All in Eastern Kansas. Monitored coal bay methane wells, gas transportation lines, saltwater disposal wells, disposal lines, conducted MITs. Set up tank batteries, you've done it all, haven't you?
Done quite a bit.
Sorry, I'm not trying to play on your humility here at all. I think your experience is quite extensive. As I understand it, you're presently responsible for overseeing oil and gas operations in Allen, Bourbon, and Woodson. Is that correct?
At the time of this testimony, that was correct, yes. I am now helping Russell Hine with the abandoned well program at this exact time and working a lot on the federal plug-in project coming up, along with helping in other areas as needed.
Okay, well, thank you for that addition. Again, taking from your pre-filed testimony, your inspections here were pretty much confined to Allen and Woodson County, and that's a pretty poor use of the word confined. It appears that they've inspected 4 leases in Allen County. Is it possible that I counted 83 leases in Woodson? Is that right?
That sounds about right. Without going back through and counting them, yeah, that sounds about right.
Okay. And I've looked through all of the exhibits that you have here. They're exhaustive. They're, I don't know, it makes the New York phone book look small. So my question to you then, Dallas, is basically the same I've asked of your counterparts. Based upon your personal inspection of the Haas leases that you have inspected, what in your opinion was the most common violation?
The most common violation, as Rodney and Taylor both started, would probably be wells that were listed as producing that were inactive. And the other one in Woodson County, in one well, I think in Allen County, but I know a lot in Woodson County where wells were listed on operator certified well inventory as producing oil wells that I could not even find a well location above ground per operator's footage is on their certified well inventory. And when operator staff was contacted, they had very little or no knowledge of what may have happened to that well and where that well may have been. And on a couple of those leases, they had reported supposed oil spills within the last 2 years. Example would be, let me find it, it's a Colt lease is the name of the lease. It had in a Kimball lease. Those are the two that come to mind. I could not find any wells on either of those leases, and both of them had reported fairly recent oil spills within 2 years. And that is puzzling to me, to say the least.
Okay. Did you find within the ambit of these leases you were looking at within Allen and Woodson, how frequently was the occurrence that there was no surface well control?
Very, probably 75% at least of wells that were inactive had no surface control. Now, all those wells may not have been on operators well inventory, but even the majority of the wells found inactive on operators well inventory did not have surface control. They were not properly shut in.
Okay. And my last question again, same as with your colleagues. What, in your opinion, is the most serious violation that you witnessed?
Unauthorized injection wells, as they both stated, but then not only unauthorized injection wells, but unauthorized injection wells that were not even wells listed on operators well inventory. So wells that we had no records of, or wells that were matched to expired intents from either past operators or a license that was associated with Haas from a previous license, but wells that, again, they had no completion information. You know, we had to go out and physically confirm there was a well there, and they'd been actively putting water in the ground for an extended period of time. So, sure, with that being stated, the thought of a mechanical integrity test never being done had ever occurred. So I'm sure these wells, for as long as they'd had water put in the ground, had never been tested. So that would, I'd say, be the largest concern.
Okay, thank you. Didn't mean to talk over you. In those instances of wells you saw being used for injection that had no permits, in all instances, was the water being injected through tubing, or was it being injected directly into the casing?
We had some actually just injected into the casing out in Woodson County. There were some actually injection wells, some slim hole wells that were having fluid injected into them, that again, they were unauthorized wells, not on operators well inventory.
Okay. All right, thank you. That concludes my questions. Mr. Marsh, redirect.
Thank you, Chair Kane. Dallas, how many unauthorized injection wells did you find on Haas's leases during your inspections, if you remember?
Over half a dozen I can think of off the top of my head, and that may not be all of them. I think Ryan has closer to exact numbers on his exhibit that we looked at, but I can't remember the exact number of them. It's right off the top of my head. I know it's over half a dozen.
Thank you. No further questions.
All right, thank you. Any cross?
No cross.
All right, thank you. I believe, Dallas, this concludes your testimony. The commission appreciates your appearance here this morning, and you may virtually stand down. Mr. Marsh, I'm going to push the envelope a little bit here. Call your next witness, please.
All right. Yes, sir. Staff would call Keith Carswell to the stand.
When you're there, Keith, please put on the video. Good afternoon, Keith.
Good afternoon.
If you would, please raise your right hand. You swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Thank you.
Can you please state your full name for the record?
Keith
Mr.
Carswell.
Mr. Marsh, correct exam, please.
Thank you, Chair. Sorry,
I'm sorry.
I talked over you.
Mr. Marsh?
Can you hear me? Okay. Can you please state your full name for the record?
Keith Carswell,
By whom and in what capacity are you employed?
the Conservation Division of Kansas Corporation Commission as an ECRS,
And what is your work address?
137 East 21st Street, Chanute, Kansas.
Are you the same Keith Carswell who caused to be filed in these consolidated dockets, testimony consisting of 17 pages and 4 exhibits on December 20th, 2021?
Yes,
Was this testimony created by you or at your direction?
yes.
Now that you're under oath, do you have any corrections to make to your testimony?
Just one. On my testimony, page 12, line 19 and 20, I stated that on the Farrell lease that there was an active or a authorized injection well that was in producing status. After talking with Haas staff, I got 2 locations mixed up, and I've since corrected the wellhead footages to show that.
Okay, thank you. So given those corrections, do you swear that the answers contained in your pre-filed testimony at the time it was filed are true to the best of your knowledge?
Okay,
At this time, staff moves for the admission of Mr. Keith Carswell's pre-filed testimony consisting of 17 pages and 4 exhibits on December 20th, 2021 into the formal record.
I have no objections.
Without objection, it's admitted.
Thank you. At this time, staff tenders the witness for cross-examination.
Mr. Brock?
Thank you. I have no cross-examination questions.
Thank you. Let's see if we have commissioner questions. We go with Commissioner Duffy.
I have no questions. Thank you.
Commissioner French.
No questions. Thank you.
Okay. Keith, I do have a few questions for you. They are few in number. If I'm correct, here in looking at your pre-filed testimony, the areas of eastern Kansas that you are responsible for and overseeing your commission responsibilities include Anderson, Franklin, Lynn, and Miami. Am I correct?
yes, sir.
All right. And with respect to the the lease inspections that you performed, it appears to me that they were performed in 2 counties with respect to Haas, 14 leases in Anderson, and by my count, 30 in Franklin. Does that sound about right?
Yeah, that's right.
Well, as well, I am impressed with your background as well. You have a lot of real practical experience that you bring to the commission. So let me ask you the same questions I've asked of your peers. Based upon your personal inspection of the operators' leases that you conducted, what, in your opinion, was the most common violation?
Same as the others, wells listed on operators inventory as producing when they were actually inactive.
Okay. And my second question would be the same. What, in your opinion, from the wells that you witnessed here on these leases, was the most common, was the most serious violation?
The unauthorized injection wells.
All right. That concludes my questioning. Mr. Marsh, any redirect?
No redirect.
Mr. Brock?
No questions. Thank you.
All right, thank you. Mr. Carswell, I think that concludes your testimony. The commission thanks you for your appearance here this morning, and you may virtually stand down.
Thank you.
All right. Mr. Marsh, call your next witness.
Mr. Keen, I don't mean to interrupt. I do want to just be clear, though. I will have questions for the next one. I know I haven't had any for the others, but I just wanted to make the commission aware that I do have some planned for the next witness.
Fair enough. And I appreciate that very much, Keith. I think given that fact that what we will do then is take a break for lunch, and then we might have some continuity with respect to the testimony of the witness. So why don't we do that? By my reckoning here, it's 12:20. Let's take a half-hour break we'll take a recess and resume at 12:50. That sound all right for everybody? All right. We are in recess until 12:50. Thank you. Do turn off all your devices there. Thank you. Okay, John, if you could, let's go back to full screen. Very good.
Mr. Chairman, can I say something really quick before we start?
Please do.
My client sent me a message that their power went out a few minutes ago. They're experiencing internet and electrical problems right now, so they're trying to join. I just wanted to.
I see Mrs. Epps is back.
Okay, great. She fixed it. Thank you.
Things better on your end, Ms. Epps? Okay, very good.
Yes, thank you for asking, yes.
All right. Keith, if it's okay with you, we'll proceed.
It is. I apologize for that. It freaked me out when.
No, these things happen. These things happen. Our end too. Very well. It's now 12:52. We're going to return from our recess here, and we are back on the record. I'll turn to you, Mr. Marsh, and ask that you call your next witness.
Thank you, Chair Keen. Staff calls witness Ryan Dooling to the stand.
Dooling, if you would, please raise your right hand. You solemnly swear that the testimony you are about to give in these proceedings will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
All right, thank you. Good afternoon, Ryan.
Good afternoon.
Let me turn to Mr. Marsh for direct examination.
Thank you, Mr. Chair. Can you please state your full name for the record?
Ryan Dooling.
Mr. Dooling, by whom and in what capacity are you employed?
I'm employed by the Conservation Division of the Kansas Corporation Commission District 3 office out of Chinook, Kansas, as a compliance officer and regulatory specialist.
And what is your work address?
137 East 21st Street, Chinook, Kansas, 66720.
Are you the same Ryan Dooling who caused to be filed in these consolidated dockets, testimony consisting of 11 pages and 11 exhibits on December 22nd, 2021?
Yes, sir.
Was this testimony created by you or at your direction?
Yes.
Now that you're under oath, do you have any corrections to make to your testimony?
I do not.
Do you swear the answers contained in your pre-filed testimony at the time it was filed are true to the best of your knowledge?
Yes.
At this time, staff moves for the admission of Mr. Ryan Dooling's pre-filed testimony consisting of 11 pages and 11 exhibits that was filed on December 22nd, 2021 into the formal record.
No objection.
Without objection, they're admitted.
Thank you.
Yes. All right. Direct examination.
Staff tenders the witness for cross-examination.
Pardon me. Indeed, let's do that then. Mr. Brown.
Thank you, Chair. Mr. Dooling, do I understand from your pre-filed testimony that you're the compliance officer for District 3?
Yes, sir.
Okay, thank you. And do I understand that it's your job to prepare evidence and recommend penalties for probable violation of commission regulations for District 3?
Yes, sir.
Mr. Dooling, are you aware that KSA 55179 was amended in July of 2021?
Yes.
Did you receive any training or education about the contents of the amended 55179?
Under that statute, I advise getting information from legal as to where to move forward with anything that would come up in a case.
But you didn't receive any formal training about what changes may have taken place as a result of the statutory amendment?
I'm going to say no to that. I just become the compliance officer lately, so.
Okay, thank you. If I may, I'm going to share my screen. Mr. Dooling, can you see my screen? It's a portion of your pre-filed testimony. Can you see it or?
Yes, sir.
Okay. I'm going to go to page 5, lines 3 through 4. So at the beginning of this testimony, you indicate that staff's investigation included 2,232 wells. Is that true?
Yes, sir.
Isn't it true that this number includes a large number of wells that are not claimed by Haas on its well inventory?
That is true. That number represents every well that we found on the lease, even wells not on Haas's well inventory as of to date, whether they were inactive or actually currently being produced or injected into.
And I've just switched the document that I'm sharing to you now. It's just a copy of the new KSA 55179. I'm going to scroll down to subsection E, abandoned well. It says abandoned well means a well that is not claimed on an operator's license, that is active with the commission and is unplugged, improperly plugged, and no longer effectively plugged. So would you agree that these wells that are not on Haas's operator's license would be considered abandoned wells?
No, sir, I would not agree to that. Not all of them.
Would a large number of them be considered abandoned wells under this definition?
Without going through all the field reports from the last 2 years, again, a majority of them probably are inactive abandoned wells, but there is a significant amount of wells not on their inventory that they were currently producing or actively injecting into. So obviously, I don't believe you would like to include those in that subsection.
And just to clarify, earlier in your testimony, you had said that you inspected all wells located on the leases that Haas Petroleum operated. Is that correct?
That is not correct. I mean, staff did. I personally did not investigate each lease.
Yeah, so I apologize. That's a slip of the tongue. I was referring to staff and should have been more specific. Thank you. So to clarify, staff did include in its investigation all wells located within the lease boundaries of Haas Petroleum's leases, correct?
That is correct.
Okay. I have on my screen, it's still KSA 55179, and we're looking at subsection B3, and we had read it earlier, but it says, accepting an assignment of lease, obtaining a new lease, or other documentation between private parties shall not, in and of itself, create responsibility for a well. And then we're just going to skip, and then it says, unless such instrument adequately identifies the well and expressly transfers responsibility for it. Did staff pull copies of the leases that Haas Petroleum was operating under to determine if there were well lists or specific descriptions as to these wells in those documents that you included in your investigation?
Not that I am aware of. I would have to ask each staff, but that would, the overall investigations were so time consuming that going to courthouse records would have added many months of that to the plate. However, they did reach out a lot to field staff for Haas. As we discovered things, we would ask, staff would ask the field personnel questions on the boundaries of the lease.
And so I guess to clarify, are you testifying that to your knowledge, staff did not review lease agreements or assignments to determine if wells were specifically identified in those documents?
To my knowledge, no.
Okay, thank you. I'm going to flip back to your pre-filed testimony now, and I'm going to go to page 6, lines 22 and 23. At the very last sentence, I'm sorry, I didn't wait for you to get there. Are you ready, Mr. Dooley?
Yes, sir, I am.
Okay. The very last sentence says, further, the list includes inactive wells not on operators' well records, but within a quarter mile of one or more operators' injection wells. So this list of 2,000 wells that the staff investigated included also injection wells located within a quarter mile of one of Haas's injection wells. Is that true?
You stated injection wells located within a quarter mile of Haas's injection wells. We GPSed and located and investigated all wells, whether it was oil or injection within the quarter mile or yes, that was on within the lease boundaries that we knew of.
So just so I guess I understood the answer, you're saying you did include abandoned wells that were located within that area of review of injection wells?
Inactive wells, yes, sir.
Thank you. Is there any portion of KSA 55-179 that you relied on to do that?
No, sir, I relied on 82.3.403, section A, subsection B of the KCC regulations.
I'll flip over to that real quick. So I've displayed on my screen a copy of 82 KAR 82.3.403. Did you say you were, which subsection did you say you were referring to? I apologize. I didn't get
No, that's okay. A, subsection 5.
A5. So let's start with 5, what we're talking about. So these are permitting factors, correct?
That's what it says, yes, sir.
And so when a permit authorizing injection is issued, and then it lists several factors, do you contend that there is an application presented in these dockets where the commission's being asked to issue an injection permit?
Not in these dockets that I'm aware of.
Okay. And would you also agree that in subsection 5, it simply says for you to consider the construction of all wells within a quarter mile? It doesn't create an automatic veto mechanism, does it?
It states construction of all oil and gas wells within a quarter mile radius of the proposed injection well, yes.
So just a factor you should consider, right? Let's flip back to KSA 55-179. It has a similar provision talking about responsibility related to injection wells. So I'm looking now at subsection B1. And it says, any person causing, whoops, I won't highlight it. It put covered it with something. Any person causing pollution or loss of usable water through the well, including any operator of an injection well, disposal well, or pressure maintenance program. Did staff do any investigation to determine if there was any pollution or loss of usable water through these wells before just assigning them to Haas?
First of all, we didn't just assign it to Haas. We documented every well that was located within the lease boundaries. We did not actually include it in the well inventory. But I believe what you're referring there to above, it says a person that is legally responsible for the proper care and control of an abandoned well shall be limited to one or more of the following. And would you repeat your question one more time for me, please, on what you have there for subsection 1?
Yeah, so subsection 1 deals with, I'll just generically say that it deals with a potential for an operator to become responsible if they cause an abandoned well to break out. And so this says any person causing pollution or loss of usable water through the well. So did staff do any investigation to determine if there was any pollution or loss of usable water through any of these abandoned wells before including them in your investigation and assigning or alleging violations against Haas with them.
I'm not sure exactly. I think I'm understanding that correctly. However, we did not investigate whether, there's a lot of, it's going to be kind of difficult. I mean, a lot of the wells, some of the wells have never been tested that they're injecting into, which allows other AOR wells around. Those wells have never been tested. If you're defining the injection well that is authorized, did we do any investigation whether it was causing any other wells to flow or break out? Is that the question?
Correct. Yeah.
Well, there's a lot of ways that it could be polluting the other abandoned well.
Did you do any investigation to determine if it was? That's all I'm really asking.
I'm going to answer no there.
Okay, thank you. That I wasn't trying to trap you. I know it was a long question, but that's all I was getting at. Let's talk about T1 transfers for a little bit. I'm going to switch my screen now. I'm going to show KAR 82-3-136, transfer of operator responsibility. And I don't know whether we're actually going to need this up here, but when is a T1 due?
A T1 is required when an operator sells a lease or assigns a lease to another operator. The previous operator has to file a T1 noting that the lease has been sold or assigned to a new operator.
And when are they required to file that T1?
They're required to file it within within 30 days of the transaction.
So it's filed after the transaction takes place, correct?
Can be, yes.
Do you agree that Haas Petroleum has transferred several hundred wells and submitted proper T1s since November of 2020?
I do not review the T1s. Legal staff in Wichita will review the T1s. So I cannot answer that yes or no because I do not deal with the T1s.
Okay. So let's ask it a different way then. If a well had been transferred and a T1 was not approved, would that well still be listed in your RBDMS database as being operated by Haas Petroleum?
Yes.
Okay. And so any wells that were transferred and had proper T1s filed were included in your investigation, even if they had been transferred to another operator, correct? I said your again, I meant staff's. I apologize.
I understand the question. They had not been transferred. They were still under Haas's license.
But those wells were also included in your I'm sorry, I keep doing that. And
Okay.
Staff's investigation, is that correct?
That is correct.
Thank you. I appreciate all of your answers. Those are all the questions that I had for you at this time on Cross.
Thank you, sir.
Thank you.
All right, very well. Let's see if we have commissioner questions. I'll begin with Commissioner Duffy.
Thank you. Good afternoon. How are you, Brian?
I'm well, Commissioner Duffy. Thank you.
Good. I just have maybe a couple of questions. So I do look on page 5 of your testimony at the top, line 3, where you talk about staff locating and documenting 2,232 wells on operators' leases. So you found 824 wells out of compliance, or staff did during their inspection, which equates to around 37% of the wells located on the operator's leases. So there's been a lot of discussion about should they appropriately be on the lease or transferred or abandoned or ownership or whatever, a variety of circumstance. But all of these leases were not acquired at one time, I'm believing. So once an operator purchases a lease, do they usually know well in advance, from your understanding, what they've purchased on that lease, or do they go out and make their own physical inspection before or immediately after they've made a purchase?
I would hope that they do their due diligence and investigate the lease before the purchase. We do have operators all the time call saying that they are looking at purchasing different leases, and is curious if wells are in compliance or if there's any wells that are past due with MITs. And, we try to help let them know if there's anything that's possibly could be a problem if we know about the problem.
Okay. And we all know that District 3 has the largest number of wells in the state and the largest number of abandoned wells. I mean, if we're going to find an abandoned well, it's usually in one of the counties in District 3. So were you surprised about the percentage, 37%, being out of compliance for an operator, based on the fact that you've worked for the commission now since 2004, and you know a lot about the geography, you know a lot about the operators, you know a lot about the production in the area?
30%, 37% is a high number. Yes, I was surprised that there was that many compliance issues on their leases.
Had you ever worked the Haas leases before? And over the years, I guess, if I remember correctly, we're talking about 2005 when kind of Mark took the reins. I know it had been in his family for a couple of generations, but were you familiar with their operations?
Not 100%, no. I worked mainly, I've held different positions with the KCC out of the District 3 office. And I did have, for a short time frame, have part of Woodson County and Allen County. The leases in Allen County that I'm aware of Haas ownership of, they did not have them as long as the leases in Woodson County. Majority of the leases in Woodson County was west of 75 Highway, which we used to split that county. When I worked that county, I worked the east half. So the majority of the wells, I guess to answer that question, even when I was in the field, I did not have a lot of Haas leases. Now I've worked several counties within the district, and for a short time frame, I did have wells in Franklin and Miami County, the leases up there. So I am kind of familiar with the leases, but not, it wasn't like I was on them every day.
Okay. So when an operator purchases a lease and they go out and And like you said, hopefully they do an inspection before, a physical inspection before they purchase the lease. But even if they wait till after, in your opinion, would it make sense for them to develop a plan for that lease over a period of time?
Sure. Yes, I agree.
And that would include whether there were wells that appeared to be abandoned, or new drilling, or injection wells to complete whatever the operator develops a plan of action to maximize the production and the positive financial resources coming from that purchase.
Yes.
Thank you. I appreciate your comments.
Thank you, ma'am.
Mr. Chairman.
Thank you, Commissioner Duffy. Commissioner French.
I'm reviewing some of your testimony right now, but I think that I've had everything clarified. I don't believe I have any questions. Thank you, Mr. Dealing.
Thank you, sir.
All right. A couple of questions from me, Ryan. Let's take a look. And John, I don't think it's necessary for you to bring it up. Ryan, do you have available to you Ms. Epps' testimony, her pre-filed testimony that was filed on July 29, 2022?
I believe so. Let me make sure that it's in here. Commissioner King, you said July 29th of 22.
Yes.
Okay. Yes, I do.
Okay. Turn to the back of that testimony, if you would, to what is identified as Exhibit RE-1.
Okay.
And what I believe this is, and I hope I'm in fairness to the operator, I'm portraying this correctly, but I think what this represents is the operator's effort to, and in accordance with different categories of violations, to identify it's a spreadsheet that kind of identifies the totality of the violations and the attribution of those to specific wells. So my question to you is, have you had a chance to review this before?
I have not reviewed it thoroughly. However, staff has noted that not all the wells that we identified are on this exhibit.
I'm not sure I understand what you just said. What do you mean by wells you identified?
When we did all of our lease investigations, we identified in all the wells on the lease boundaries. And all those wells, not all of those wells are on this exhibit.
Oh, okay. Okay. So you really, I'm guessing, if I were to ask you if you thought that this fairly portrays the scope of the violations and the number of violations, what would your answer be? And please answer if you can't answer because you haven't reviewed it in detail. What would your answer be?
I cannot truthfully answer that question at this time, Mr. King.
Okay, thank you. Let's kind of go back to a line of questioning that was directed to you by Mr. Brock. And let me ask you somewhat holistically here. As the compliance officer for District 3, can you tell me basically what you believe to be are the most, what do you believe to be are the most significant or important parameters that need to be utilized in determining operator responsibility for any particular well?
Any well, no matter where it's located, we need to look at is there a possibility of pollution to any use, fresh and usable water? The parameters taken in that, there's a lot of parameters. The completion of the well, what type of completion is done on the well, the date. Not everybody knows the date of every well that's drilled. However, through experience, you can note whether this well is what we consider a newer style well or an older completion type of well. Anytime that you have activity in the oil field, that style of well that's constructed old style, there's a larger chance that that well could cause pollution to fresh and usable water. And I would like for you to repeat that question one more time to make sure that I'm answering all parts of that question.
Well, I think it was a very broad question. I think you're doing an admirable job of trying to answer it. Let me be much more specific. With respect to temporarily abandoned wells or wells that appear to be abandoned, to what extent do you have a checklist, or do you have some kind of guides or rules of thumb that allow you to try to determine who is the operator that should be responsible for any particular well under the purview of KSA 55-179 as revised?
There are things that we look at. I mean, our final tabulation is, we refer to legal for our final answer and determination which direction that we need to go. But we always look at where the well is located on the lease, who is the operator of that lease, is there any injection well, saltwater disposal in the area of these inactive wells. The part that in that 179, I mean, I know we're talking a large portion of wells for this case, but we seem to deny. I haven't heard anything throughout the day that the wells that we found that are not on the inventory that were in production were illegally being used as injection wells, saltwater disposal. We can't tell which one because a lot of records, we don't even have the information for the well. We don't know if it's in the same zone as being used as an EOR or if it's a different zone used, as an SWD. Though, I mean, those wells to me automatically become Haas's responsibility if they're producing or injecting in those wells.
Very well. I appreciate your answer, Ryan. One final question for me. I'm going to ask of you the same question I ask of Mr. Russell, and I'll be asking of Ms. Epps as well. And to me, it's the vexing and complex, probably the most complex issue that is not easily resolved, that is presented by this consolidated docket. And that is a determination of a well count that should properly be attributed to the operator. And that's complicated by a variety of factors. I'm not going to repeat those again. But what I want to ask you is, from your perspective and your opinion currently, if you have it available, what is the operator's total well count? And how does that broken out by producers, injectors, and TAs? If that's available.
I do not have that information available to me at this time.
Okay. Well, that concludes my questions. Turn back to you, Mr. Marsh, redirect.
Thank you, Chair King. Now, Mr. Dooling, I know Keith, Mr. Brock went over KSA 55-179 with you. Do you ever state in your testimony that Haas was responsible for the abandoned wells under KSA 55-179?
No, sir, I do not.
And then moving on to the permitting factors, this may be a little bit outside your wheelhouse because you're not necessarily part of the UIC department. But do you think that the discovery of abandoned well within the 1/4 mile of an injection well changes the factors under which an injection well was permitted?
I think it does.
In what way?
I'm sorry, could you repeat that question again? I apologize.
Certainly, Commissioner Dovey. Keith, Mr. Brock went over the permitting factors briefly, specifically 403 or KAR 82-3-403 subsection A5. And, he talked about how these were the factors considered whenever a well was permitted. My question was, if the discovery of an abandoned, words are hard apparently after lunch. Would the discovery of an abandoned well within the 1/4 mile area of review or within a 1/4 mile of an injection well change the factors under which an injection well was permitted? So say, we didn't know this abandoned well was there beforehand, but through our lease inspections, we discover an abandoned well is now there. Does that change the factors under which an injection well is permitted?
Yes, I believe it does. And just for the last comment there, I realize Mr. Brock, it says that it's permitted for permitting relating to new permits, but if wells are within a 1/4 mile AOR that was not known or presented during when that injection well was permitted, then yes, I believe it opens it up that they should be reviewed now once the abandoned wells, inactive wells are located.
Thank you, Mr. Dilling. In your opinion, is an abandoned well presumed to be an environmental threat?
Yes, it very much likely could be.
And is that based off of a threat to the surface and a threat within the wellbore itself?
That's correct. It could be uphole or downhole.
Now, Mr. Brock also went through, discussing the T1 or wells that were transferred. To your recollection, would these wells have been out of compliance prior to the time Haas transferred these leases?
Yes.
Okay. I think the last question I have is that, in your opinion, is Haas in compliance with all requirements of Chapter 55 of the Kansas statutes annotated and its amendments thereto, all rules and regulations adopted thereunder, and all commission orders and enforcement agreements?
No.
All right, thank you. No further questions.
Thank you.
Chair, you're on mute if you were speaking.
Sorry. Thank you. Appreciate the guide. Mr. Brock, recross, please.
Yes, I do have a few. Thank you. So you had said that you didn't make any determinations as to whether Haas Petroleum was a responsible party under 55-179, correct?
That's correct.
But you would agree that if staff's investigation included wells that Haas Petroleum was not responsible for, staff is alleging violations on those wells that are not Haas's wells.
We would have to go through each well because you're allegedly stating all wells. And I would disagree with all wells because numerous wells were found to be in production and being used as injection and saltwater disposal by Haas. So I am not in agreement with that at all.
Maybe I could rephrase my question. So you're not directly saying that Haas is legally responsible, but you are alleging that Haas is liable for a violation of commission regulations at these specific wells, correct?
Possible violations, correct.
And so if you're alleging that an operator is liable for violations at a well, you must have determined that you thought they were responsible for that well.
Yes.
Okay, thank you. The other question goes into the quarter-mile area of review. And so in the past, I've been involved in a number of dockets that involved injection wells, abandoned wells. Almost always there is evidence about chloride measurements, fluid level measurements, shutting down injection wells to determine whether communication exists, water samples, sometimes tracers put into the wells to track. Did staff do any of that?
As of today, no.
And wouldn't you agree that without doing those things, there's no way to tell whether an injection well is even communicating with an abandoned well?
Correct.
Okay, thank you. You had said just generically that wells that Haas had transferred were out of compliance at the time they were transferred. Are you able to say that about all wells, or are you just making that assumption?
The transfers, as far as I recollect, were not filed prior to our field investigations. So my answer to that question was those wells were out of compliance when we did our field investigations and documented the inventory. So yes, they were out of compliance before Haas filed the T1s, if I have my date straight.
I don't think it's that important of an issue, so I won't ask the three questions to delve into that. But just one more question.
Okay.
As the compliance officer, are you aware of other instances when an operator has a pending docket before the commission and their license comes up for renewal while that docket is pending?
Could you repeat that, please?
Are you aware of other instances when an operator had an active penalty docket pending before the commission and their operator's license came up for renewal while that docket was pending?
Not that I'm aware of. However, I haven't been the compliance officer for a great deal, so I don't know how many years you're trying to speculate back, but I can only try to answer from when I became the compliance officer.
Well, maybe I can just ask the direct question I'm getting at.
Please.
When the commission determines whether or not an operator is in compliance with all rules and regs for the purpose of an operator's license renewal, they typically interpret that to mean that an operator has not been found after being given due process and issued an order that violations actually exist, and those violations not being corrected within the period of time set forth in the order. Would you agree with that based on your experience?
Yes.
Okay, thank you. That was a really long question. I was starting to wonder if I had butchered it too badly for you to understand, but I appreciate it. I don't have any other questions. I do appreciate it.
Thank you, sir.
Thank you.
Thank you, Mr. Brock. Thank you, Mr. Dooling. I believe this concludes your testimony. The commission appreciates your appearing before us this afternoon, and you are virtually excused.
Thank you, Commissioner.
Thank you. This concludes the KCC staff witnesses, and we will now turn to the examination of the operator's witnesses. Mr. Brock, if you would, please call your first witness.
Yes, Mr. Chairman. I feel a little awkward doing this because you offered it earlier and I wasn't I wasn't thinking appropriately, but I would like to call Mrs. Epps first. I was slow to the issue, but you're correct. I think the bulk of the questions usually come first, and that may save some time. So I would like to call Mrs. Epps first.
Very well. Mrs. Epps, if you would, please raise your right hand. You swear that or affirm that the testimony that you're about to give this afternoon will be the truth, the whole truth, and nothing but the truth. So help you God, or under penalty of perjury.
I do.
Thank you. Mr. Brock, direct exam.
Yeah. Ms. Epps, can you please state your name and business address for the record?
Yes, the name is Rhonda Epps. Can you hear me all right there?
We can.
Yes.
Okay, good. Business is Haas Petroleum LLC. Business address is Post Office Box 8396, Prairie Village, Kansas 66208.
Thank you. And by whom are you employed, Ms. Epps?
Haas Petroleum.
And I'm just going to do these as two separate things for ease. Ms. Epps, did you cause to be prepared and filed pre-filed testimony in these consolidated dockets? Two sets, the first being filed on December the 10th, 2021, consisting of 14 pages, and a second set filed on July 29th, 2022, consisting of 23 pages and one exhibit.
Yes, I did.
Do you have any changes or corrections to that testimony?
Yes, there is actually one on the July 29th. On the testimony, page 9, the last word, I think there was a typo there. So the last word said wells, but it should have been ways.
Thank you.
Yeah.
Ms. Epps, if I asked you the same questions today, now that you're under oath, as are contained in these two sets of pre-filed testimony, would your answers be the same?
Yes.
We would move for the admission of the pre-filed testimony of Rhonda Epps, filed December 10th, 2021, consisting of 14 pages, and a separate set of pre-filed testimony on July 29th, 2022, consisting of 23 pages and one exhibit.
No objection.
Mr. Marsh? Any
No
objection?
objection.
Without objection, they're admitted.
Thank you. Mrs. Epps, are you personally familiar with the pre-filed testimony that was submitted by Mark Haas on December 10th, 2021, consisting of 23 pages and one exhibit?
I am familiar.
Okay. Mrs. Epps, and what is your title with Haas Petroleum?
Currently, it's the Chief Executive Officer.
And in that role, have you had the opportunity to review company records, visit with company employees, and otherwise review information in order to gain personal knowledge of the information contained in the pre-filed testimony of Mark Haas that we just described?
I have.
Okay. And are you able to today to verify that everything contained in that testimony is true and correct?
I can, yes.
And if I asked you the questions contained in that pre-filed testimony previously submitted by Mark Haas, would your answers to those questions be the same today that you're under oath?
Yes.
I believe I asked you if you could swear or affirm to the truth or accuracy of that testimony. Did I ask you that?
I think you did.
Okay, I wrote it down twice in my notes to make sure I got it, I guess.
If you didn't, you've asked twice, so.
There we go.
Okay.
I would move for the admission of the pre-filed direct testimony previously submitted by Mark Haas on December the 10th, 2021, consisting of 23 pages and one exhibit.
Is there any objection?
I mean, staff would renew its objection from earlier that was overruled and would ask that the commission give Mr. Haas's testimony the weight it deserves.
Okay. I'm going to take that as an objection. I will overrule the objection and we will note your concerns. And it's admitted.
Ms. Epps, there's one thing that that occurred after this pre-filed testimony was submitted. If it's okay, I'm going to share my screen real quick and we won't rehash what you've already written, but there's one thing that occurred after you had, oh, I'm sorry, I accidentally pushed the leave.
You're still here.
Yeah, went to push the share button and clicked leave. It almost, okay, this is a letter. You probably saw it earlier. I was discussing it with Commission staff witness Troy Russell. It's been marked TR Cross number 1. It's a letter given to Haas Petroleum. Are you familiar with that letter?
I am.
And can you tell me generally what it requires?
On this particular, on this letter, you're asking me what this is actually requiring us to do?
Correct.
Is that what your question is?
Yes, yes, I'm sorry.
Well, all of this is dealing with the permitting factors regarding our injection wells. It's also talking about the abandoned wells that are within a quarter-mile section of our current injection wells that we have on record.
And so is this requiring you within 30 days to shut down 116 of your injection wells?
It is asking us to do that, yes.
Are you aware of any other operators who have received a similar notice to this?
I am not. The industry itself, especially here in this part of Kansas, is a very close-knit community. So a lot of the operators talk quite a bit amongst each other. I have had several conversations with other operators. And
Objection, hearsay.
I am not aware of anyone else receiving such a document.
Do you want me to respond, or there's not really?
I overrule the objection.
Oh, okay, I'm sorry. I didn't hear it come through on the audio. I apologize. Okay. On or about around when your pre-filed testimony was filed, was Haas Petroleum also discontinued access to the COLAR electronic filing system?
Yes. We have access to be able to visually see previous records and only can see what has been done up to this point as far as what's been entered through the COLAR system. But anything that we have submitted paper-wise, which is what we now have to do since we don't have the access to be able to submit electronically, those documents you cannot see. So it does make it a little bit difficult to be able to ascertain where we actually are, the statuses of things.
Thank you. Just one more question, and then we'll cross-examination. Earlier, you were present for the testimony of Troy Russell, correct?
Yes.
And did you hear the statement about Haas Petroleum wanting to be rewarded for doing what it was already obligated to do?
I did.
Is that how Haas Petroleum feels? Is that what they're asking the commission to do?
Certainly not. I think Haas Petroleum has a fiduciary responsibility to operate in both ethically and responsible manner. That's what any operator should be doing. So it's certainly not anything that would deserve to be rewarded. That is something that we should do.
Thank you. I would tender the witness for cross-examination.
Thank you. Mr. Marsh, cross-examination.
Thank you, Chair King. Good afternoon, Ms. Epps.
Good afternoon.
So let's just jump right on into it, shall we?
Let's do.
So on page 21 of the testimony you filed on July 29th, 2022, you state that you believe Haas complies with all requirements of Chapter 55 of the Kansas statutes annotated and amendments thereto, all rules and regulations adopted thereunder, and all commission orders and enforcement agreements, correct?
I did.
Okay, so let's start with the commission orders. There are 4 penalty dockets that are part of these consolidated dockets, correct?
That is correct.
And that's 21 CONS 3193 CPEN, 21 CONS 3201 CPEN, 22 CONS 3031 CPEN, and 22 CONS 3034 CPEN, correct?
That is correct.
In docket 21 3193 CPEN, Haas was assessed penalties for 4 violations of KAR 823-407 because the wells failed mechanical integrity tests, correct?
That is correct.
None of those 4 wells were brought into compliance by the deadline in their respective notice of violation letter, correct?
The 4 wells that we're talking about, please ask me that question one more time so I can make sure I understand what you're asking.
I was asking that none of the 4 wells that are subject to that docket were brought into compliance by the deadline in their respective notice of violation letters, correct?
The wells were brought into compliance after the deadline, yes.
Okay. And as you just said, Haas has since repaired or successfully retested and repaired each of those 4 wells.
That is correct.
And docket 21 CONS 3201 CPEN, Haas was assessed penalties for 18 violations of KAR 823-407 because each of those wells failed mechanical integrity tests, correct?
That is correct.
And none of those wells were brought into compliance by the deadline in their respective notice of violation letters, correct?
Yes, there were 20 wells that were identified in that docket. All but 8 were brought into compliance after the date.
So Haas did not bring the wells into compliance by the deadline provided by staff.
Yes, we did miss the deadline.
And since has Haas plugged or repaired and successfully retested each of those 18 wells?
Since we have successfully plugged, repaired, or T1'd all but 8 of those identified wells, 2 of which are probably in process as we talk.
Well, I wasn't asking necessarily about T1s. I'm just talking about wells that have been plugged or successfully repaired and retested. And there's only 7 of those wells, correct?
Let me count those, please. Yes, there would be 7 that were plugged and a few that are in process.
Okay, thank you. In docket 22-3031, Haas was assessed penalties for 10 violations of 823-407 because each of those wells failed mechanical integrity tests, correct?
That is correct.
And as we've kind of, or as I've asked before, none of those wells were brought into compliance by the deadline provided by staff in their notice of violation letter, correct?
Yes, it seems that deadlines are an issue here. Yes, all but 3 of those wells were brought into compliance, however, after the deadline.
Whenever you say brought into compliance, are you talking about plugged and successfully retested?
That is correct.
Because my notes have 6 wells that are still out of compliance with the commission's rules and regulations. So what 3?
And I'm sure you probably do, being that you probably received most of your information from COLAR. Again, that information is not updated due to us not having access to that. So I'm sure it's a paperwork issue that hasn't quite caught up.
But still, Haas is able to file paper forms, correct?
That is correct.
Lastly, in docket 22 CONS 3034 CPE, and Haas was assessed penalties for 77 violations of KAR 82-3-111 because each of those wells have been inactive for a longer period of time than allowed by regulation, correct?
That is correct.
And none of those wells were brought into compliance by the deadline in their notice of violation letter, correct?
I would say that that is correct if we're going off of a deadline, yes.
Since has Haas plugged, obtained temporary abandonment status, or returned each of those 77 wells to service?
We have a great deal that we actually have done that with, but again, those are all been filed through paperwork. So that information hasn't actually caught up with what you probably have in your system.
But there are still wells out of compliance with that penalty order.
Let me double check those numbers for you. Yes, there are still some that remain outstanding, and I'm sorry, I do not have that exact number.
Okay, the number I had was 61, but as you say, maybe there were still some paper filings that need to come in.
Yes.
Okay, now let's start to take a look at your testimony. And I want to start with the testimony that you filed on December 10th, 2021.
Okay.
On page 5 of that testimony, I'm looking specifically at lines 68 through 73. You state that Haas hired David Griffin to develop more complete well records and information and auditing records for all of Haas Petroleum's lease or wells for regulatory filings, correct?
That is correct. He's actually worked with us for quite some time as a geologist when we were doing quite a bit of drilling. So we still have access to his services, and we were able to give him some additional time out in the field to help us conclude these records that needed to be addressed.
And when was he officially hired by Haas?
I do not have the date. Again, he's worked with us for a really long time. So most of his work is all contract. So he's not necessarily an employee. He's a contract laborer. So when we send him out, whether it's geology work or field work in this case, we send him out on those jobs, and then he in turn bills us for the time that he spent.
So are you saying that he's not an employee, he's just a contractor?
He's a contractor. He is a contractor, yes.
Okay. Are you familiar with Haas Petroleum's website?
I am.
Okay.
I am. Probably needs some updating, but I am.
So I've pulled up, hopefully you can see it. It's the Haas Petroleum specific page of the website. Is that correct? Or can you see that?
Yes, I can. Although I'm going to
Okay.
put my glasses on because that's tiny. But yes, I can.
I can try to zoom in a little bit.
Yeah,
So
perfect.
it does discuss, so it says Haas Petroleum has hired David Griffin, University of Kansas graduate, as head geologist. His primary job is the evaluation of new acquisitions, mapping, and drilling sites in field. Is that correct?
That is what it says. I should also note that this website was actually done before me, so I cannot necessarily comment on the accuracy of the information that's here.
Okay, but it doesn't mention anything about regulatory work, does it?
No, it is just mentioning that his primary job is the evaluation of new acquisitions, mapping, and drilling sites. That's what I'm reading.
Okay. On page 8 of your December 21 testimony, you state that Haas is doing all it can to retain the employees it has, correct?
That is correct.
And that includes pumpers?
Yes. That would include anyone that is currently employed with us.
And it also include the employee who destroyed evidence requested by the KCC as part of its investigation, correct?
Are you asking me if that employee is still employed?
Yes, is Randy Bishop still employed by Haas Petroleum?
Randy Bishop is still employed with Haas Petroleum.
So his actions were not strong enough to result in a termination?
If you're asking me whether his actions were horrendous and egregious, I would say absolutely. Yes. What I can also tell you is there are ongoing investigation, also matters that affect policies with HR. There will probably no doubt be some additional changes coming down the pike. We just have to make sure that we are moving correctly so that we do not open ourselves to further liability.
Okay, thank you. On page 9 of your December 21 testimony, you state that Haas was in a strong financial position until 2015, correct?
I would say so. This is from my my little deep dive into things. Yes, I would say so.
Now, in Mark's testimony, it seems that he felt that the financial burden started in 2013 when he was divorced, correct?
That is what he says, yes.
How much of Haas's finances went towards paying off or paying elements of or results of that divorce?
I do not have any knowledge of that.
Is that because it was before you were a member of Haas Petroleum?
Again, yes. I would say that.
So there's nothing in the company records anywhere that would show that or indicate that?
From what I understand, the divorce process was actually affecting Mark Haas individually. So I don't know that there would be a great deal of records available, at least for me to look at this position, to compare them with whether or not they were coming out of, company funds or if they were affecting Mark individually. But I do know that the settlement was done individually and not necessarily Haas Petroleum.
Well, and his testimony claims it affected both, correct?
That is what he claimed, yes.
But you weren't part of Haas at that point in time, right?
I was not.
Going off of that strong financial position, or like when times that finances began to become tough, that didn't stop Haas from expanding its operations and drilling more wells after that period of time, correct?
Again, I was not part of the company at that time, so I don't know that I could actually answer that with any real factual base.
But you have incorporated Mark's testimony into your own, correct?
I understand that. I understand that, yes.
Okay, turning back to Haas's website, there is a company news portion of the website, correct?
I believe so.
So I'm going to share that. This section talks about 2014 to 2017 developments. Did I read that correctly?
Yes.
Now, I won't make you go through counting all the numbers and adding everything up, but does it seem reasonable to believe that Haas states that it acquired 7 properties and purchased several leases with 941 wells on those properties and leases, and drilled an additional 177 wells during that 2014 to 2017 time period?
Well, let's read this here for context. Well, let's just look at the first line. The Nicholtown East Massey, 28 wells were drilled, 12 drilled on the McCult, 24 additional drilled on the Arnold, 6 on the Edwards, and 5 additional were drilled. It does tell me that they were drilling. Was that your question?
Well, and I was more just getting to the total numbers of,
Okay.
during this time of tough financial times for Haas, Haas was still drilling wells and acquiring leases, correct?
I would say during 2014 and 2017, they were certainly developing more leases. I would note that the Nicholtown project had investors, and Haas Petroleum and the Black Oats as well. Those are under the direction of investors. So Haas Petroleum just acts as the operator. Doesn't necessarily mean he owns the land, and certainly doesn't mean that he actually receives all of the income that's produced from those leases.
Okay, thank you. All right, now I want to flip over to your testimony that you filed in July of 2022. From the time that you filed your December testimony to the time you filed your July testimony, you became president and CEO of Haas Petroleum, correct?
That is correct.
And you replaced Mark Haas, is that right?
That is correct.
And when did you replace him?
That was actually of this year. So I think my testimony actually stated in May of this year. However, it feels like I was acting way before then, but officially, I would say the recommendation was actually made in May of 22.
And when you say recommendation, are you talking about the recommendation of the Haas's advisory board?
That's correct. There was lots of conversation with the advisory board that actually came at the suggestion of myself. Those conversations with those people, as well as having conversations with Mark himself.
And was Mark terminated, or did he leave the company on his own?
Well, I think that's kind of a twofold question. He was asked to step away from that position. But I think he also knew that he needed to step away from that position if we expected to be able to keep things moving forward, or at least make the necessary changes that would be critical as we continue to operate. So while I think he understood that, we certainly did not shy away from asking him to relinquish that position.
And he relinquished that position in May of 2022 as well, correct?
He did.
Who all is a member of Haas's advisory board?
We have a few. Would you like for me to name them individually?
Yes, please.
Okay. Let me get to that sheet so that I do not mess up their names. One of them is Dawn Rattan. Dawn is actually a chemist by trade, but she is also sits on the board of directors to the board of trustee for Johnson County Community College. We also have Laura Yates. Laura Yates is a manager of engineering department at Garmin here in Overland Park, Kansas. And then we have John, and I don't know why I'm just drawing a blank on John's last name right now. Let me see if I can find that for you. John Frick. So sorry. John's watching this. I apologize about forgetting what your last name is. John Frick is an independent business owner of pharmacy here in Kansas City.
And when was the advisory board formed?
We formed that, actually started forming that in March of 22. That was probably one of the very first things that I suggested that we do, just to get another set of eyes and ears on the business. For far too long, we were just looking so inwardly. I felt it would be advantageous for us to just have another set of eyes just to help us make some of the changes that we needed to make. Also, just to be able to offer their opinions and their suggestions. So that started in March, and I think we probably completed it around May, if I'm not 100% off with that.
Okay, thank you. In your testimony, and I'm looking at page 4, lines 2 through 5, you state that as a result of an advisory board's recommendation, every Haas Petroleum employee who was in a position of senior leadership in November 2020 was removed. Is that correct?
That is correct.
And that senior leadership was Mark Haas?
Yes, Mark Haas at the time was president and CEO. John Haas was owner, vice president. And then Morgan Haas was the HR and office manager. And I believe Megan Haas was just a admin support. However, they all seem to have very critical roles with regard to the company.
And that was based off the recommendation of the advisory board?
Some of it. However, part of the their removal actually came earlier before the advisory board actually came on. So I do believe everyone, with the exception of perhaps Mark and John, were still actively working in the company.
Now, this is a discovery request that was made that you responded to. And it talks about the employees that were removed since November of 2020. I'm looking at number 11, correct?
Yes.
So really, it says that Morgan Haas was removed or left in August of 21, that Megan Haas left in August of 2020, and that John Haas left in November of 21. That was all before the advisory board would have been formed, correct?
Yes, according to these dates, that is correct.
Really, Mark Haas was the only one that was removed as a result of the recommendation of Haas's advisory board.
That would probably be fair. What I should also, however, recommend, what I would like to know is that although we have November of 21, that John was actually, up until November of 2021, that John was actually still working. He still did have some, he did have some, I would say probably input into what was going on with the company. So I apologize if I wasn't real clear on that. But I would say that it would be fair enough to say that honestly, out of this group, Mark was the remaining person that was left that needed to move from his position. So yes, I would say you're correct.
And why did it take a year and a half after these egregious violations occurred to remove Mark from the company?
Well, I didn't come on into the role, obviously, until some time after these egregious acts. So at the time, honestly, the only person that was still working and running and making the decisions would be Mark Haas. That's why it took so long. I came on initially as a director of operations, and my job was specifically, just dealing with operational things. It wasn't until I came on as the chief executive officer that I could really get in, hands untied, and make the decisions that needed to be made.
Thank you for that. Sorry, I'm trying to find what was your role again before becoming CEO?
I was director of operations.
Okay, thank you. Is that, where does director of operations fit into the hierarchy of the company? Is that like a second in command type of position, or?
It was not. It truly was just I was a director of the actual activity of operations, which means that I came on as a role to try and move the company more forward, try to make the company more efficient, and basically kind of clean things up. And that was both probably the biggest scope of my work was actually looking at the front office part of the business, looking at how we're doing paperwork, looking at how money is being spent, how vendors are being managed, that type of role.
So really you weren't in a decision-making position until becoming CEO in May, correct?
That is correct.
Now, one thing that seems to previously been the case was Mark was the sole owner of the company of Haas Petroleum. Is that correct?
I believe so.
Was it correct?
Yeah, I believe so. There may have been some ownership with John Haas. I am not absolutely certain of that.
What's the ownership makeup of the company today?
The ownership of the company today is I'm actually at 51% owner, and 49% actually is over with Mark Haas.
So Mark still has a vested interest in Haas Petroleum, correct?
I would agree with that. Yes, he does have a vested interest. All the more reason for him to be a whole lot more accountable than what has happened in the past.
How much did you pay for that 51% interest?
I have a small ownership in a lease that I actually invested in. So if you're asking me, but that did not actually curtail into me becoming the chief executive officer. So I did invest on a couple of leases along with probably 3 or 4 other investors that he has. But that was before even, that was actually before we actually, sorry, I'm getting a little tongue tied here. That was actually before my position as chief executive officer.
So did you not pay anything then?
I did not pay anything.
So is that just a mutual decision between you and Mark to give you 51% of the company, or how did that work?
That was a mutual decision, but a lot of that is trying to figure out where you might be asking, but yes, that was a mutual decision.
And when was the last time that you saw Mark?
I saw him this morning, actually.
Okay. And when was the last time that you discussed matters concerning Haas Petroleum with Mark?
Probably discussed this hearing with him this morning.
Okay. And what is your relationship with Mark Haas?
And I figured that's maybe where you were going with all of this. I was kind of thinking, why don't you just ask that question? I'm actually would be considered Mark's partner in life as well as his wife. So however you would like to.
Have y'all been officially married, or do you just kind of live together?
Do I need to answer that? I'm trying to see where you're actually going with this and what difference is that relevant?
I don't believe it's relevant. Move on to the next question.
Yes, sir. As president and CEO of Haas Petroleum, how important do you think it is to make sure Haas's information is current and up to date, especially with the commission?
That's critical. It's absolutely critical that information is up to date and correct.
Okay. I'm going to share my screen. Maybe make this a little bit clearer. Can you see the picture? This is a licensing record for Haas Petroleum.
Okay.
And does it say Haas Petroleum LLC under company name?
It does.
And under retention, does it still say Mark Haas?
It does.
So you or anyone from Haas has not updated this contact information at this point, correct?
It does appear that way. I'm a little jelly about that. Can you tell me where are you pulling this document from?
This is from the commission's internal RBDMS risk-based data management system. And this is part of the licensing page.
Right. So this license looks like it was issued in 2005, filed through COLAR. So I would imagine this information is not correct, being that we still have no access to electronically file anything through COLAR.
Well, and you have not contacted the licensing department to update Haas's license information?
That is actually out of my scope of work that I actually do. I do not know who's responsible for actually filing this paperwork. But again, this looks like it was initially, I guess the initial was what, in 2005, and the renewal date was 2020. So
and your name's not associated anywhere on this license?
It is not. However, in 2020, I probably would not have had my name on there to begin with.
Are you familiar with the commission's rules and regulations?
There's a lot of rules and regulations. So can you be more specific?
I'm specifically looking at 82.3.120, which regards operator licensing.
Okay.
subsection L, or this is a copy of 82-3-120, correct? Or at least appears to be.
Yes,
says
phase 2-3-120 operator licensing.
Okay. And subsection L of that regulation states that each operator shall notify the Conservation Division in writing within 30 days of any change in information supplied in conjunction with the license application. Did that read that correctly?
Yes, that's what I'm reading as well.
And Haas to this point has not updated their licensing information with the commission. Is that correct?
That I do not know. The license that was actually sent or was applied for hasn't been approved. So I can't answer that.
But to your knowledge, it hasn't been.
Since we don't have an actual license, I would say, how can it actually be updated if we have no license?
So once again, to your knowledge,
Hopefully I'm understanding that right.
well, to your knowledge, no one from Haas Petroleum has reached out to staff to put you onto Haas's license, correct?
I do know that I am not on the license. I do know that we submitted a license renewal at the time that it was due. But again, because that license has not been renewed, I can't honestly tell you what the changes are on that form.
Okay. Now, you mentioned earlier about having a Kohler operator management or Kohler account for Haas Petroleum, correct?
Mm-hmm.
And Haas was no longer able to access that Kohler account after July 30th, 2022, correct?
Well, actually, I said we can access it. We can certainly access it, and it does provide information there. What we can't do is be able to submit forms through Kohler, which in turn gives us almost immediate updating of numbers and information. So yes, we are certainly open to still being able to access it for views, but we are not able to submit paperwork. And I don't think any of those other names on there, Wendish, who does a lot of our MITs, and Dave Griffin, who oftentimes comes to this site as well. We all have access to be able to see it. We just don't have access to keep it updated so that the statuses are a little bit more current for both the operator and the KCC.
And as you kind of pointed out, there is a list of users for Haas Petroleum's Kohler group. Your
Yes.
name is not one of those users, correct?
That is correct.
But Mark Haas's and Morgan Haas are listed as users for that.
That is
Kohler
correct.
account, correct?
Yes.
This is a business entity or a record pulled from the Kansas Secretary of State that lists the resident agent for Haas Petroleum. On that form, it says that the resident agent is Mark Haas. Is that correct?
That is correct.
And if I look at the most recent annual report, you're not listed as part of the license at that point, correct?
That is correct. That report was actually executed on April 4th of 22. I did not have this position until May of 22, a month later.
All right. But you have not updated that information with the Kansas Secretary of State?
Not as of yet. These reports, as you know, they're annual. So that's going to be updated next April.
Okay, thank you. Switching back to Haas's website. Under the Haas Petroleum page, there is no mention of you becoming or being CEO of Haas Petroleum. Is that correct?
That is correct.
And under company news, there is no mention of you replacing Mark as CEO of Haas Petroleum. Is that correct?
That is correct. Like I said, this is obviously indicative of just not having it updated here. We have been inundated with many, much more priority items than what's actually being issued on our website. The people that do business with us, and for the most part need to know exactly how we're running business. Usually, and in this case, the website is a way to sometimes garner business. In other words, also be able to give the general public, other operators, the breakdown of our company. But we can certainly tell you that the people that we do business with on the regular know exactly how our company is set up. So, but we should update this.
And then lastly, on the contact page, you're not listed as part of the contact page for the website.
That is correct. And in fact, see a couple of other little typos. It doesn't look like the address is correct. This website is actually operated by an outside entity. And again, they rely on us to be able to submit to them accurate information as things happen. This just hasn't been a priority for us. As you know, and part of the reason why we're here is we have much bigger fish to fry than worried about what our actual website looks like at this point.
But as you stated earlier, these changes were made in May of 2022, correct? So roughly 5 months ago.
The changes internally were made, yes. Those changes did not, obviously aren't reflected on our website, but again, it's just not a priority for us at this point.
Okay, thank you.
You're welcome.
Now, I want to get back to your testimony, specifically testimony filed in July of 2022.
Okay.
On page 3 of that testimony, you state that Haas has addressed 142 wells by plugging 25 wells, transferring 63 wells, filing TA status for 26 wells, and returning 28 wells to service since December 2021, correct?
I did.
So I guess one question I have is, are those 25 plugged wells in addition to the 48 wells Ms. Barber claims were plugged as of December 2021 in her testimony?
I believe, so you're asking me, are the 28 wells associated with the 45, are they included in that number? Is that what you're saying? Is that what you're asking me?
Yeah, I was asking if the 25 wells mentioned in your testimony are included or in addition to the 48 wells referenced in Ms. Barber's testimony.
I would say that they are actually included in the 48 wells.
Okay. Now, after, you say that Haas has addressed 142 wells since these matters began, but as we discussed earlier, there's still wells that are part of these penalty dockets that are out of compliance, correct?
Yeah, of course. A lot of those wells, there just weren't the wells that have been addressed. There's a number of wells that have been addressed and addressed for a number of reasons. Some of them plugged, some of them TA'd, some of them repaired. So yes.
So is that just because the wells at issue in these penalty dockets aren't a priority to Haas, or what's the reason behind
they're very much,
them?
yeah, they're very much a priority. What we try to do, obviously, there's a large, if we look at the scope of work that needs to be done, it's large. And it's oftentimes very difficult to get third-party companies out that help us do a lot of this work. As you know, the industry has changed dramatically over the last 5 to 10 years. There's limited amount of resources and a limited amount of contractors available to do a lot of the work. So oftentimes, if we can get them out there working on a priority well, and we have a nearby well that also needs to be addressed, and we try to do it at that time, just because it seems to work a little bit better oftentimes for that contractor as well. So we try to get them out there to do as much as we can. Obviously, starting off with that priority well, but if there are wells within the area that need to be addressed while they've got all their equipment out there, then we try to get them on that as well.
Thank you.
You're welcome.
Now, notice you mentioned filing TA status for 26 wells, but that does not necessarily mean that those wells have been approved for temporary abandonment status, correct?
I would say so. I mean, we file them and then we wait for you to approve them.
And if they get denied, then the wells would still be out of compliance, correct?
They would be out of compliance. If they're denied, then that still means we need to do something with them. So, yes.
In your testimony on page 5, lines 18 through 21, you state that the overarching goal is to achieve compliance with the commission's rules and regulations and to carry out the statutory directives of the commission, correct?
That is correct.
However, since, these dockets and compliance issues were discovered, Haas has also been penalized in 4 separate dockets outside of these consolidated dockets at issue today, correct?
I do believe we've had additional penalties, yes. A lot of those penalties, sorry.
I was just sorry, I keep talking over you. My apologies.
That's all right. A lot of those additional penalties are also wells that are just no longer in our inventory, although they show up in your inventory because those T1s haven't actually been transferred in your record keeping.
Okay. Do you happen to know those penalty dockets off the top of your head?
I do not. I do not.
Could they be 22 CONS 3435 CPEN, 22 CONS 3460 CPEN, 22 CONS 3469 CPEN, and 23 CONS 3061 CPEN?
I suppose they could be.
I can pull them up if you like.
I did not have those documents here. I thought that the hearing was just going to pertain to the 4 documents that were actually listed.
I would object to this line of questioning on the basis of relevance. I mean, the operator is entitled to due process as it relates to those violations, and frankly, we have legal arguments in those dockets, and if we're allowed to continue the license, I have confidence that the commission will find those violations don't actually exist. So I have objections on the basis of relevance until those violations have actually been proven.
I'd like the commission to take administrative notice of those 4 dockets since they have been penalty orders issued by the commission.
Right.
I think that's probably appropriate. You could take administrative notice that they're pending.
That's what we will do. We'll take administrative notice of the 4 dockets.
Okay, thank you.
Thank you.
Ms. Epps, what are the commission's statutory objectives or statutory directives?
What the commission is asking of us as operators?
No, what are the commission's statutory directives? So what is the commission's responsibility regarding conservation rules in the state of Kansas?
Well, I don't have the commission's directives here in front of me to read it to you verbatim. But obviously the commission role is to ensure that operators are operating within the scope of how they should be operating, and be able to make sure that we're doing that so that water, aquifers, that type of thing are not contaminated by what we do in producing oil.
Okay, I was just curious because your testimony talks about that Haas is trying to achieve compliance with the commission's rules and regulations to carry out the statutory directives. I just wanted to make sure you knew what those statutory directives were.
Yeah. I gave you the, what would I call that? The general terms of what the commission set out to do. And hopefully I got pretty close to what that is.
Well, would they be to protect fresh and usable water,
Absolutely.
protect correlative rights,
Absolutely.
and prevent waste?
Absolutely.
How is fresh and usable water protected by allowing an injection well that has failed a mechanical integrity test to remain out of compliance for almost 2 years when the commission's regulations allow a maximum of 90 days?
If you don't mind, would you ask the first part of that question again?
Sure. How is fresh and usable water protected by allowing an injection well that has failed a mechanical integrity test to remain out of compliance for almost 2 years when the commission's regulations allow a maximum of 90 days of noncompliance?
Well, I think I would best answer that question is obviously the rules are in place to help protect, right? We don't oftentimes know if a failed MIT is actually going to equate to some type of contamination, but obviously those rules are set forth to help protect. So I would say that, it's clear that we need to do MITs. They should not fail. If they do fail, they should be repaired. I don't think any of us is, or certainly not from this standpoint. I don't believe that anyone here at Haas Petroleum thinks otherwise. And certainly they thought otherwise prior to my coming on board. We've certainly changed that thought process. We have, again, I think I mentioned it earlier, we have a fiduciary responsibility, not only to the landowners, to the commission, to the state of Kansas, to the people of Kansas, to be able to operate ethically, responsibly. And part of that is ensuring that our wells are passing their mechanical integrity test. That is something that we have failed to do in the past, and that is something that we're absolutely committed to doing moving forward.
One of the things you said that was you don't know if a failed mechanical integrity test is necessarily a threat to fresh and usable water. Is that what, did I hear that correctly?
It is, because I wouldn't know that. I'm certainly not a scientist, a geologist. Just like anything else, I think we put rules in place to help mitigate the possibilities of those. So our wells are, we have, the constructions are different. There's just probably a lot of things that go into effect for me to be able to say, is this well actually contaminating fresh water? And I think that probably goes way beyond your job, my job. However, the commission has set forth guidelines and rules in order to protect that. And I certainly respect that. And I'm certainly committed to make sure that we respect that rule and apply that rule.
Well, and wouldn't you say that given the short timeline to return a well to compliance, that the commission sees a failed mechanical integrity test as a threat to fresh and usable water?
The commission may see, I can't necessarily answer for the commission, but I would not be surprised if they said that it was certainly a threat. I wouldn't be surprised if that's what their answer was to that question.
Okay. How are correlative rights protected when there are leaks in a well and there's no way to determine where the produced water and oil within the well are going?
Well, I think if you have produced water and oil and you don't know where it's going, it's not protected. So again, those type of things have got to be repaired. They have to be repaired. You won't find me saying otherwise. So again, goes back to our responsibility to the state, the community, everything, as well as to other operators.
Would you say that Haas has lived up to that responsibility at this point?
I would say there's a lot of work to do. I would say that communication probably has not been a very strong sticking point here, whether it's just internally in the office or even out in the field. And that's probably one of the biggest things that I identified as coming into this role, is how important it is for that communication to happen. That is something that we are actively working on. We cannot continue to operate without it.
And how is waste prevented when there is a leak in a well that could potentially flood out a producing zone?
How is waste prevented? Well, again, if there's any type of leak, I mean, I don't think any of us would argue that if a well does not pass the mechanical integrity test, then we need to do everything that we can to ensure that it does. So whether that's plugging it or whether that's repairing it. And again, those are things that we're actively working on. Those are things that we're committed to do. And part of the reasons of why we're hoping to at least partner with the staffing of the Kansas Corporation Commission to get these things done, whether that's by entering into some type of compliance agreement, or whether it's just even by using their expertise as well, and helping prioritize some of these things so that we can get this done. So something that I actively really want to do. I want to be able to partnership with the Kansas Corporation Commission and get these things done. I do not understand some of the past behaviors. What I can tell you that it is unacceptable, and we're committed to getting it done.
Okay, starting at the bottom of page 10 of your testimony, you begin to go into more specific detail of the violations outlined in staff's testimony, correct?
I believe you're correct. I'm just moving along to that page, but yeah, let's go with this.
Okay. Now I want to start with, or kind of cover some of the big ticket or items, I guess you could say, or issues that seem to be more contentious, but specifically regarding violations of KAR 82-3-111. Haas acknowledges responsibility for 392 of the wells that staff found to be out of compliance, correct?
That's what it says, yes.
And specifically regarding the violations of KAR 82-3-407, Haas acknowledges responsibility for 27 of the wells that staff found to be out of compliance, correct?
Correct.
And if I understood your testimony correctly, that was 18 wells that are at issue in these consolidated dockets and 9 wells that Haas did not have injection authorization for, correct?
Let me look at that. Bear with me. A lot of paper here. Yes, that's correct.
Continuing on to the violations of 82-3-120, you say that Haas does not claim that any violations occurred, correct?
I'm sorry, where are you seeing that?
82-3-120, it's page 14, lines 10 through 14 of your testimony that was filed on July 29th-ish of 2022.
I'm gonna stick to one testimony here so I can quit flipping through all this paperwork. Bear with me. And repeat your page that you're on once more, please.
Page 14, lines 10 through 14.
Okay. Yes, this is stating that this is actually stating that there were no violations since 2005.
However, the list of wells there were wells that Haas was producing from or injecting into, and they were wells that were not on Haas's license or part of Haas's well inventory at that point in time, correct?
I think it depends on whose well inventory you're looking at. That's probably also been a very big eye opener and a struggle to actually kind of understand this well inventory. We're required to certify that well inventory every year, in which our compliance manager, Julie, does that. And so we're looking at a list that we show as within our wells. But then it seems like sometimes the list that you're looking at is different from the list that we're admitting to. So there is quite a bit of discrepancy in that. I for one would like to get a very accurate count of the wells and let them match up with what you guys have, because your list is a little bit different than ours.
Well, I guess maybe to help things out a little bit, I'll pull up Ryan Dooling's testimony. Is that what you can see?
I can.
Okay. And it says KAR 82-3-120.
It does.
At the bottom of page 7. And at the top of page 8, it says the list contains many wells from which operator was producing without being licensed to operate those specific wells. Did I read that correctly?
You did read that correctly.
So really, staff's position regarding violations of that regulation aren't that Haas wasn't licensed, but that Haas did not have those specific wells under its license, correct?
That's correct. And that would go right back to, again, the list that we have on our well inventory. The list that you have in your records, they don't coincide. So the other part of that I should also mention is, in the past, which I can tell you is not the way I necessarily would do business. But in the past, when these operators would buy leases from one another, didn't seem like many of them, and I can certainly tell you that Haas Petroleum didn't often do their due diligence to actually go out and survey that lease and understand exactly what they were getting into. That is something that we definitely 110% require now. But that is apparently, from what I understand, that is something it's kind of commonplace for these operators to do that. So as these leases changed hands, someone sells a lease and says, hey, it's got 20 wells on it. Nobody goes to check, beyond me, of why that would ever happen. And they find out they have 25 or even less sometimes. So oftentimes these leases, again, were sold back and forth, almost like horses, between operators, and they oftentimes took the other operator's word for, hey, this is our lease, this is what we use for injection. There's no wonder that the numbers aren't accurate, whether certainly that they aren't accurate when they're lining up with what you have and what we have. Something that I'm also committed to correcting. I think that the numbers that we have in our doc and what you have should obviously match. And I think that's where the discrepancy is.
Okay, thank you. Specifically regarding violations of KAR 82-3-113 and KAR 82-3-117, since they're kind of similar, I think contain mostly the same wells. You state that Haas claims no responsibility for these violations, correct?
What page are you on again? Same
That's going to
page?
be on bottom of page 14, I'm guessing, through the top of page 15.
Yeah, so the same thing here. Again, there's a number of wells that we don't have on our inventory that you have on yours. And I don't know how we can ever get to a solution if we can't agree to the inventory.
Well, looking at going back to Mr. Dooling's testimony, it looks like this exhibit lists wells that operators' well records indicated were producing, but district staff was unable to locate during their inspections. So from what I can tell is, Haas is listed and claimed these wells as inactive or producing, but whenever staff performed their lease inspection, they did not find a well at that location.
So then if, would that actually make our inventory less if you couldn't actually find a well? Or no? Because clearly, okay, maybe, right? Again, I will tell you one of the other things that I think is also critical here. It's again a lease inspection, which has honestly helped us. That all the work that the KCC staff did out in our field, and I'm sorry you guys had to do all of that, but you actually also provided some very valuable information to us, and also, allowed us to be able to see where we could do a little bit better in trying to keep up with our well inventory. And it was critical that some of these lease inspections were done. I think almost every operator in the state of Kansas could benefit from doing a lease inspection. Oftentimes these wells are buried, they're not marked very well. And that's probably also what's contributing to the abandoned well status. So as an operator, we need to do better. We need to have a good figure of what these inventories look like, not only in what we're operating, what we're injecting into, and so forth. So again, I'm sorry if I'm not giving you the best answer. I can just tell you that these records, the state's records and our records don't actually coincide. There are wells that you say that we have, there are wells that we don't have.
I think those are wells that Haas is saying they have producing or inactive, and state was unable to find during their inspections.
Yes, oftentimes, and this could be the case, I don't know, because I don't know if we're talking about in particular, certain well numbers. But what I can tell you from my experience is what I found is well numbers aren't always accurate. That's been and I think I've even spoken with some of the field staff. They're oftentimes having a difficulty finding a well. And then, we find that sometimes our guys are, injecting or doing something with a well, and we find out their numbers are off. And then I go look at the KGS website and the numbers don't match there either. So, that's not to put any blame on anyone. I realize this industry has had a lot of change, rightfully so. But I think there's a little bit of a mess out there, but we're committed to getting it cleaner and just cleaned up, so that when I'm talking about a well that we're operating, that it coincides with the well that you're asking me about. But unless we have like real specific on certain wells, I'm sorry, I just can't really give you much more information than that.
Sure. Well, I appreciate it. One of the things that you did say was, sometimes you provide a well record or something along those lines, and then there isn't a well there. Mm-hmm. So are you saying that Haas has provided inaccurate well records to commission staff?
I am saying that I have seen I have seen paperwork that should be questionable, and it's not always necessarily something on our end. I'm one of these that, you know, I proofread things. So, and oftentimes it could be very easy for people to miss numbers. I mean, you can literally miss one number and have the wrong information, or get, you know, a change in the section, township, and range and have the wrong information. Not to mention, there are sometimes, you know, 2 wells with the same number. I don't know why that is, but if you go through the KGS website, there's oftentimes 2 wells that are exact same numbers, which then requires you to dig a little bit and find out, you know, if the section, township, and range are different. So I would say yes, there's obviously, when people aren't looking and being, oh gosh, what am I trying to say? If they're not really looking and paying attention and double checking, triple checking, certainly there's going to be room for error and human error. Not that anyone does it on purpose, it's just kind of what happens. And then when that happens and it needs to be caught down the line, that is something that I don't really see happening here. Sometimes we've mentioned to staff that these well numbers don't, you know, they're not adding up. And they're like, well, that's what we have. That's all we have. And I get that, but hopefully as this industry evolves, we can get a little bit better about that as well. So I went a very roundabout way to say, yes, I am sure that, you know, there's probably been paperwork that has had wrong information, not purposefully, but sometimes it's repeated wrong information from years.
Well, wouldn't you say the operator is responsible for making sure that they provide the correct information?
I think the operator is responsible for providing the information that they have. The problem is that sometimes the information that they have is not correct. And so in that case,
the operator isn't responsible for verifying that information is correct before they submit it to the KCC?
No, that's not what I'm saying at all. But you're asking me, yes, the operator should make sure that it's correct, but they only have a certain, number of places that they can go to ensure that information is correct. So if we're accessing, for instance, KGS website, and the information there is not correct, then we're actually perpetuating incorrect information. And I've seen that a lot. So yes.
Okay, thank you.
Absolutely, should be making sure that the information is correct. But sometimes that does take, it takes some outside influence. It takes the ability to be able to work with one another and figure out, where the mistake was and correct it. Absolutely.
Okay, moving on to page 17 of your testimony, you state that Haas has tried to do all it can to ensure those kinds of actions never recur, correct?
That is correct.
And I'm assuming that those kinds of actions means the number of environmental violations that Haas had manipulated the testing equipment at.
We're talking about page 17.
Yeah.
Well, on 17, the question's referring to it's important to investigate and respond to each of the allegations that's found by KCC staff.
Okay.
And
so maybe I was misquoting there. I apologize.
That's all right. It's okay.
But along those lines, as we discussed earlier, Haas has received penalty orders, which I get, that they aren't necessarily final orders yet, and that Haas is contesting them, but Haas has received penalty orders for 3 violations of KAR 82-3-407 and 41 violations of KAR 82-3-111, correct?
Correct.
On page 18, looking at lines 4 and 5, you state that commission staff is alleging an enormous number of additional violations that don't exist. Correct?
Page 18. Yes, what I'm saying again, if we're some of the violations that are occurring, maybe 2 violations on 1 well. So that sometimes inflates the, it can make a bad situation look worse. But the other part of that is on some of these violations, they're actually wells that we have transferred to other operators. So they still remain on our inventory, even though we've diligently sought to transfer some of these to operators that we feel are respected in the industry, that are committed to bringing them into compliance. But yes, those are still showing on our inventory.
Well, and just looking at wells that Haas has accepted responsibility for, and staff found a violation at, that still totals 490 violations as reflected in your exhibit RE1, correct?
I don't know if that number is actually correct, but I can say that that we actually have wells that are still out of compliance and have violations against them. Yes, that is true.
And that 490 violations, that would be outside of the other wells that seem to be a little bit more in contest between staff believes that they're Haas's responsibility and Haas believes that they're not their responsibility, correct?
I think that additional 490 wells, some of those are dealing with wells that have been transferred, or that are wells that the staff is tying to us because they're a quarter mile within an injection well that we might have. Some of which I found actually were more than a half a mile within our injection. But yes, I would say that those again are part of the wells that we have yet to determine if they truly are wells that we should be responsible for. And I can tell you, if that's determined, we're going to show up with responsibility.
Well, I'm just talking about the wells that are part of your exhibit, RE-1.
Well, let me pull that one up.
And I know you noticed you said something about wells being transferred, and I can see that there's some notes on the left-hand column about wells that have been placed back into production, but I don't see any notes saying that any of those wells have been transferred, correct?
Yeah, let me look at it for you. All the more reason to have a really good well count here. Bear with me one second.
And I don't know if it'd be helpful to have John pull it up as well, but.
Okay.
Chair Keen, while they're pulling that up, can I just ask you when we might be?
Yeah, I'm going to break the
For a
subject right
break.
now. Yes, there's no break subject right now. Kelsey, do you have any idea how much longer your cross-examination may take?
Hopefully not too much longer. I'm getting towards the end of my list of questions. I think I had 3 or 4 maybe left. I haven't looked at too much of questions that I would have asked Mr. Haas if given the opportunity, but since
we're going to be proactive here. We've been going for over 2 hours here, and I think Commissioner Duffy raises an important point. I think it's in our best interest collectively to take a 10-minute break now. So we're going to do that, and we will recess. Let's recess until 3:15, and then we'll resume with Ms. Epps' examination. We stand in recess until 3:15.
Thank you.
Okay, John or Sean, someone, could we go back to full screen now? Okay. Okay, I believe we're back. It's now 3:15 and we are back on the record. We'll resume with the cross-examination of Ms. Epps. I'll remind you, Ms. Epps, that you are still under oath. Kelsey, please resume your examination.
Thank you, Chair King. Ms. Epps, the question that we left with was regarding Exhibit RE-1. There are no notes in that exhibit that claim any of the wells that are part of that exhibit have been transferred to another operator, correct?
That's correct. And let me interject if you don't mind. And I apologize. I've got two different lists here. Probably should highlight these labeled lists so that I can actually read them because the print is quite small. So I did not, if I confused you at all, I think I was probably going back and forth between the two different lists, but I have the correct list. So if I seem to be confusing you at all, I do apologize about that. I have the correct list in front of me now.
Thank you.
Yes. And ask your question again. I'm so sorry.
Well, the question I had was, the wells that are part of that exhibit, RE-1, none of those wells have been transferred to other operators, correct?
That is correct.
So those are wells that Haas claims responsibility for?
Yes.
Okay, thank you.
You're welcome.
On page 18, lines 4 through 5 of your testimony, you state that staff alleges an enormous number of additional violations that do not actually exist, correct?
That is what my testimony says, yes.
So are you claiming that all the other wells where staff found violations at are actually in compliance?
No, what I was trying to interject there is, again, there's some wells that are actually on two different dockets due to different violations. So oftentimes we're seeing one well that may have a violation against it, but it may have two violations against it, or three violations against it. And so therefore it's we're not looking truly at the correct number of wells, like maybe a well's counted 2 or 3 times.
But you'd agree with me that there could be more than one violation per well, correct?
Oh, sure. I mean, yeah, that's evident. I've been able to see that.
I was just trying to figure out if you're talking about, there's those wells that Haas doesn't claim responsibility for. I get that. I was just curious if, you were saying those wells were actually in compliance, or if you meant those wells are probably out of compliance. We're just contesting whether we're or not we're responsible for them.
Right. Yeah, if I understand you correctly, there's certainly a lot of the wells that are in these higher numbers are all TA issues, which, as you may or may not know, we're actively working on those TAs. So I think all the staff testimony has seems to be the general consensus that that's our biggest violation. Like a lot of operators, the TA is an issue. So yes, I'm not saying that we do not have violations. Again, we're not going to try to skirt away those violations. We want an opportunity to bring those violations into compliance. It's the responsible thing to do, and obviously it's the thing that any operator must do in order to continue operating in the state of Kansas.
On page 18, I'm looking at lines 6 through 7 of your testimony. You state that Haas should be penalized for the events of November 2020. Are you saying that Haas should not be penalized for the other violations found by staff?
I'm saying on the dockets that have where we have had where we've been penalized, we absolutely should have to take care of that. I do think that there should be some penalties. There's no doubt that there should be. And
For the other violations found by staff?
Are you talking about the violations that we are discussing on the 4 dockets?
I'm talking about the violations that were found as a result of staff's investigation into Haas's leases.
The violations like the TAs?
I mean, there's lots of different violations, right?
Yeah.
A23111, unauthorized injection, producing from wells that aren't on Haas's license, just to name a few. So are you saying that Haas should not be penalized for those types of violations?
I think that if the commission has ordered a penalty, I trust the commission's opinions and their decisions, and we should pay that penalty.
Okay. I know part of the testimony goes towards Haas's actions prior to the events of November 2020, correct?
Correct.
And its compliance history there. But don't you yourself state that really doesn't matter? And the phrase that caught my eye there was on page 19, I think it's lines 13 through 14, that basically says whatever penalty the commission imposes upon Haas Petroleum should be based on the events of November 2020 and Haas's response to those actions, correct?
This is in relationship to the bigger picture, to the commission. That was a question from a big picture perspective. Why is all of this important to the commission? My answer was, whatever penalty the commission imposes should be based on the events of November 2020 and Haas Petroleum's response to those actions. In addition, the commission should decide whether or not such actions alone justify not renewing that operator's license. So correct. I'm not saying that we shouldn't be penalized. What occurred without my knowledge and still not 100% on where that knowledge fell, but what occurred was horrendous. It was disappointing. It was disgusting, and that is not indicative of how an operator should operate. And we are entrusted by not only the staff, but the community to operate, again, responsibly and ethically. And you cannot do that if you are doing activities that skirt what's actually being done or what needs to be done.
Right. So, and my question about that was basically Haas's compliance history beyond November 20 or prior to November 2020 doesn't really matter in this case, correct?
No, I think it certainly matters.
But that's not what's reflected by your testimony.
I don't think that's what I said, but if that may be what you're reading from that, but that's certainly not what I said. Haas Petroleum has been around for a long time. Mark Haas himself has, my gosh, from what I understand, the stories that I've been told, he's operated since he was a teenager. He's been in the business for a long time. And the research that I've also found is that he has not had major violations. I think 4 small violations as an operator. So I think what that says is historically, he's been a pretty good operator. The issues that they had in November 20, I have no words for that. It's ridiculous. Do not know what happened between, the 80s to 2020 or 2005 to 2020 at that point. But yes, I don't think that we could erase the history. He's been a great operator. The Kansas Corporation Commission has recognized that by continuing to renew his license. I don't think that we can erase that. Do I think that November 20 represents what his past has been? No, and that's a shame. That's a shame. But as the current chief executive operating person, we're committed to do better. We're committed to do better. I would love to see better relationships with the KCC. Me personally, I've been out in the field, which I love going out in the field, get out of the office a little bit and crawl around in the dirt, try to stay out of the way of getting oil sprayed on me. But I've had a good working relationship the few times that I've been out with several of your staff members. And I think with the direction that we are currently moving in and with the staff that you have in place, I have no doubt that we can find our ways back in the good graces of the Kansas Corporation Commission and be recognized as a good operator. That is my goal.
With regard to Haas's actions since November 2020, how many wells are still out of compliance?
With our, and we are talking about those actual dockets. So let me give you the exact number. On docket number 3201, there were 20 wells, I believe, identified on that docket. The wells have either been plugged, have either been repaired, have either been transferred to other operators. And in fact, I believe, on occasion, you may have seen me looking up here to the side. I have some guys out in the field actually today that are working on a couple of wells as we speak. So currently on that list of 20 wells, there have been 8 of them that are still needing work done. 2 of those are actually being done as we speak. That's
and then several hundred others also, correct, based off of staff's inspections of wells that Haas does claim responsibility for.
Are you talking about the TAs again?
Talking about TAs, unauthorized injection, producing on wells that aren't on Haas's license, those types of violations.
I will say yes. And then the only reason why I say yes again goes back to that TA. I mean, the TA, as you recall, as we've been sitting here most of the day, it seems to be the biggest violation that we have. And we're actively working on that. We've, in fact, spent a great deal of time getting those TAs taken care of. And my direction has been, I don't care about pulling. I don't really care about the producing. I need the TAs done. So that's what we've actually been doing. So yeah, I mean, you know, and when we discuss the violation and the hundreds of violations, again, there are violations. And I don't want to necessarily get into the numbers of it because I don't think that either one of us can really 100% know what those numbers are based on the fact that sometimes there's a well that's not out there. Some of those wells, by the way, that we have are done in the 20s. So things weren't filed properly back then. And so to expect that non-existence of paperwork back in 1920 to necessarily show accurate today, I don't think that's possible unless we are all committed to bringing that paperwork current. And that takes us as an operator, that takes our help. And it also takes the help of the KCC.
So after acknowledging all the violations that we've discussed previously this afternoon, that Haas is, we know, or you seem to say that Haas is responsible for and staff found violations at those wells, both subject to these consolidated dockets and through staff's field inspections. Are you still trying to claim that Haas is in compliance with all requirements of Chapter 55 of the Kansas statutes annotated, all rules and regulations adopted thereunder, and the commission's penalty orders in these compliance or consolidated dockets? Excuse me.
Well, what I'm saying is that there are certainly still wells that we are working on, actively working on to bring those into compliance. That is what I'm saying.
Okay, thank you. I do have questions based off Mark's testimony, but I'm guessing you won't be able to testify to his intentions, correct?
Well, I don't know that. Yeah, I can't quite get in his brain, so I'm sorry. I probably, if they're opinionated questions, I'd only be giving you my opinion, and I don't know that that would do any of us any good.
Well, I guess maybe the one thing was, I know his testimony mentions a lot of old wells that were accepted by Haas.
Mhm.
So does that mean that Haas recognized that those wells were potentially environmental issues that needed to be addressed whenever they obtained them?
I don't know that. Again, I'm just going to give you my opinion on that. I do not. I don't think I can say that he recognized that those wells were out of compliance or needed work. What I can tell you in the past, and I think this is similar response to a lot of operators. Oftentimes, when they get these leases from other operators, especially when they were done in the 60s and the 70s. They just didn't do a very good job at inventorying what they actually had. And so oftentimes, if you're not, I would think if you're not out there actually walking your property, doing the kind of surveys that you guys took the time to do, and of course, then the surveys that we had Dave Griffin do, I don't know how you could possibly even know what you have. Literally, and sometimes the terrain of the land, sometimes you can't find them. I was actually out on a well with Dwayne Sims not too long ago. We're actually doing a plugging job, and he asked me about another well, and I said, well, let's go look at it. Neither one of us could find it. Sometimes trees have grown over it. Sometimes, there's a new fence line, all kinds of reasons of why sometimes operators don't really know what they're actually inheriting. Do I believe that an operator should do their due diligence? Absolutely. Absolutely.
Thank you. Thank you very much for your time.
You're welcome. You're welcome.
I believe that covers the questions I have, Chair King.
All right, thank you, Mr. Marsh. Let's see if we have commissioner questions. I'll start first with Commissioner Duffy.
Thank you, Chair King. Good afternoon, Ms. Epps.
Good afternoon.
First of all, I'd like to understand you own 51% of the company. Is that correct?
That is correct.
And Mr. Haas owns the other 49%?
That is correct.
Okay. Secondly, as I look at your timeline, I'm not sure when you joined the company and as what. Could you walk me through your work positions with the Haas company?
Sure. I believe it was in 2019 that I did some freelance work for them prior to that. But I would say that I actually came on as an employee in 2019. And again, at that time,
a full-time employee. I understand. Are you also a licensed real estate?
Yes. I've held a Kansas and Missouri license for quite some time, since 2004.
Okay, so you came on in 2019 as a full-time employee?
That's correct. That's correct.
And what was your position?
I was the director of operations. And in that role, I was brought in to identify areas in which we could operate more efficiently.
Okay, meaning efficiently in terms of regulation, in terms of financial, in terms of what?
Almost in every aspect. And it's taken a lot of time to fully understand the scope of the actual business. At the time when I came on, I believe it was just right after COVID. If I have my dates correctly, that seems to be what sticks out in my head. And at that time, oil prices were not good. There was money being spent in assets that we just no longer needed to hold. And there were certain things, jobs, roles within the actual front office that just didn't make a whole lot of sense. There were ways that I identified some things that we could do to make that run a little bit more efficiently. And so that was my initial role, that I would move from and just work my way down. Obviously, there were things out in the field that need to be addressed as well. I will say that, well, that was the role.
So did you have a prior oil and gas background coming into the position of director of operations?
My oil and gas background is very limited. I grew up in Oklahoma, so I had oil wells in my backyard. But in the early part of my career as working, I did work for an industrial company that we produced. What do we produce? Filters, filter separators, oil water separators. So that's probably about the scope of my work. I worked and sold those types of equipments to different distributors across the United States.
Okay, so who were you considered part of the senior management team in 2019? And if not, who was the senior management team from 2019 up until April of 2022?
I would say yes. I was not considered senior management. From what I know on paper, the senior manager was Mark Haas. His second person in command was John Haas, his son. And then he did have another daughter, Morgan Haas, that seemed to manage the office, the finances, the HR, as well as the compliance part of things.
So Julie Barber did not handle compliance back then. That was his daughter instead.
Julie Barber's role, it was probably more of an administrative support role. So she is responsible for producing the paperwork. And I would say that was probably the majority of her role. Once I moved into the position that I'm in now, there's obviously some things that I recognize that she should have a greater role in and a greater understanding for what she does. But, you know, again, she did do the compliance, but it was mainly from a paperwork administrative support position. She really relied on senior managers to make sure that she had the information that she needed in order to do the paperwork.
So now who is senior leadership in the organization besides yourself?
It is lonely here at the top, Commissioner Duffy.
So you are the only person.
I am the only person at this point in time, and which is also the reason why we put together an advisory board. Even myself needs an accountability check. And also needs, another set of eyes looking at the business to make sure that we're moving forward in the direction that we need to move.
Okay, so since you're taking on Mr. Haas's testimony, also, I believe you guys hired a Mr. Griffin. I believe that's in line 239, page 13 of his testimony completely devoted entirely for developing complete records for each of Haas Petroleum wells and auditing regulatory compliance on all wells. Sounds like to me he hasn't been very successful.
Well, he's been actually very successful. The problem is, and it's not necessarily a problem. Mr. Griffin didn't really start doing this, obviously, until after all of these violations started coming down the pike.
Excuse me, when exactly was he hired then? I'm confused because he's mentioned several times.
Well, again, he's not actually, well, I suppose you could say he's hired to do the job. I don't have the exact date of when we commissioned him to do this work. I can tell you, he's worked for us for a very long time. Again, he's part of the, he's a geologist, so he handled when we did our drilling, that was, Dave was the primary person out there helping us drill, but that was actually before I was on board, and that was some time ago. I don't think we've even drilled anything for quite some time. But he's very versed in the not only the KGS website, but he has access to records sometimes that we don't have access to through the KU Geology Services Office. So he was an excellent person to be able to go to say, hey, we got this problem here. We've got the KCC that's gone out and inventoried our wells. We need to do the same. We absolutely need to know everything that we can about our wells, not only the wells that we are showing that are in our inventory, but also these wells that they are saying are in our inventory. I said, let's get a spotlight on this. And that's what he's done. But again, his role in this particular position has been after all of the discovery. It was actually it was a proactive move for us to bring him on board to help us ascertain the entire situation that we currently find ourselves in.
Okay, thank you. So I wasn't clear on your answer to Mr. Marsh. Have you or have you not submitted paperwork to the KCC stating the change in leadership with Haas?
I cannot, I do not know. I do not know that answer.
Why don't you know that?
When we're talking about the list on COLAR, that was actually, our license expired. Actually, the actual license went into effect for renewing in April. It was April of 22. I did not come on board in this role until May. So that license application through COLAR has been sitting there in limbo. But it's also
the application that you submitted was submitted in April with Mr. Haas' name.
That is correct. I'm almost positive.
Was that done electronically or with paper?
I am going to probably say, and I don't know for sure, but I would almost say that it's probably electronically because we did have access to COLAR at that time.
Okay, so, but you don't know whether you have followed up the next month amending that application and putting your name as now the majority owner of this entity.
Yes, I can testify that I do not. No, we did not do that.
Okay. So with the Secretary of State's office, I understand that an annual report is filed. Have you submitted any additional information to the Secretary of State amending the ownership of the company?
I do not believe that has also been amended. Again, the paperwork that went in that was renewed was in April. And I'm sure that that change will actually be reflected at the next renewal time. But I would say no, I do not believe. Now, unless Julie, who also is responsible for doing that, unless she has done that, I'm not aware.
But you've not directed her to do either one of these specifically.
I do know that we did fill out paperwork. Whether it's actually been filed, I cannot say for sure. But we did complete paperwork here in-house.
Okay, so I would agree too with Mr. Marsh's comment on, let me see if I can find the page where you state that you believe you should be penalized for the events of November 2020. And I read that to believe that you believe that was your only thought, that those were finable, but the other events were not. And I'm sorry, I don't have the page in right before me. But now what you're saying is you believe that the total amount fined by the commission to date, this is what I thought I heard you say to Mr. Marsh just a few minutes ago, is acceptable to you to pay.
I didn't say that.
Oh, okay. So if you could clarify, I thought you said the amounts were acceptable in your mind.
Yes, no, I did not say anything about the amounts, actually. What I said was that when you talk about the seriousness of the alleged response to MITs in 2020, I agree that it's egregious, disappointing. I'd be embarrassed. It's embarrassing too. So I think that the staff has every right to actually require something of us because of that. What I was trying to implore is that given our history as operators, I think that we also deserve an opportunity to do better, to make it right, not just for ourselves, for our employees, for the commission, for the state, and so forth. So I did not get into specifics about the actual fines. I think our legal did have some recommendations for that. But yeah, I mean, obviously a penalty is certainly in order. What that amount is, obviously that's still up for debate, possibly. But yeah, this was bad. This was not good. And I think we're better than that. And I think the leadership that we have between myself and the advisory board is worth betting on, that we can certainly move ourselves out of the situation that we're currently finding ourselves in. We owe that to ourselves, the community, and our workers, as well as our investors.
Okay. You mentioned that the investigation is ongoing by your company into what happened in November of 2020. Do you mean a criminal investigation? Is that what you're alluding to?
No, I wasn't.
Mr. Bishop?
Yeah, no, I wasn't alluding to that at all. With something like this, and I guess you'd probably have to understand a little bit of the kind of the makeup of this company. This is a really small company. A lot of wills, but a very small company. And a lot of the people have been doing these jobs for a long time. The culture has been it's almost a night and day difference. You either have a part of the culture that is, well, till someone tells me to do it, I'm not doing it. And then you have a whole nother part that's like, that just does it without any type of direction or anything else. So those are things that we are finding out. We're having to retrain people. We're also having to place some constraints on people, and some of those are working out, some of those are not. And I can tell you that, without going into everything as far as our employees, there are some issues that I just can't completely discuss as far as with employees due to HR and opening myself up to further liability besides the liability that we have on our wells. But I can tell you that the mistakes, the rogue way that some people were doing things, that is over.
Well,
That is absolutely over.
okay, well, can you answer, did Mr. Haas have any connection to the events that occurred in November?
I do not believe so.
But you don't know?
Are you asking me if he implemented these devices?
If he implemented or was a part of what occurred in terms of the use of these implements into the MIT integrity test units?
What I can tell you is what I believe to know is that he did not physically do any of these things. But here's the reality of it. He's the owner of the company. He certainly should have known. It's his responsibility to know. Whether or not he did, I cannot answer that for him. But I do know that, I have the accountability that should something happen like that on my watch, I'm going to have to take full responsibility for it. If I didn't know, I should have known.
Okay.
That much I can say.
Okay, and real quick, these employees that you're talking to, are they full-time equivalent employees in the company, or are they hired help?
I would say the employees that we have right now in our field are full-time.
And so Mr. Bishop is a full-time employee within your company?
He is a full-time employee within our company at present, yes.
Okay, all right. Thank you very much.
You're very welcome.
And Chair King, thank you.
All right, very well. Commissioner French.
Thank you. Good afternoon.
Good afternoon.
I only have a few questions. Most all of the written testimony, I found your positions very clear. I'm going to ask you a few questions, and these may be uncomfortable, but I think they're relevant. Let me ask you a bit about your relationship with Mark Haas. It's my understanding in response to Mr. Marsh's questioning that you are legally married to Mr. Haas. Is that correct?
I think we actually determined earlier that wasn't actually relevant, and I'm not sure if we're sticking with that or if we find that there's relevance. Is there any?
Well, I certainly believe it to be relevant, and we can get into it, or you can refuse to answer, and we will take that as a as we will.
I'm certainly not trying to skirt any of your questions. Can you explain to me possibly why you feel that is relevant to know that information?
Well, it does seem to me that maybe not 100%, but a large portion of the defense in this case rests on a clean break from the past. And I think I would like to understand how clean that break is. There's also clearly a financial link between you and Mr. Haas. You were gifted 51% of the company. I think it's relevant whether that occurred before or after your marriage, during a relationship. These things might all go into a consideration of how clean a break from the past we actually have in this docket. So I will give you the option of answering, but I would certainly like to know the information.
Okay, well, let me first say, gifted 51% of the company. Company needs a lot of help. So, I think the company is quite different than what it used to be probably 10 or 15 years ago. With that said, the company has needed a little bit of financial support, a little bit of support as far as shouldering some of the responsibility of a company. So I don't know that I'd consider it a gift right now. If we can get out of this mess and work to rebuild things, then it might be considered a gift. I almost feel at present it isn't so much as a gift, but yes, I understand what your question is. Yeah, I will answer that question. I am married to Mark Haas. That happened probably, I don't know, maybe a year ago or so.
What was the exact date?
Now you're going to embarrass me because I'm going to be one of those people that doesn't really know, right? What are we in 22? I hope he's not looking right now. I'm truly going to have to look on my calendar, so stand by. I want to say it was in April. Let me look at that. I think the stress of all of this actually doesn't help me with keeping many dates of anything, birthdays or anything else. Let's go with April 22nd, maybe, of 21.
Okay. So it would have been mid-April 2021.
That's fair.
And the 51% gift of Haas Petroleum, I presume occurred after that?
Way after.
Okay. What was the date of that, when that paperwork was completed?
That was after my initial appointment to Chief Executive Officer. And just know too that there was obviously some planning that went into that, being that with that type of ownership, we actually stand to benefit should there be other things that whether we decide to move into. It did help with that role. So like I said, I don't know. I feel uncomfortable when you say gift. This is probably one of those gifts at this point that seems to keep giving. So
I understand that position.
Yeah, it's been.
I'm just trying to knock out the date of the transaction. How about that?
So I would say it was after we filed paperwork. Obviously, trying to reinstate the license, and after the sometime
it was after your annual report was filed with the Secretary of State.
Yes, that is correct.
So sometime in May or June.
Yeah, May or June. I would say that was accurate. I don't have that document in front of me, but I would say that's pretty accurate.
So let me ask you another question, and you're going to consider this personal as well. But it does appear that between you and Mr. Haas, you do own 100% together as marital property of this company. Is there any prenuptial agreement or any other agreement between the two of you that for some reason that is severable, that is not marital property together?
I don't feel that that's relevant either. And so I'm going to refrain from actually answering that question. I'm happy to, maybe you can get more at the meat and potatoes of what it is that you really want to know without having to go with such a personal angle. Are you concerned with what? What's your biggest concern?
Well, I'm trying to understand who owns the company.
I think the paperwork says 51%, 49%. The paperwork also states that I am the chief executive officer and I am in charge of making the decisions. So this wonderful gift that I was given is currently resting on my shoulders right now. So I'm very optimistic about things, but certainly it is a lot. So that's all I can say. That's all I can say.
Well, we will take the answer as it is. I've got one other area, and this may be a question for your counsel, but I think you indicated earlier that your husband, Mr. Haas, was there with you this morning for breakfast. I think you just indicated he may be watching. And I guess I'm trying to understand why counsel has represented that Mr. Haas was unavailable to present his testimony. If he is perhaps at the house, if he is watching the hearing, I understand the position that he is no longer employed by the company, but I'm having trouble understanding the position that he is unavailable to present his testimony.
So
I do think that's a question for me. I have an email from Mr. Haas telling me that he was going to Cincinnati, and when I reached out to him to be here, and so I believe he was in Cincinnati. So that's why I said what I said to the commission.
Ms. Epps, is that your understanding?
Yes. So when I told you that I spoke to him this morning, we have phones. And when I think I may have even said I saw him this morning, we have FaceTime. So yes, and no, he is not here on property where I am. I am sitting here at my desk in Kansas City, Missouri. The only person that is actually here working in the office today is Julie.
And do either one of you have information on what he is doing in Cincinnati?
Yeah, probably trying to decompress. Probably, yeah, trying to decompress. So I don't think it was business at any. It was probably more pleasure. He is used to be an avid, had an avid interest in horses. It's almost therapy for him. So if I were to guess, he is probably at a horse farm with a trainer, decompressing with some horses.
Well, I'll leave it there.
As far as mine, he didn't tell me what he was doing there. I reached out to him about this hearing specifically, and that he told me he would be in Cincinnati, but that's all that he told me.
All right. Thank you, Mr. Brown. That's all I have. Thank you.
Thank you.
Okay, in a sense, I have several questions as well. I'm going to start very succinctly with the question I've asked several others, the vexing question, which is the well count. So I want, in your opinion, for you to tell me currently what is the operator's total well count and how does it break out by producers, injectors, and TAs?
Oh no, I was hoping you wouldn't ask me that. I do not have the breakout, and I apologize. You would think that I would have that. I believe what I can tell you is the well count. of what we are actually showing is 11 something, but let me see if I can find it really quick. But I had all of that with me. And I may be right or wrong here. I'm going to give you an estimate, and I apologize. I do have that here somewhere, but I'm honestly lost in all of this paper right now. But it should be somewhere in the neighborhood of 1,148, under 1,200. And as far as injectors, I know on the list that is added to the example are the RB1 maybe. Mine actually missed being labeled. Probably in the neighborhood of, I don't know, maybe 8 or so injectors. I could be a little wrong on that too.
I'm sorry.
Probably somewhere in the neighborhood of 80 to 90 maybe injections.
Okay.
I may not be completely accurate on that, and I do apologize.
And TAs?
I do not have that number. There were quite a few TAs, quite a few temporary abandonment wells, and I wished I could also give you a little bit more accurate number on that. I'm still waiting on submissions from my field personnel. They're literally turning those in by the day. So we've gotten through quite a bit of them, but I do apologize. I don't have an accurate number of exactly how many there are.
So am I taking it that you don't have a centralized place that you can go to and quickly retrieve at any given point in time the number of producers, injectors, and TAs that you have together with your total well count?
No, Julie
You
does
cannot,
have
you
that.
cannot do that. There's no system in place. Pardon me. I'll finish the question momentarily. There's no system in place that allows you to quickly retrieve that information.
The current system in place is being done by Julie. Julie does have that information. And some of that information is accessible as well that I have on my screen, but no, sir, I would have to tell you at this point in time, there's not an easy spot for me to look at that unless I actually get with my person that is responsible for getting all those TAs and wells amended, and that would be Julie Barber, but she should have that information.
Okay. How large is your office staff?
We have Julie and I are full-time. And then we have a part-time person that comes in and assists with some of the invoicing and taking care of orders and that type of thing. So I would say 2 full-time and then 1 person that is part-time. That person is also contract labor, so she works less than, 30 hours, anywhere from 20 to 30 hours a week.
So between yourself, bear with me, Ms. Barber, and this contract person, you're trying to handle all of the accounting, the bookkeeping, the compliance, all of these tasks that pertain to roughly 1,100 to 1,200 wells and run all other aspects of the business. Am I understanding that correctly? This is,
Right.
You're trying to do all of these things?
That is what we're currently doing. We do have an accountant that handles that part. And again, she's contract labor and I didn't include her, but we do have an accountant that does that part. However, yes, Julie and I do a lot of the paperwork on this side of the fence. The rest of the work, as far as the actual well work, the actual ordering parts, all of that is actually done out in the field. I certainly have to monitor it. It is a lot. I will not try to be dismissive on that. It's absolutely a lot. Do we need to hire more staff? We absolutely do. And we're also working towards doing that as well. One of the things that we are working to do before we actually go full throttle into that is the vision that I see for this company is not only has the staff dwindled, but we can't deny that age also kind of plays a part in things. And so you have an aging workforce. And to be quite honest with you, I don't know that I want to continue to work this hard. This is a lot. So we're working towards shrinking this business down. This is a lot for the amount of people that we have. We understand that. So we are working on shrinking this down with the goal of being able to have a much smaller amount of wells that we are, that we are actually responsible for. In total, I think there's between field personnel and people that help us in the office is somewhere between 14 and 16 people, with the majority of those people being out in the field.
What sort of bookkeeping system do you have?
We use QuickBooks is what the software is what we use.
All right, you were headed toward the other part of my question. How large is the field staff?
The field staff, let me give you the exact number. I'm gonna have to think about this. I didn't bring that information. Let's see, we've got I would say the field staff, well, give me one moment. I'm not even going to guess at this, and I can actually look right next to me. So do you mind if I grab something out of a drawer right next to me?
Go right ahead, please.
Like, what's the point of guessing if you can just pull out a piece of paper and look? All right, it looks like there are a total of let's see, it looks like there are actually 13 people that work out in the field, and then probably 2 additional that I should add. They just don't receive their income through payroll, their contract labor. So we actually have 2 additional people that we pay weekly that are actually doing some field work as well. So, but just running through payroll, there looks like there's about 13 people that work out in the field.
How many of those 13 are pumpers?
Let's see. Well, we have 2 here, plus 1 relief. And then I have 2 over here, 1 relief, plus another. Let's see, 4, 5, 6, 7. There's about 7 to 8 of those gentlemen that are, oh, wait, I'm sorry, hold on. I forgot a couple more. So it looks like in the Gridley area, I would say that we have 3 full-time pumpers in that direction. We have another one that does help with relief pumping, so probably 4 there. And then here in the Wellsville, Rantoul area, I've got 3 and maybe 1 relief pumper.
So how many total would that be?
Let's go with 3 plus 1, 4, maybe 8, 7 to 8 people that work on our pumping, in addition to an extra one that does some relief pumping for us from time to time as well.
Who does well servicing for you?
Well servicing is usually, we have a couple of different well servicers. Some of those, and I'm assuming you're talking about a third party servicer, or is that what you're asking me? Or just
Whoever it is that does rod or tubing jobs for you and other well servicing for you.
Yeah, so we actually, some of that we can do ourselves. We do have some people that operate pulling units, and some of, changing out the wells and that kind of thing, they're responsible for doing. However, there are some jobs, in fact, one of the ones that we're working on today while I've been discussing all of this with you, or outside of our scope. We don't have certain pieces of equipment to pull out some of those tubing and packers. So we have a company that we work with called Glacier. We have a company that we work with called Hurricane, and sometimes AJ Services is also on hand to help us with the things that are outside of our scope.
Does Haas own its own well pulling units?
Yes.
And who operates those? How many employees operate those?
We have 4 different guys that actually work on the pulling unit. So they're in the Chanute, or I say it's Chanute, I'm sorry, I keep referring it to that. The Gridley area, there's 2 pullers there and a helper. And then Rantoul, there are 2 pullers and 1 in the, 2 of them in the Wellsville area. Wellsville, those wells are a lot more shallow, so oftentimes they can pull without necessarily having to have more than 1 person.
So how many well pulling units do you own yourself? Does the company?
If I have to be exact, I know there's been some shifting of some of that equipment. There is, each area has their own pulling unit. I do believe there could be additional units sitting around. In Wellsville, for instance, there's probably 2 there. 1 is only usually being operated at a time, but obviously sometimes if you have equipment breakdown, we do have access to be able to get another pulling unit in there.
How many counties in Kansas does Haas operate in?
Let's see. I'd have to sit here and count them all. Let me look. There looks like there are 6 different counties.
Okay. Okay, so you have operations on somewhere in the range, as I understood your testimony, of includes basically 1,148 to 1,200 wells. With daily oversight by 8 pumpers in 6 counties. That's a lot of territory to cover. It
is a lot of territory.
With that people.
Yeah, I agree. It's a lot.
How can that number of people, does that number of people, your pumpers actually daily perform? Did they actually daily visit each well and each lease?
Yes, they're supposed to. Yes, that is the goal. Keep in mind, some of those leases, for instance, we have some leases that are currently shut down. So obviously that limits the amount of work that those guys have to do. And also keep in mind that some of those counties, and we have leases that sit in 2 counties, so they butt right up, against each other. Again, we had more employees at one time when John left. In fact, now whether or not he was actively doing it, part of his position was actually in the supervising and managing a lot of the rental and the Wellsville area. So like I said, there's a lot, and some of those wells, they're either they don't always require someone going by there, especially if they're shut down. But regardless, the goal is to trim that down even further, get in a number that is just easier to be able to account for. If you're alluding to the fact that that is a lot for a small group of people to manage, I would agree with you.
That is what I'm alluding to.
Not manage it. Yeah.
No, you have a lot in motion. There's a lot in motion out there. You have
Yes.
producing wells, you have injecting wells, you have pumps, you have all kinds of slew of things. And in the ordinary course, things go wrong. And you've got tank batteries, you've got well siphon, you got siphons that'll plug up, all kinds of issues can happen.
Yes.
It's a lot of territory for such a few number of people to cover. And have you tried to do the backfilling to improve your operations? It seems like it's a Herculean effort, almost impossible to me.
I would think I would say that you are probably correct in your assessment. It does seem like an impossible effort, and I have felt that many times. However, we spend an awful lot of money as well on third-party help, and again, that's part of the recognizing that we have to trim the amount of wells that we're responsible for, trim the amount of wells that we can effectively manage, just scale everything down. And we're in the process of doing that. We've transferred a lot of wells. We have wells that are, or leases that are currently looking at moving them out of our assets. So it's taking some time, but I feel like we are making some strides in doing it. We definitely recognize that it's a lot for such a small organization to have to manage. I think if I might say, from my experience and having conversations with people, I think there was a hope that Mark would be able to, probably turn this over to his kids. I think, they've got the youth on their side, certainly. And I think that's probably what the hope was. Things didn't pan out that way. And so a lot of the growth was supported by Mark, but not necessarily spearheaded by Mark. And the people that he thought was going to be around, stick around and kind of manage that, grow that, those people are no longer with us. So we have no choice but to scale it down. I think it's the most effective thing that we can do. And like I said, we're working towards doing that. Probably more than half than what we're currently responsible for.
Thank you. In your opinion, how did the company's internal compliance overview and procedures come to be so lax?
I don't think it was laxed. It certainly appears that way, but I don't know that that was the. I don't know that that was the root. I think just and this is my experience and my opinion, there was a lot of hands being tied in this organization. And I don't know if it was a trust factor. I don't know if people that were put in positions didn't trust other people that were put into positions. And the communications was awful, like absolutely awful. I've seen some bad communication, but you've got to communicate. So some people are better at communicating than others. I would rather over communicate than not. And I think that was the culture. Lots of I will admit, even coming in, I faced a lot of roadblocks. There were some people that made it very, very difficult for me to do my job. But here we are, we're working through it, and I am working towards and actually finding some success and helping reculture this environment that information is critical. Information is critical, communication is critical, relationships are critical. Like I said, I actually enjoy going out and being out in the field and being able to have some face-to-face with the KCC staff. And I wish that I had been more proactive at stopping by the district office and just being more visible. That is obviously something too that I plan on doing. Relationships are critical, communication is critical, and that is something that Haas Petroleum has actually failed miserably at. We are working to improve that.
Who was the person within Haas that was responsible for fabricating and using the MIT testing tool that led to the acknowledged MIT violations in November of 2020?
I do not have an answer for you, sir. I do not know. I do not know that answer. Like I believe I told Commissioner Duffy, I think, and I apologize if it wasn't when I was speaking with her. This is something I realize that you can't always know everything. There are going to be there's going to be some points that you just might miss, especially when it comes to being here, working inside the office and then being out in the field. What I find is it's important to have people in the field that are trustworthy, people that are accountable, people that communicate with you. That has actually been a problem. Again, working to correct that. So I cannot tell you who was responsible for it, who knew about it. What I can say from my position is that had I been in that role as an owner, if it were me and this situation happened, I could honestly say I may not know who did it, but is the blame going to come on me as the CEO? Absolutely, and rightfully so. If I didn't know, I should have known. That's my thought on that.
If you're trying to determine prospectively who is trustworthy, how can you do that if you don't know retroactively who was responsible for such a violation that you have characterized yourself as being egregious?
Yeah, I think there's a lot of things that you can do that tell you who's trustworthy just by having conversations. I've had some conversations with some people, and I'm left kind of looking a little off, wondering, okay, did they just really respond that way? And that happens. I think you know who's trustworthy by actually cultivating that relationships with your people and being proactive and being present. Probably the biggest thing is actually being present. In that particular space, that Gridley space, the person that was, mainly making a lot of those decisions is no longer making those decisions. I have to have people that know what they're doing. As Commissioner Duffy asked what my expertise was or my experience in oil and gas. Like I said, I've seen lots of wells pump up and down living in Oklahoma, but knowing the ins and outs, I don't know those. And so it's very critical that the people that we have hired do know them. I've told all of the employees when I took over this position and I went out and met with all of them, I rely on you to know have your level of expertise out here in the field. And if you don't, it will show itself very quickly. And what I can tell you is we've made strides. We've taken people out of the positions that they were in. And I would be remiss to say if we're not going to have some more of those kind of changes made down the road. We just have to.
I believe I understood that in response to a question from Commissioner Duffy that you indicated that Randy Bishop is still in the employ of Haas.
Yes, he is still employed with our company.
In what capacity?
He does a little bit of pumping. And he is working with, for instance, I'll give you an example of what he was doing today. We had a company by the name of Glacier Well Services out pulling some tubing and packer. So his job is to meet them and make sure that they have access to that lease. And then he's to report back to me of, that they actually made it on site. So that's what I can tell you now. He does not have any of the decision making on how we actually handle wells. He doesn't have the freedom to make decisions without proper advisement. Again, something that seemed to be occurring on the regular prior to my appointment as the CEO.
Who supervises the field operations?
I have two. The field supervisor in that Gridley space, his name is Ben Harrell. Ben's been in the oil and gas industry for a very long time and has had quite a bit of experience, even outside of Haas Petroleum. And he's one of those that I identified, if I might be candid, of being able to do more than what he was being allowed to do. So with how we've moved him into that position, he's proving that I made the right choice. He's one of those I definitely feel like his hands were being tied. And that's unfortunate because I think it negatively impacted our company. When it comes to the Rantoul and the Wellsville area, I have Chad Hammond, again, another person who's been in the business for a very long time. And what I might say, what I like about these gentlemen is that they understand that I need the communication. I need them to be my eyes on the ground. And so far they're doing quite well at providing that data for me so that I know what's going on out in the field when I can't be there.
How did basically the operator's well count evolve? I presume some wells were from cases where Haas was the original lessee and they drilled wells. There are other instances where they acquired leases from other operators. How exactly did that well count evolve?
Gosh, I don't know. I don't know that I could answer that because that well count evolved over several years, I'm sure. But yes, I would say that some of it definitely was acquired. Some of it was even on the drills. And I'll give you an example. One of our when I was looking at some of the history of our wells, and then I think the latest order on the injection wells of how they were recommending that those would be shut down until we got wells within a quarter mile done. I started looking at some of those wells, and I picked a particular lease. And unfortunately, me picking that one lease knocked about 2 to 3 hours off my day, just trying to figure out what was going on with this particular well. And what I found, there was a well that there was an intent to drill, and the intent to drill expired. There is paperwork to show that the KCC sent a notice out that reminded the operator, you've got an intent to drill, it's soon to expire. Basically, what are you doing with it? Julie did respond back, and this has been some years ago, but she did respond back, said, yeah, we're not going to drill that. So they had the plans, decided not to. I sent my geologist out, and I said, can you go out there and tell me what's there? And I said, if you have the intent to drill, that means, you're going to plan to drill. And he said, yes. And I said, so did that, I'm going back to my construction days. Does that mean that there's just land and we haven't quite put the foundation on it? He said, yes. And I said, so what's there? Dirt. Okay, so there's really not a well there. That is correct. But it's showing that there is a well out there. And that's clearly just probably an issue of, again, paperwork not getting to the right space so that the KCC knows, yes, there was a drill intent, gave the well number, but that well number really doesn't exist. So there's a lot of issues like that as well. I took a long way to tell you that story, but hopefully that made sense.
Well, the reason for the question is simply, I'm concerned about your inability in-house to try to reconcile what your well count is in real time. And when you have basically experiences when you're saying you're going out in the field and you're coming across wells that are hidden by trees, or you're going out there and you can't, by contact with your field personnel, ascertain what an actual well count and how accurate the well count is with any specific lease. And that field staff has a problem IDing wells that they stumble. See, these things really they kind of evidence chaos in the well inventory process. That was the reason for my question here. I'm thinking, okay, certainly you would think that you would have records in-house, thorough records in-house from wells that you drilled. I would think that you would obtain from leases that you acquired information about those specific wells, maps, logs, the whole potpourri of those things. But how, even organizing those, trying to keep them current, that'd be a Herculean effort in its own right. I'm just concerned about your ability to maintain some level of control and management over your well inventory.
I understand.
That was the.
Yeah. No, I absolutely understand your concern. It is quite chaotic, but our situation is not unique to the oil and gas market, or at least oil here in Kansas. Again, we have what I consider pretty good records. There's more paper in-house than I ever care to see. Well logs, maps. We can pull maps from the 20s. So we do have access to that, and we have that cataloged. However, some of what you mentioned is the chaos, is that it also, like when operators, sell leases or hand leases over, you're oftentimes subjected to only be able to get what that actual operator has. So there have been leases that have been bought and sold, and the operator has absolutely no records. Certainly not our fault as an operator that is taking it over. But that seems to be something that is not unique. I do find that a problem, but it's certainly not unique to us. Again, that's, in my opinion, it speaks volumes on how important it is to be able to work with the Kansas Corporation Commission to remedy those problems. I think it should be a joint effort. Yes, it's our responsibility, and I get that. But when we take on leases, that especially when we're buying them from other operators that also didn't have their paperwork, that also maybe failed to do paperwork, not to mention, I think even some of the KCC record keeping has been a little bit archaic up until probably the last, 10 years. So this is definitely a problem, but I think it's a problem that can be solved if the operator and the KCC worked jointly in an effort to make that, more accountable and more visible.
Well, certainly, if you're acquiring a lease, you don't have to close on the lease until you can do your due diligence. And you would think at a minimum that would be finding out how many wells are on that lease. If the information isn't available, I mean, it just doesn't seem very businesslike for me not to maybe dot every I and cross every T in the process of trying to actually spend money and acquire the contingent liability that comes with the plugging responsibilities that come with accepting that lease. It doesn't make any sense. Let me ask you a separate question.
I'm sorry, if you don't mind my saying.
You may answer. Yes, you may respond.
You are absolutely correct. I cannot tell you how right you are. I have had that conversation. I don't understand purchasing a lease without the due diligence of understanding what it is that you're buying. Besides the fact that, yes, it's the liability. Once you acquire those, you are liable for it. Again, I don't understand it either. I can tell you that we're not in the business to acquire any new leases. And certainly if we were, that's not how we would move forward with doing it. So I agree with you 100%.
In response to one of the questions I think was asked of you by Commissioner Duffy, you indicated that Mark Haas was removed as president, and I think I tried to write down what you said in further response to that, and that was, I think you said he needed to move from his position. What do you mean by that? What does that mean?
Well, life happens, right? Life happens. I think Mark Haas had a lot of life happening to him. And there comes a point in time that you have to be honest with yourself and realize that, how effective you are in something. It was a tough conversation. I'm very forthright. I usually don't sugarcoat things. But when I have a position on something, I speak my opinion. And in this case, he had a lot of life happen to him. No fault of ours, the commission or myself or any of his workers necessarily, but a lot of life happened to him. And I think, in my opinion, his direction was clouded, and I don't think he was able to clearly look at the business from the standpoint of whether or not he was being effective. And the decisions that were being made and the lack of decisions that were being made were things that were putting the company in jeopardy, putting himself in jeopardy. And it was a tough conversation in some respects, but I'm like, it's time for you to fall back. You're no longer being effective. And I think he realized that too. Maybe someone just had to say it out loud. But I think he realized that too, and was encouraged by the potential of someone else being able to at least bring the company back into a good operating standard so that you could leave the legacy that you deserve to leave after having been in this business for 30 plus years.
Okay. My last line of questioning, we're there. I went online to retrieve publicly accessible information from the Kansas Geological Survey website. You can go on Kohler, you can obtain this information, and it shows production information by operator. And when I pull up this for Haas, what I found is, and it covers the period from 2005 to 2022 through May of this year. Okay.
Okay.
The highest productive year you had was in 2015. During that period, it was over 165,000 barrels. That's a lot of oil. And that was from reported 1,028 oil wells. Okay. I'm sorry I don't have a graphic to show you, but I'm just reading from this information. And I'll be very brief. In 2019, the annual production from your leases was roughly 105,000 barrels. That was from 1,137 oil wells, it shows here. By 2021, that was less than half that production. It was 41,192 barrels from 745 oil wells. And through May of 2022, the production was 18,000 barrels from a reported 652 oil wells. Now, I'm not going to ask you to reconcile we can't do that. Reconcile the well counts and all that with all the other numbers. It would be a fruitless. I'm not asking us to do that. But what I am wondering about is this. How have the increases in the price of oil over the past couple of years impacted the company's cash flow and, more significantly, its viability? Because it appears to me that you have significantly declining production. I guess to what would you attribute that significantly declining production that appears almost arithmetic, if not exponential? It's really a steep decline. To what would you attribute that?
Sure, I would attribute it to a lot of different things. Number one, on the site that you're actually looking at, what I've actually found is that's not always accurate to look at the amount of oil that's actually being produced. I tend to go off of records that we keep from what is actually being sold at the producer level. So these aren't accurate. So I would say that much. However, there's no doubt that there's actually been a decline. We've had numerous wells that are shut off, some due to some of these very things with injection. And then just the natural progression is if you're not doing any new drilling, you're going to have a natural decline anyway. That's just what's going to happen when you're not doing any new drilling. I don't believe, I don't honestly know when the last time that we drilled a new well, but it has been some time, and certainly before I got here. With that said, it is, we should also know, I think in 2015, and I don't have the exact information, and again, I was not necessarily here at that time, but was certainly around the industry a little bit to know. 2015 was a tough year. As far as, some of the prices of oil. 2019 was certainly an issue as far as price. So, that can also affect our ability to, cash flow. But some of the things that we've done since all of this is which is the part where I kind of came in, is looking at ways that we can streamline the business. There were just a lot of things that we didn't need, that we were bankrolling. There were, salaries being paid for that shouldn't have been paid, meaning that there were workers that just clearly were not doing their job. So I'm not sure why we're continuing to pay these kind of salaries. It's really hard to take a look at the overall picture because there were so many things. But being that, when you have declining stock, I mean, you have to then take a look. You can do one or two things. You can either figure out ways that you can produce more, or you can figure out ways that you can operate with less people that fall more in line with the amount of oil that you're actually producing. We did both. So, when you take out some of those costs, one of the things is, give you an example, we're paying it for an office, on a big lease for 4 people, 2 of which maybe came in full-time, the other 2 part-time. So we don't need that space. That's quite a bit of an income. So we looked at things like that, taking that, when your dollars are being decreased, you have to figure out ways that you can maximize what you're currently working with. And those are some of the things that we did. As far as these numbers, however, I would maybe caution you to be exact, because they just never really line up with those numbers on the website of actually what we're actually producing. I hope that answered your question.
It does answer it. My experience in life is that sometimes with statistics, it's hard to figure out which ones are the most reliable and actual and which ones aren't. I can tell you that the reported statistics in terms of the production, the quantity of production for Haas Petroleum that's reported on this website, it isn't derived from conjecture. It isn't derived from speculation. It's derived, the survey obtains that information from the Kansas Department of Revenue. It is exact to the barrel, because every barrel that's produced is taxed. And there's a tax dollar that's associated with, and fees that are deducted from every one of those
Absolutely.
barrels. And I can assure you, if there's a statistical array that's accurate, this is accurate. Anyway, having said that, let me ask you just one other question. I'm done. Of all the leases that you have, and you have a ton of leases here, what are the best 5 leases? What are the names of the best 5 leases that you have?
All right. I don't know that I'd be able to actually give you that information at this point in time. There are, without, I don't know that I could actually answer that. There are, gosh, the number of leases are probably in that 60 to 70 range, somewhere in there. There are some wells that are actually leases that are actually quite good. They're just not showing so good right now, being that some of these leases are shut down. That is part of my work, is to be able to take a look at those leases, be able to figure out where we can, whether it's the leases that we feel like we can grow, or leases that we feel like we need to, give up working on that one, and seeing if we can move that one out of our inventory. We're still kind of in the process of doing that. So I don't know that I could actually give you the 5 best. I can tell you that at one point in time, all of the leases were good. And we're working at trying to determine which leases are worth, really kind of honing in on, based on the amount of people that we intend to keep in order to work them. The rest of them, like I said, we're looking at trying to get some of those leases, out to other operators that have the youth, that have the staff, that have the resources that can properly manage those. But we are doing our due diligence in doing that, and taking the time to correctly identify those operators. We certainly don't want to send these leases on to another operator that's not going to operate and within the guidelines of the KCC.
All right, those are all of my questions. I appreciate your indulgence, Mrs.
You're
Epps.
welcome.
Real quick, Chair Keen, I just wanted to ask, did you apply for the Director of Operations position? Was that an advertised position, Ms. Epps?
No, it was not.
Did you know Mr. Haas before you were hired?
Yes. Yeah.
Okay.
I've known him for a long time, and I was actually
Thank you.
yeah.
All right. Mr. Brock, redirect.
Thank you. I'll try to go as quickly as we can. Ms. Epps, you were asked some questions about the overall production of Haas Petroleum over the last 3 years. Do you recall those?
Yes.
If Haas Petroleum had been offered a compliance agreement in order to be able to allocate certain amounts of capital to repair a designated number of wells each month, do you think you would have had more capital to be able to sustain production available to you?
That's a good question. Absolutely.
Okay.
Absolutely.
I'm sorry, I didn't mean to cut you off.
I was going to say that by not having that opportunity to be able to enter into some type of a compliance agreement, certainly by the ones that you referenced, 2 to 3 wells every 3 months, that being afforded an opportunity like that can certainly be beneficial to the funds that you have available to do this type of work. So yes, I think it would have.
Okay, I'm gonna lead you through something real quick. We're gonna see if I can get it done. If not, I'll do it in my closing. So I'm gonna share my screen with you. Are you able to see this well inventory?
Yes.
Screen that's showing?
Mm-hmm. I do see it.
Okay, and the date at the top is July 26, 2022, correct?
That is correct.
And can you identify what this appears to be to you?
That looks like our, gotta love these glasses. Yeah, that looks like the well inventory that we certified on July 22nd. Can't really scroll away from that for a moment, but it does look like the list that we sent in.
Okay. And there are some comments along the side.
Yes, the green, it looks like it is saying that there was a P1 submitted. Those are actual, the one I'm looking at right now looks like the Ashley lease. And those leases that we actually transferred over to another operator.
And if I could just maybe shortcut some of this, would you agree that this well list contains 1,168 wells that are not noted as being transferred to someone else?
Yes, that's correct.
Okay.
It was off by 20, I guess. So I think it was 1148, so 1168.
I'd move for the admission of this. I have it marked as RE redirect 1. I've emailed it to John and to Kelsey.
Any objection?
I have not seen that email come in yet, but I don't have any objection.
Without objection, it's submitted.
Okay, I'll check as soon as we get off. I apologize for that. I thought I sent it while she was talking. So then I've switched my screen to, this is your pre-filed testimony dated July 29th, 2022.
Yep.
and this question talks about the 44 violations. In essence, staff located 44 wells that they claim that Haas was actually operating that are not on your license. Would you agree with that?
That's correct.
So when we talk about the accurate well count, the list, there's really only 44 wells that are that are alleged to be operated by you, that are not on your well inventory. Is that correct?
That is correct.
And so that the rest of them, the other 1,000, are added through other means. Would you agree with that?
That would appear so, yes.
Thank you. When it comes to the T1s, I'm going to stop my screen share. I'm not using it. I'm not going to use it anymore. When it comes to the T1 transfers, is it your belief that by transferring a well, you automatically place it into compliance with KCC regs?
That it goes into compliance upon transfer?
Yeah, I mean, I almost put words into your mouth. I'll not do that. I mean, are you claiming that just because you transfer a well, it becomes compliant with KCC regulations?
No, absolutely not. Our transferring has nothing to do with the condition that the well is in.
And when you did transfers of some of these wells, specifically the UIC wells in this docket, what was discussed? What was agreed on? Why did you do that? Why did Haas Petroleum do that?
Well, two reasons. One, there are several operators that we, again, I think I said at the beginning of the testimony that the operators themselves, it's a tight knit community, close knit community. They all know about each other's leases. They're oftentimes buying things that are next door to the lease that they eventually want to own, and so. Again, this is part of the process for us. Is like, the writing was on the wall. It should have been on the wall some time ago. This is a lot of leases to be able to manage when you're looking at the number of, not just the number of employees, the aging employees, the desire to continue operating at the level, Mark himself has been doing this for 30 something years. I don't have 30 years to continue to do this. So I really had to I'm on board with making decisions of scaling this down. So I have operators call me all the time asking for certain leases. And some of these operators, in particular, the two, the ones that you're mentioning that you kind of brought up on the screen, it's a young guy. It's a young guy. He's got a lot of, he's got a lot of energy, and he wants to build, upon his assets. So yes, we said, hey, here you go. Would you be interested in these? And oftentimes, in this particular case, this particular operator also had access to equipment and supplies that we could use to do some other things. So it was a win-win situation for us. We were able to put him on board and, have him do some things. And in return, you've got these wells. We are very clear on what needs to be done with those. And it was an asset they're worth, for them, it's worth them taking. They're like, yeah, absolutely. We'll get it. We'll bring it into compliance. Because it's an opportunity for them to increase their assets. So
I think you alluded to it right at the end, but I just want to ask that very directly. Did you tell these operators who were taking these wells that these violations existed and that they needed to be corrected?
Absolutely.
And
absolutely.
Did they know that these needed to be corrected in a timely manner?
Yes. They knew that they were that there was deadlines that needed to be needed to be met. So they were very aware of what the violation was, They were aware that there were deadlines involved, and many of them have tried to meet those deadlines, but have been met with a little bit of difficulty doing, being that it's hasn't transferred out of our name, so they're not able to do what they need to do with the well.
And have they specifically told you they could not get permits to plug or repair these wells?
Yes, that is correct.
So let's talk about, we have two categories of things here. One are the UIC violations, and the other are the TA violations and the other generic violations. And if I just want to make sure that I'm clarifying what your point is. When it comes to the UIC violations, if I'm just going to state what I believe you're saying, I don't believe you're asking that those wells be placed on a compliance agreement. Is that correct? Or are you asking that the UIC wells, the injection wells, be placed on a compliance agreement?
No, not at all. No, those should not be placed on a compliance agreement, and we're actively working through those wells. So no, we're not asking for a compliance agreement on those. We're mainly asking for a compliance agreement on the TA wells. That is a common, violation with many operators, where it's not exclusive to just Haas Petroleum.
And as it relates to the UIC wells that have not been transferred to other operators, the typical procedure is that the commission would order that a violation exists, issue a penalty, and require compliance within 30 days of the order. And if compliance is not reached, the operator's license is suspended. Are you okay with that happening to Haas?
I think that's fair. I think that's fair.
And so just to clarify that, you are asking, though, on these TA violations and these other more generic violations, that there should be negotiation, there should be a compliance agreement as it relates to those. Is that clear? Is that correct?
I would be very, very happy to see a compliance agreement, because again, that would be it'd be an opportunity to be able to have that same benefit that many other operators actually receive with regard to these type of violations. We're working through a lot of these TAs, so that number is dwindling as we speak. But with the remaining ones, yes, I'd be ecstatic if we could enter into some agreement and keep us accountable for what we need to do, but give us the time in which to do it, like seems to be done for a lot of other operators.
Did you specifically request to open discussions regarding settlement concerning these TA and other violations?
I expressed that to you, that could we actually sit down and have a face-to-face and discuss the way to work through these. Yes.
I apologize. And what was the response?
Well, I wasn't there for that response. So I have to rely on what was shared with me by you. But you indicated that the staff was not interested in sitting down with us to work out some type of resolve.
And did that happen more than one time?
It did. Unfortunately, it did.
Okay. And just so we're clear, when it comes to field employees, have you had interaction with KCC field employees?
I have.
Have they been good? How have those been?
Very good, very positive. I think they're always a little surprised to see me come out, being that you don't see a lot of women out in the field, but very professional. I asked a lot of questions, and they were patient with those questions. I felt like besides the fact that, we seem to be working positively with one another. I felt like they felt like that too. I mean, it was just a good working relationship. Lots of questions got answered, lots of things were explained. And I think it helped just to be able to see a face out there. I think that was important for them to be able to see the decision makers out there in the field. So it was a positive experience for me. Hopefully it was for them as well.
Have they given you any feedback about whether they've noticed changes since you've taken over control of Haas Petroleum?
Objection, calls for speculation.
I think she can answer whether she's received feedback.
I think you could ask staff if they gave feedback whenever they're testifying. I think to ask her the question also calls for hearsay.
For my
Also
speculation.
seeing the objection, could you re-ask the question?
Have you had any conversations with field staff about whether things have improved since you've taken over operations at Haas Petroleum?
I have.
Yeah. And what were they?
The only conversation that I can recall and having with any of the field staff would probably be Dwayne Sims. I've probably spent the most time with Dwayne. He, we visited a little bit on, what our status is and some of the things that, need to be done on the particular site that we were actually at. And he did comment, he's like, this is moving in a better direction since you've taken over. Too bad it didn't happen earlier, but it is moving in a better direction. And I have not had an opportunity to meet all the staff. I've met, like I said, I've been with Dwayne on a couple of occasions. I think there's 3 Ryans now, so I can't keep them all straight. I think I've probably met each one of them. I've seen Rodney Breeze out on several occasions. I'm a little disappointed that I have not had the opportunity to have a face-to-face with Troy Russell. That was something that I had intended on doing, but when you came back that they weren't really interested, I really didn't really push that. But I can tell you, just by being able to look at the screen of everyone and actually put faces with these people that I'm either talking with or see on a piece of paper. I have no doubt that every one of these people that I'm looking at today and that are here, I have no doubt that we could work together. Like I said, I'm a little disappointed that I haven't had the opportunity to, be face-to-face more with Troy Russell. But I think the panel that I'm, here with today, I think their heart's in the right place. I think they're doing what they need to do. I'm hoping that I'm coming across that we are also committed to doing what we need to do. Our hearts are in the right place, and we want to get back in the good graces and do what we need to do as a responsible operator.
I don't have any further redirect.
All right, thank you. Recross?
No recross.
No recross. Very well. Mrs. Epps, I believe your time to testify has come to an end.
Thank you.
We want to thank you. The commission thanks you for your appearance here this afternoon. You are excused and you may virtually step down.
Thank you. I appreciate that.
Commissioner Duffy?
Okay, so we have one witness left.
Yes,
I'm just wondering, do we anticipate doing that tonight or tomorrow?
well, my preference would be to finish
I
tonight.
would imagine there's quite a bit of questions to ask this particular witness. Maybe
We have
not.
quite a crew assembled here, so I would think we would proceed this evening. Do you have any idea, Kelsey, I think you're looking at some cross-examination. Do you have any idea how much time that might take?
Oh, probably Well, it depends on the answer I get, right? But 20 to 30 minutes, I'm guessing. Maybe a little bit longer.
Mr. Brock, any thoughts?
Would it be possible for me to have 5 minutes to talk with my client and see if we could, I mean, maybe shorten this?
Absolutely. In fact, I think since we're doing this hearing in 2-hour increments, we've reached our 2-hour increment.
Okay.
So I think probably let's take a 5-minute break here. I have 5:15. Let's make it 10 minutes. Let's resume at 5:25. We're in recess until 5:25. John, could we go back out to full screen? Thank you. Or Sean's with us too. All right, we're so 5:25, and we're going to go back on the record. I'll turn to you, Mr. Brock, and ask that you call your next witness.
With full understanding that her testimony will not be incorporated into the record, if she's not called, we're going to rest at this time and not call our second witness. My closing is a little longer than I had promised John, and I'd rather do that for a little bit, I guess.
All right. Well, that was a different turn than I was expecting. I guess we're ready for closing statements. So we'll move to closing statements, and I'm going to begin with statements on behalf of the operator, Mr. Brock.
Thank you, Mr. Chairman. It's okay. I have a really short PowerPoint I'd like to use for a closing statement. Is that appropriate to share my screen to do that?
Please do. Did you hear me? Yeah.
Yes,
okay.
yes, I got it. Okay. So we started this out talking about the UIC violations. I'm just generically referring to the different violations. The UIC violations, meaning the mechanical integrity test issues. There is no dispute that happened. There is no dispute that is egregious, that is serious. We're not asking you to find that. Penalties are absolutely appropriate for what happened in that. What we're asking is for, we're in essence arguing against the death penalty. We're asking for an opportunity at redemption. We're asking for an opportunity to earn our way back into, being seen as a good operator. We've tried to lay out the steps that Haas Petroleum has taken to change the methods of its operation, to change what it's doing, to reduce the number of wells that it's responsible for to something more manageable. We've done that not to provide excuses, not to try to minimize what did happen, but to try to show the commission that these have been taken seriously. And Haas Petroleum has taken steps. They have spent enormous amounts of capital to comply with these. The pre-filed testimony indicates that there are nearly 200 NOVs that have been issued since this started. The resources to do that, the resources to investigate these other 2,000 wells that were conducted in a generic investigation are staggering. And so ideally, neither party would be in that position. But I'm just trying to stress that they're trying to make those steps. They're trying to show through their actions. The 35-year record of compliance, it doesn't excuse what happened. It absolutely doesn't. But it is part of the picture, and so we do think it's there to be considered. But we're not trying to say that it excuses what happened. I apologize with the screen share. It's not allowing me to change. Oh, there it went. It wasn't letting me change my slide. The dispute that does exist, there are a few of them. One of them, in one of these dockets, they're the 77 temporary abandonment violations. When the commission issued those, they expressly indicated that they were puzzled by how these could be issued because all that's required is at a minimum to contact staff and try to work something out. And that these were part of an effort that affected nearly 2,000 wells. And that these operators needed to contact staff. We want the commission to know that we did that. On July 16th, we were expressly told, we're not interested in meeting with you. On July 1st, again, we're expressly told, remain uninterested in meeting with you. I've never had that happen working with the commission before. I've never been told we don't want to work something out with you. In my mind, almost every issue should be able to be settled. You can always think outside the box. You can always find something that works for both parties. But you can't do that if you can't even start these discussions. And that's why we're here. We couldn't work anything out because we couldn't even start any discussions to do that. We've given several examples of how other operators are treated with these TA violations, how they're being handled. The issue here is that staff has decided that Haas Petroleum should not have an operator's license. And so these violations are being added to try to solidify that outcome. But that's the commission's decision to make. We're putting that at your feet. You have the responsibility to make the decision whether the UIC violations justify the death penalty, justify losing the license alone. But all of the stuff that's piled on, that is not appropriate, because a lot of those violations are created by not entertaining compliance agreements, by adding wells to the well inventory, by issuing enormous amounts of NOVs, short deadlines to comply. I mean, 200 NOVs in that period, that's crazy. I mean, that's not reasonable for an operator to comply with. I mentioned at the beginning that they weren't being treated the same, and that's how they're not being afforded those opportunities. When it comes to Haas Petroleum, settlement discussions in that way, they're just refused. It's not that we can't agree on terms, it's that we can't even discuss it. Other operators are allowed a compliance agreement. Haas isn't even able to discuss the possibility of one. We didn't even get to propose a number of wells to bring back into compliance. It never even got to that point. If Haas Petroleum was allowed to bring in so many wells every 3 months like other operators, you can see in the pre-filed testimony the number of wells they did bring back into compliance, and it's substantially more than that. It isn't a huge number compared to the overall wells, but it's substantial when compared to what other operators are asked for. The whole purpose of the compliance agreement is to allow the operator to remain viable so that they can actually achieve compliance. And the production records show that Haas Petroleum is not being able to do these, to bring its wells into compliance in a reasonable fashion. Just as a compliance agreement is offered to let an operator remain viable, it's denied in order to try to prevent an operator from remaining viable. There's been 1,064 wells that have been imputed to Haas. We've talked about the different ways that that has been being done. It's 4 ways primarily. Wells within a quarter mile of an injection wells within a quarter mile of an abandoned well, wells located on lease boundaries that are not operated or claimed by Haas, wells that are operated by other or formerly associated with other entities, other legal entities, and then wells that have been transferred but not approved. And I know the staff's witness they kept referring back to, well, there are wells that Haas Petroleum actually operates. But when you look at the testimony, there are only 44 of those. We're talking about adding 1,064 wells, but there's only 44 that were identified specifically that staff is alleging were being operated by Haas, but not claimed on their inventory. So that's easy to say that generically, but when you look at the numbers, that's only a drop in the bucket for these 1,000 wells. No operator could have 1,000 wells added to their inventory. And when you add a bunch of abandoned wells to an operator's inventory, of course you will create a whole bunch of violations, because every abandoned well is in violation of commission regulations, every well. Haas Petroleum is being told that they have to shut down every injection well located within a quarter mile of an abandoned well. This is not being done to any other operator. I don't believe there's any legal authority to do that, but Haas Petroleum is being targeted with this specifically. That notice didn't go to other operators. only to Haas Petroleum. There's been transfers of operatorship. Those have not been, they've either been ignored or haven't been approved. There was some questions about the T1. I'm going to try just to touch on it a little bit. When a transfer occurs, there's in essence two parts to every violation. Certain violations incur a monetary penalty when an operator conducts an act, and certain violations incur a monetary penalty by virtue of having a well or having a condition exist. If a monetary penalty is due by virtue of conducting an act, then a prior operator can still be penalized for something that happened on their watch. But if they don't own the well anymore, you cannot hold them hostage to say, you have to trespass onto this lease to fix this problem. The new operator assumes responsibility for bringing the well into compliance. It doesn't allow the prior operator to skate free because they still potentially have a penalty. But that, in my opinion, from a legal perspective, that's how the T1, that's how the transfer and the penalties relate to one another. When these wells are not transferred, you've heard testimony saying that the new operator can't plug them. Specifically, the new operators have tried to pull permits, have been told they couldn't, and can't bring the wells back into compliance. The commission's job is to ensure compliance, to make sure there's enforcement and compliance with its regulations. But by not approving transfers, it's preventing someone from bringing the well into compliance. That is not, it's not only detrimental to Haas, but it's detrimental to the commission itself. Being locked out of COLAR, we list it, but they still file paper forms. It's more of an inconvenience. The notice of violations, we've said how many there are. There are other dockets before the commission, but when we come before those dockets, if we're allowed to keep the license, I won't be arguing that these occurred and we need mercy. I'll be arguing that these occurred on abandoned wells that are not Haas's legal responsibility. Those dockets are completely different than these. And if those are to be taken into consideration at all, I just ask the commission to give us that chance to show the issues that exist with those. Don't just take them at face value. So what did Haas Petroleum do? It promptly admitted to what it did wrong. Not one employee, but that employee has been taken of all authority to do anything, and it sounds like other actions may be on the horizon. But they've made enormous changes in the company structure, and they continue to do that. Most importantly, in my opinion, is that they are actively reducing the number of wells they're responsible for. The commission recognizes that needs to happen. Haas Petroleum recognizes that needs to happen. They're trying to do that, but when transfers aren't approved, it makes it difficult for them to do that. And so they will continue those strides. They did promptly reach out to commission staff to try to work out these other issues aside from the UIC dockets. When those issues arose, the conversation was always that, hey, with respect to these UIC dockets, the commission needs to set a penalty. We're not asking for any change in that. The commission will do that, but we need to discuss these other issues. That was the request. That's what was denied. Haas Petroleum did that 2 days after its NOV was issued. They didn't just sit on their hands. They tried. During those discussions, they disclosed that they had approximately 321 wells, primarily TA violations, that they wanted placed on a compliance agreement that they were interested in discussing. Trying to find, I have the number. Oh, here it is. I apologize. I had it in my notes, but couldn't find it. When the commission staff conducted their general investigation, they located 368 violations. that were on wells that Haas Petroleum is legally responsible for. Of those, 18 of them were already the subject of this violation. So you have 350 quote unquote new violations. I think it's very notable that Haas Petroleum asked for a compliance agreement for 321 wells. They weren't hiding anything. They didn't pull punches. They tried to lay the cards on the table. But discussions ended right there. We couldn't even identify specifically which wells. Since the dockets began, Haas Petroleum has plugged 79 wells. They've returned to service or transferred 487 wells. They filed 83 TA applications, conducted over 200 MITs, and investigated and responded to nearly 200 NOVs by commission staff. This docket shows the things that Haas Petroleum could not do, but I think it's important to also emphasize the things they did do. They didn't just sit by. They didn't just do nothing. They're trying to prove themselves with their actions, but they need to be afforded the same opportunities as other operators to be able to do it. They need to be allowed to set quarterly targets and to be proactive with budgeting. You know, it's a snowball effect. When you force an operator to have all of its money spent on responding to these things, you cause their production to decline. The more the production declines, the less money is available to bring wells into compliance. And it just snowballs in that way. That's why the compliance agreement is a tool that the commission staff promotes. That's what needs to happen here. The general investigation inspected 2,232 wells. We've indicated earlier that Haas Petroleum's operator's license contains 1,168 wells. Commission staff identified another 44 that they say are actually operated by Haas. So that number that's in dispute is 44. So staff inspected 1,068 wells. Even if you remove the 44, staff inspected 1,020 wells that Haas Petroleum neither operates nor are their well inventory. Those are not their wells. And even though they want to try to agree to things because they understand how egregious the UIC violations are, that is not reasonable. That's not doable. That's not being asked of anyone else. We've already talked about the 350 versus the 322. So how did the staff add wells to the well inventory? We tried to answer questions earlier about about the true numbers. And so that's why I introduced the well inventory. And then that's why we referred to what staff found as the actual number of wells that they found Haas producing. So what they do, they added abandoned wells located within a quarter mile of an injection well. The argument that the regulation conflicts with the plugging statute, that is not accurate. First of all, you have a statute enacted by the legislature that expressly deals with abandoned well responsibility. An administrative regulation could not override it, even if it did speak to the same subject, but it doesn't. The administrative regulation being referred to is permitting criteria for new applications, not abandoned well responsibility. And in the pre-filed testimony, you saw that they can bring these into compliance if they add them to Haas's well inventory. Well, that's not, that is, I don't know, I almost used a poor choice of word. I won't elaborate on that. But here's the language. I mean, these are clearly abandoned wells. We went through it during the testimony, so I'm not going to do it now, but I have the statutes here. These wells are not causing pollution. Nobody designated rising fluid levels. Nobody took water samples. Nobody took chloride samples. Nobody put markers in a well to trace them. Nobody did any of that. That has always been standard practice at the commission. But now it's within a quarter mile, it's your well. That is not a legal position, and that is a complete departure from the way that it has always been handled. There's no scientific basis for just generically treating it that way. The other thing that they did is they included all wells that are within Haas's lease boundaries, even if they're not operated by Haas or included in their well inventory. To me, that question is easy because the statute specifically says you cannot do that. The new 55-179 specifically says that is not the law, but yet that's what staff has done. The other thing they did is they added wells that were associated with other legal entities to Haas Petroleum. Clearly, they're separate and distinct entities. Haas Petroleum is a LLC. I don't know what these other companies were, but they're not. You can't just add wells from one company to the next simply because the name is similar. The fourth thing that they did is they're refusing to transfer any of the wells. A T1 is due 30 days after the transfer occurs by virtue of an assignment, a new lease, or some other means. There was questions about how these are normally handled. From a property law standpoint, that assignment, that lease legally transfers ownership of the well. The operator responsibility for the well is transferred there. I can't cite to the regulation off the top of my head, but you are not allowed to assign a well except to another licensed operator. It might be 120, your regulation 120, but you have to only assign the well to another licensed operator. And then you have to give notice of that transfer within 30 days after it happens. And so you can't arbitrarily prevent someone from assigning a lease or assigning a well. The commission can issue penalties for things that happen on their watch. If they don't file a T1, they can issue penalties for doing that. But they can't just decide this person gets to own this and operate it. This person doesn't. There has to be an objective standard, and there is. The commission has rules about requirements for operators. It's not up to staff's discretion as to who gets them and who doesn't. It's up to the objective rules that define what an operator must do to be a licensed operator. So what is Haas Petroleum asking for here? Above all things, they want their operator's license renewed. They want a chance to earn their way back. That's number one for them. They've drastically reduced the number of wells they have. They're going to continue to do that, but they want to put their money where their mouth is, so to speak, and show themselves to do what they say they're going to do. If they don't, put a repercussion in there. You know, I've not heard of an operator's license being granted on a probationary basis, but I think we all know that the commission's eye is on Haas, whether they're given a license or not. So give them a chance. If it's believed that they won't follow through, give them the chance to prove that they will or they won't. The second thing is monetary penalties. Monetary penalties as it relates to the UIC violations only. There was questions about all these other violations. These other violations, the vast majority of them are on wells that Haas Petroleum is not legally responsible for. And on the wells that they are legally responsible for, Haas Petroleum should be afforded the same opportunity as every other operator in the industry to try to work something out with commission staff to address these in a reasonable, timely manner. That's all they're asking to do. There was discussion about, well, environmentally sensitive things need to be done first. Great, set the terms for that. Pick which wells, pick what goes first. That's fine. We're not trying to force unreasonable terms. We just want to discuss terms at all. That's what's being asked there. And then the third one is when the commission rules, they have to make it clear that whatever penalty the commission chooses, that's it. We're not going to continue to try to exact a pound of flesh. We're not going to continue to try to add wells. We're going to treat them like everybody else, and we're going to give them a chance to succeed or fail on their own merits. And the penalty, the outcome that the commission decides, we need to respect that. And I think that's just as important as a license renewal, because without that, I mean, that's what's caused all of these these extra 1,000 wells. That's what's caused these notices to shut down 117 injection wells. Without that, we'll be in the same place we are now a year from now. We have to set that aside, put them on the same footing as everybody else, and give them a chance to prove themselves. So that's what we're asking for from the commission. I know it's been a long day. I very much appreciate your time. I thank you all for staying late, and just sincerely thank you.
Thank you, Mr. Brock. If you could take down the screen sharing.
I'm trying to, there it goes. I couldn't find the button. I apologize.
Things working differently as we approach 6 o'clock, it appears.
That's right.
All right. A closing argument for the staff, Mr. Marsh.
Thank you, Chair Keen. May it please the commission. I think there's a few things that Keith brought up that I'd like to try to address real quick, and then maybe just wrap things up in a bow. Keith started off his first slide talking about the 35 years record of compliance. I think Ms. Epps, said it best whenever she said that Haas should be judged from November 2020 moving forward. And I think that's really important to consider here. These violations didn't just happen overnight. I think it goes to years of non-compliance at Haas's leases. And while maybe they didn't get caught at those times or sooner, they did get caught in November 2020, and they need to be penalized for their actions. Keith talked about the 77 TA violations and really the other violations that are out of compliance with 82.3.111, and ask the operator to be treated as other operators have been. However, I think we can all agree that Haas isn't necessarily in the same situation that other operators are in. Other operators come to staff before staff has to get on to them about violations. Haas didn't come to the table until after UIC penalties had been discovered, and staff began looking into the other violations found by her that fell under or onto the wells under Haas's license. Keith talked about the number of wells that Haas has plugged since November 2020. I think it's 79 wells and filed 83 TA applications. However, the fact still stands that why aren't the wells that are subject to these penalty dockets brought into compliance by this point? Here we are 2 years later, and there's still UIC wells that are out of compliance. There's still, and I think there's still 17 UIC wells is what we determined that are out of compliance out of the 30 that have been penalized. There's still 61 of the TA application or TA violation wells that are out of compliance. You add those numbers up of the penalty dockets, that means that 78 of the 109 wells subject to these penalty dockets are still out of compliance. That ends up being about 72%, which is a large majority of non-progress over the course of 2 years. Throughout staff's inspections, they found 2,232 wells. And obviously there's some disagreement there on Haas's responsibility regarding those wells. However, Haas does claim responsibility for at least 1,168 of those wells. And one thing that Keith didn't mention in his PowerPoint is the number of those wells that are out of compliance, or the number of violations that staff found regarding those wells. And I think it's those number of violations are contained in Ms. Epps' testimony, or the exhibit attached to that testimony, exhibit RE-1, which totals a number of 490 violations that were documented at wells that Haas claimed responsibility for. One of the things that, circling back to the compliance agreement, Haas talks a lot about good faith, and that staff should be directed to enter into a good faith compliance agreement. I had to look up the definition of good faith, but it means honesty or sincerity of intention. And, I don't think that Haas can characterize their actions up to this point as being made in good faith. Whenever you're concealing environmental violations, you're not disclosing well records that are inaccurate. You have unauthorized injection wells. You're producing wells that aren't on your license. You're injecting into wells that aren't on your license. There's a lot of dishonesty there, and I don't know that you can really trust an operator or act in good faith with an operator who won't act in good faith with you. Staff relies on operators' integrity. We talked about that in my opening, and I think one of Commissioner Keene's questions to Ms. Epps talked about the number of pumpers that Haas has and across a number of counties. I believe it was 8 pumpers across 6 counties, and they talked about how that was an extreme burden for Haas Petroleum. I mean, whenever you compare that to District 3 staff, I mean, you have 9 compliance and regulatory personnel that cover 31 counties roughly. Whenever you have that similar number, but doing an immense more times the work, I think you have to rely on an operator to have integrity. And I don't think that's the case here. Whenever I say at the very beginning, there are really 2 issues that need to be decided, despite the mountain of violations that have been documented by staff on Haas's leases. First was whether the penalty orders in these consolidated dockets should be affirmed. And second is whether Haas Petroleum should have a privilege to continue to be licensed as an operator in the state of Kansas. Haas does not deny that the violations in these penalty dockets have occurred. And staff's position is that the lack of contesting these violations and the lack of concealment that went into covering up the UIC violations especially necessitates the affirmation of the penalties and justifies the heightened penalties that have been assessed by the commission. In regards to the license, I really believe that the commission has the opportunity to show how serious it takes environmental violations and operators who conceal environmental violations. Haas would lead you to believe that the mountain of violations documented by staff is nothing more than a molehill. However, that does appear to be inaccurate. And, taking out the wells that are contested, as I stated earlier, there's still 490 violations that were documented at staff during their lease inspections at wells that Haas claims responsibility for. Additionally, you look at it from an outsider's perspective, this is still very much Mark's company. We know he has a vested interest in this company, and really outside of Rhonda's testimony, there is no indication that she is even associated with Haas Petroleum, much less CEO and president of the company. We saw that by looking at the licensing information in the commission's RBDMS database, the lack of or the authorized users for the Kohler database, the lack of updating information with the Secretary of State's office, and even looking at Haas's own website, where she was not included in that website at all. Either way you look at it, there's no way that Haas can meet its burden of proof that more likely than not, it is in compliance with the Kansas statutes, commission rules and regulations, and the commission's own penalty orders that have been issued in these dockets. Therefore, it's staff's position that under KSA 55-155 and KAR 823-120, Haas's application for license renewal cannot be granted. Thank you.
All right. Thank you, Mr. Marsh. Before we conclude, I must ask if there are any post-hearing issues the parties wish to discuss, probably most prominently including whether the parties wish to file post-hearing briefs. Counsel? What's your pleasure? Mr. Brock?
There are several legal issues involved, but we asked a lot of legal-based testimony to the witnesses and I feel like we've really covered it. If the commission would like briefing on any issue, we're happy to do that. But the authority that we had in those legal arguments, even though it may have been, we did that with the witnesses and in closing. So, but I'm happy to brief anything that the commission would like more information on.
All right, thank you, Mr. Marsh.
Oh, I would echo Keith's comments. I mean, if the commission wishes to have post-hearing briefs, then we're more than happy to work on that.
Well, I don't see either party having a compelling reason here provided for why we should have post-hearing briefs. So I think we'll dispense with it in the absence of your wishing to do it.
Thank you.
All right. So given that, I guess before we conclude, I would ask my fellow commissioners if there's any other matters that they wish to have considered in conjunction with this docket. I have a pretty good idea. The answer is universally no. That being the case, this does conclude our hearing in these consolidated dockets. The commission decision will be forthcoming in due course. And we will at this time close the record and adjourn. We thank you all for your participation in this hearing. Have a good evening.
Thank you very much.
Thank you all for your time.
Yeah, thank you.
Take care.